Hold. Hold to matter. Attack on another. Great. Proper beginning sign up. Allowance. And leave. Bushman. Bushman.
That one matter. Blood. One fresh matter at 2:30 blood. Repatriation matter blood. There is an order of stay. Blood. Two matters I am giving for tomorrow. Fresh matter.
My lord, day before yesterday, entry matter, expert entry matter was partially the punishment day. But punishment was imposed in the month of November, and it has already been given effect in the month of November. And the salary was paid as per the punishment order in the month of November. Now it has been stayed, my lord. And they should not file that contempt petition and all, because this matter is very serious. Where objection also filed, my man. Today when I filed the objection, this may be posted tomorrow orders, my lord. ಅದು ನಾಳೆ ಆರ್ಡರ್ಸಿಗೆ ಹಾಕ್ಬೇಕು. ಯಾಕೆಂತ ಅಲ್ಲ ಮೈ ಲಾರ್ಡ್ ದಟ್ ಅಲ್ಲ ಕಂಟೆಸ್ಟ್ ಹಾಕ್ಬಾರ್ದಾರ ಈಗ ಫಾರ್ ಎಕ್ಸಾಂಪಲ್
ಮಾಡೋದು ಮತ್ತೆ
ಅಲ್ಲ ಅದಕ್ಕೊಂದು ಕ್ಲಾರಿಫಿಕೇಶನ್ ಮಾಡಿ ಕ್ಲಾರಿಫಿಕೇಶನ್ ಅಲ್ಲ ಮೈ ಅಲ್ಲ ಪನಿಷ್ಮೆಂಟ್ ಆಲ್ರೆಡಿ ಇಂಪೋಸ್ ನಾವು ಫಾರ್ ದಿ ಇಫ್ ದಿ ಸೇ and 7th to date 7th January on the date for on 7th
the release source offer in the petition is now allowed by the government of Karnataka, wherein they have applied the old pension scheme to the petitioners who are before this court, my lords. Now they are saying that since the matter is pending, so we will not forward the orders. No, it's pending matter. The matter had come up before this court. Thereafter, my lords, the government passed an order applying the old pension scheme. So therefore, my prayer becomes now fulfilled. Therefore, they want us to close the matter before this court. Therefore, tomorrow, my lords.
Two matters listed on 10th, last 10th. One is granted interim matter, and another is one matter is granted
interim matter. In another matter is listed yesterday fresh matter. The near reach agla 39 is the serial. Same. Second tomorrow.
Worship, in this matter, seeking for end of the list, the petitioner has been selected for the post of graduate primary teacher, but they have not selected him, saying that case is pending against him, but the High Court has granted an interim order of stay of conviction, in spite of which he has not been selected. And multiple judgments are there saying if stay of conviction is there, he should be eligible for employment. Therefore,
May I make a request?
With permission, my lords.
My lord.
My lords, on 16/12/2024, your lordship was pleased to dispose of a matter, my lords, by allowing the writ petition. It's regarding that commissioners to municipal my lords, I'm moving a memo for being spoken to in that matter. My
Tomorrow. My lord, may I make?
Upload
My lord, may I make request? My lord?
You must inform the other side. What ground now?
It's been recorded that we've given an undertaking. That undertaking may be read to mean for the entire state where it was only meant for that particular district. So the undertaking reads would mean to show that we would have, we've undertaken to replace all of them. That may be a bit of a problem.
Okay, that we can clarify.
Yes, ma'am.
But even without undertaking, you have to,
That, yes, my lords, the undertaking.
that I'll
That
clarify.
would be, yes.
My lord, the serial number 48, my lord, the order of
Gentlemen,
suspension has been quashed.
List one,
Just
page number 1 to 6, page number 2, serial number 7 to 14, page number 3, 15 to 17, page number 4, 18 to 21, page number 5, 22 to 24, page number 6, 25 to 29.
Lords, I appear for serial number 29, my lords. I appear for R2 in that, my lords. University, my lords. I pray for time, my lords. I have to file a statement of objection, my lords.
have you informed the other
Yes, my
side?
lords. I have informed the petition.
At request of the respondent, list the matter in the week commencing from.
27th of January.
Grateful, my lords.
Page number 7, serial number 30 to 35, page number 8, 36 to 42, page number 9, 43 to 49.
My lord, serial number 48, my lord, it is order of suspension was questioned, my lord. The order of suspension was passed on 6/11, my lord. Four adjournments work, so it may be taken up a preliminary hearing list, my lord.
But
40?
it's,
48, my lord.
my lord, it's that matter pertaining to a temple employee who had assaulted a devotee, my lords.
Yeah.
The proposal is pending before the
But
endowment.
since last 3 occasions, they make it very submission.
The commissioners are in Belgaum, my lords. No orders have been passed.
No, what
May
was
be
the-
taken up immediately after vacation, my
no,
lords.
what was the last proceeding? What was the, why was it adjourned last?
It was adjourned for the order of the commissioner, my lords, because we had said that there was a proposal forwarded for reinstating him. That, but not in the same temple, in another temple. That has to be approved, my lords. That has been pending.
But that is the stand that I've
Yes,
recorded
ma'am.
in
We
the-
will place him in another temple, my lords, but that has to be approved by the commissioner.
My lord, the case of the petitioner is
So
that,
then you have to wait.
Lord, Lord, the case of the petitioner, only
That way, that
the
way.
rule itself is not retracted, my lord.
No, that's on merits, sir.
Yes, madam.
As a,
Since from, my lord, last 1.5 month, my lord,
you have to wait for what you have done. You have to wait, that's all. That we can't do anything, nor. we
let,
can-
my lord, my interim prayer may be considered.
No, that I've already said, it cannot be considered. Only as a via media, I've given you some relief. You'll have to wait however long it takes. It's for the.
Otherwise, my
government to
lord,
make it-
subsistence allowance, so they are not paying, well, since from last 1.5 month.
That they will see.
I'll.
That
commit-
no, now, during the period of suspension,
Yes,
till some alternative arrangement is made, subsistence allowance you have to.
pursuant to that 1 month period.
No, whatever, till order is,
I'll
till
ascertain that.
till the order of suspension subsists.
Yes,
Without any direction, you give an instruction immediately
I'll do that.
that subsistence allowance is paid. Yes, this is the matter.
Lord,
The week
one more
commencing
request,
from-
my lord, can I permitted to move in vacation bench.
No, definitely not. Request to move the vacation bench is rejected. This is the matter in week commencing from.
20th of January.
Lord,
Okay.
last 4 times, my lord, they are making
Yeah,
very
again,
same
I'm-
submission.
Correct.
Yes, my lord, my case is,
You
my
have
lord,
been given relief of via media of providing you posting somewhere with revocation of your suspension. You are not entitled for any more relief. That you have to wait till the
on
next
merits,
day.
my lord, I have a case, my lord, on
That
merits,
you
I have a
argue.
case.
You argue it out.
That is the reason, my lord,
Argue
I'm
it
sought
out
for
after.
pressing for interim prayer.
That you argue it out after vacation. I've considered your plea and then only passed an order. Yes, Nick.
Page number 10, 50 to 54.
Serial number 52, my lord. The case of dismissal of the petitioner from service without holding inquiry. Now I have filed a memo to pass the impugned order, reserving liberty for me to hold inquiry and pass fresh order.
I'll take it up immediately in the preliminary hearing list.
Yes.
Huh? After 13, I'll take it up.
Please.
13 Admiral Kari.
Page number 11, 55 to 61. Page number 12, 62 to 64.
My lordships kindly, my lord, serial number 62, my lord. I appear for respondent in all the three matters. My lord, there is one IA filed, even though it was filed on 13/12, my lord, we have been served with the copy only yesterday, my lord. We wanted to file a short reply to that, and the matter may be taken up tomorrow if possible, my lord.
Tomorrow, my lords.
Tomorrow, please, my lord,
The
because
Indian Institute of Science matter, my lords, which I mentioned yesterday and moved it, my lords.
Regarding what relief?
My lords, we are seeking permission to submit the application, my lords. The upper age limit has been fixed as 55 years for the post of financial controller. We have challenged the C&R rules, my lords, on the basis of the central government's regulation. And on previous occasion, the institute itself considered that they will permit me to submit application, and that
my
notification
lord,
was
that's the wrong submission. We
no
did
one
not
was
speak to any,
selected.
my lord. It was only as a chance. We had granted him to accept submit his application.
List tomorrow. List tomorrow.
Please, my
Please.
lord.
Okay.
Page number 13, 65 to 70. Page number 14, 70. Page number 15, serial number 71 to 75. Page number 16, 76 to 80. Page number 17, 81. List to 2. Page number 1, 81.
On behalf of respondent number 3, yesterday only we filed a color, praying time for filing objections.
Correct. Have you informed the other side? Have you informed the other side? Inform the other side and you report to the court officer, we'll adjourn. Yes.
List to 2, page number 1, 1 to 8. Page number 2, 9 to 13. Page number
At
3,
serial number 10,
10.
I appear for
List
the
to-
respondent,
Yes.
Your Honor. We seek a short accommodation. My senior colleague who's arguing the matter is not well today. We've informed the other side also.
List the matter. In the week commencing from.
30th of January.
Yes.
Page number 3, 14 to 18. Page number 4, 19 to 27. Page number 5, 28. List 3, page number 1, 1 to 6. Page number 2, 7 to 8. List 1, serial number 1. Padmanabha
My
R.
lord, my lord, my humble apologies, my lord, may I be permitted to give a memo? My lord, the petitioner herein was called for an interview. However, at the venue, he was arbitrarily denied the permission to sit for the interview and he was sent back. In the event an appointment is made for the post, my lord, the writ petition would become infractuous. It may kindly be heard tomorrow.
Tomorrow.
Grateful, man.
Yes. So what is the changes now?
My lord, as your lordship said, my lord, I have changed the petition, cost title of the petition.
So what is the
Legal
change?
age has become a,
What is the change made now?
lord, in the first petition, my lord,
Huh.
cost title, my lord. T. Dasaya, the son of deceased employee,
Yes.
has become a petitioner.
Yes. Then what is the other change?
The facts, facts have been changed. As the
Huh.
petitioner is a legal representative of the deceased employee.
That's why is the legal
Page
representative
4,
of
my lord.
Timaya.
Yes, ma'am.
Huh?
This is the employee,
Huh.
Timaya.
Yes. So that you have changed.
Yes, ma'am.
Orders, there is no change, my lord. Orders correct, my lord. Only that has to be
You have
changed.
seen the order.
Orders are correct.
Only the,
Only that cost title. only
Cost
that has to be
title.
changed.
so we'll permit him to amend in terms of the petition file.
Yes, ma'am. Yes, madam.
Huh? Learned counsel for the petitioner has filed along with memo a petition with the amendments and submits that description of the party was erroneous, as originally petition is filed in the name of Timmaya, who is the deceased. Taking note of the legal position that the petition cannot be filed by a deceased. Court had also called upon the petitioner to take steps for appropriate amendment, in light of which, along with the memo, amended petition is filed, incorporating some amendments, including as regarding cost title. Same is taken on record. Petitioner to effect changes in the original petition as well.
ಮಾಡ್ತೀನಿ.
You carry out the corrections in the original petition also.
During the course of the.
Yes. Same.
Petition, my lord, 6 to 9 are the legal representative of the deceased employee.
So you make the changes, same order.
Sir, ಬನ್ನಿ.
In that also you have filed the amended petition.
Yes, ma'am.
Serial number 3, Rajshekar Reddy V, AG.
Yes,
They have sent all the records to the AG of a Accountant General.
for processing the claim.
Yes, ma'am. Yes, sir. Officer is present.
Ah.
Within 3 months will may settle down. There is an AG of objection also.
Pending yearly.
Pending ಇರ್ಲಿ ಅಲ್ವಾ? Huh?
Compassionate appointment cannot be given.
Correct, that's a different matter. We are only on the point of
Pensioner.
pension. Taking note of the order dated 5/11/2024.
Check ಮಾಡಿ.
The state was asked to clarify regarding steps taken for release of pensionary benefits. Learned AGA, upon instructions of so and so present in court, submits that insofar as the pensionary benefits are concerned, necessary communication has been addressed to the Accountant General's
General.
office. And endeavor would be made to have the pensionary benefits released within a period of 3 months. That submission is taken note of. However,
There is a
Learned
some-
AGA submits that the question of consideration of request of compassionate appointment is a matter regarding which he would place his stand. Regarding which he would place his stand.
Yes.
Full stop. Accordingly, matter is adjourned. List the matter. We'll have it after 10 weeks. We'll have the matter. You find out what is. List the matter. On 11th of March. Yes.
4, Ajit PB.
Appear for the petitioner in this matter, my lord. The writ for mandamus to consider my representation. Respondent number
You
4,
serve on Pavan Kumar.
please, my lord.
Or if he comes, the learned counsel Pavan Kumar is directed to accept notice for respondents 1 to 3, emergent notice to 4 and 5.
Interim order.
Huh?
Interim order during pendency, my lord.
Manjunath. Chinchana, you appear for BBMP? So then you accept notice. Learned counsel Sri Chinchana Miss Chinchana accepts notice for respondents 1 to 3, emergent notice to 4 and 5. Now they're only seeking for taking action against the illegal construction of 4 and 5.
Please, my lord.
So if a complaint is made, then you issue notice to them, we'll record it and close it.
Don't have a copy, my lords, I'll serve. I've already given representations.
So we'll have it on 20th. What we used to do is in all these matters, you can undertake to issue the first notice. If it is issued, you place it on record. We'll record the undertaking that you'll pass over.
5,
There's one more matter, I think, BBMP. You just wait for 9. You just wait, 1 or 2 other matters.
5.
For petitioner lordships.
Let him come, pass over.
No, it may be taken after vacation. My file was not given.
Huh?
File was misplaced.
No. Which is this matter?
This is a matter wherein this lab technician, your lordship, has not been paid the wages, and as well as they're intending to replace his services with that of some contract employees. Even his nature of employment is being changed from that of a direct employee to that of a contract employee. That's also not permissible at all. Now they want to totally remove him and replace him with an outsourced agency.
But then they have to complete their instruction.
Yes.
No preliminary instructions.
No, my lord.
But this honorable court had twice it has directed the respondent to take the appropriate instructions.
No, what is your apprehension?
It may be
What,
taken.
what is your apprehension?
Apprehension that annexure N, your lordship.
Annexure?
Annexure N, they want to procure or appoint the set post through outsource agency.
No,
I
that-
have been working in this establishment
No,
as per
correct.
the, as per annexure A, your lordship.
No, that we'll see. We will say status quo regarding terms of employment as on date till the next date. And I'll reserve liberty for you to modify.
Yes.
Next.
There will be an order of.
Wages also, lord. His wages are pending. How can he leave it? That's also pending.
There will
since
be an
October
order of
2020.
status quo regarding terms of employment of the petitioner till the next date. Respondent is at liberty to seek for modification of the interim order upon filing statement of objections. Full stop. Needless to state, for work done by the petitioner, respondents to ensure wages are paid.
Yes. Much.
6, Kumar, yes.
Yes.
Please, my lord, I beg to appear for respondent 1 and 2, my lord. I'll file the wakalat in the counter, my lord.
What do you say regarding the interim relief?
My lord, the
Interim relief is.
They're saying that only 10 months.
Yes, 10
Please,
months.
my-
Months is left,
please, my lord.
and also that it is premature.
Please, my lord. There's no question of premature, my lord. It is a business organization, my lord. We have not adopted any government guidelines or any transfer guidelines. Based on the best interest of the business, my lord, the transfers are being made, my lord.
Lower line per row.
And moreover, my lord, on 28th of August,
Base
the
34
petitioner
years
has
is-
been placed to Mangalore as in charge, my lord. And 2/12/24, the respondent number 3 has assumed charge in Mysore. And 6/12/24, my lord,
On,
to 2nd December, my lord,
no, just 1 minute. Now,
Please.
first, what is the order of transfer?
26/11, my lord,
Is from Mysore, Mysore to Mangalore.
Bangalore.
Page?
Page 10, my lord.
10 million. ಅದು ಇಲ್ಲ.
You were working at Mangalore. Additional charge of Mangalore.
Please, my lord, that was
No,
done
no, I
on
was working
28th
in
August.
Mysore. I was also in additional charge of Mangalore.
Bangalore.
Now they
now-
say I have taken charge in Mangalore. No. Mysore I was working and I was looking as additional charge. I was looking after my Mangalore also. I was.
Now what has happened?
My
you're
lord,
saying?
my lord, 25/20/23, my lord. I shall just peruse the dates, your lordship.
20th?
25th of May, the petitioner comes to Mysore branch, my lord.
2020,
2023, my lord, 25th of May, 2023. He comes to Mysore branch, my lord.
Yes.
28th August 2024, he is given additional charge to Mangalore division. 26/11/2024, the impugned order is passed, my lord. That is relieving him from Mysore and giving him permanent posting in Mangalore, my lord. On 2/12/2024, my lord.
just one,
Please, my lord.
26/11 relieved. and
No, my lord,
posted to
the impugned
Mangalore.
order is passed.
Huh?
Impugned
Correct.
order is passed.
Relieved from Mysore,
Please, my lord.
directed to work at Mangalore.
Please, my lord. My
Then
2/12/24, my lord. Respondent number 3 assumes charge in Mysore, my lord.
he has already assumed charge.
Please, my lord. And on 6/12/24, the office also relieves the petitioner from Mysore, my lord.
Then we can only issue notice without hearing the other side. We can't pass an order.
In view of my 10 months, Your Lordship hearing,
So we'll fix a date, then we have to hear the other side. Since he has already taken charge.
true, my lord, but this court has got a power to put me back, Your Lord.
Correct, but at least we have to hear him now that he has already reported. We have to serve him, we have to hear him and then decide. The counsel for the respondent appearing for MSI submits that the private respondent.
My lord, another aspect I want to bring is, he's a second class officer, I'm a class 1, Your Lordship, even under the company's. He is posted to my place.
That we'll see, that will see in the video. Has assumed charge pursuant to the impugned order on 2/12/2024 at the office at Mysore. Further, it is submitted that on 6/12/2024, petitioner has also been relieved. In light of the same, it would be necessary to hear the third respondent if any interim order is to be passed. Consideration of interim order is kept open. This is the matter in the week commencing from
13th of January.
Your Lordship may fix the date.
in the week first week and yes.
7,
Much obliged.
serial number 7, Raghavendra Ji.
But I appear for the respondent 2 and 3. On the last occasion, my lord was pleased to say whether it can be resolved. Lord, my colleague had a discussion with the registrar of the university. My lord suggested 2 things. One is the inquiry can go on. He will cooperate. He will, my lord, the suspension order will be kept in abeyance, is what is suggested. But the registrar says that, my lord, there is another campus in Kadur, which is about 40 kilometers from the main campus. If he can agree to go there and work, we have no difficulty, my lord, for 1 and 2. Or there is another university college in Shimoga itself. If he goes there and works, also we have no objection. It can be kept in abeyance, and then, my lord, the inquiry will go on. If he agrees for that, my lord, first 2, my lord, I try to convince. The third one is what is the request made. If my learned friend's client agrees, one of the reasons is this, my lord. His tenure as the president has also expired on 5th December. He has to call for elections. Anyway, that may be a different matter altogether. But fact of the matter is, my lord, we are agreeable for both. But he should either, it is his choice, shift to work in University College in Shimoga or go to Kadur, my lord, the other campus of the university. If he agrees that, the matter can be resolved.
Lords, my client is here only. My lords can pass over. I will
Pass
just
over.
speak.
You discuss. Pass over.
Yes.
8. Govind Rajke.
But working at the other place will be a stopgap arrangement.
No, my lord, that is left to the university because there are 3 places, my lord.
Let us-
Kadur, there is a campus. He can't insist, I must work here only. He has no such a right, my lord.
Pass over. Let us.
My lord,
Therefore,
may I-
if he agrees there, the whole thing can be resolved. Otherwise, my lord, there is a
Let us
difficulty for him.
pass over.
Yes.
Eight.
Petitioners. Lord, they were selected on the basis of an earlier notification. Lord, the notification came to be challenged by some other candidates.
Now,
There was-
who appears Karnataka Urban Water Supply and Drainage Board?
Panel.
Third Council Sri Chennai Gowda is directed to accept notice for respondent number 1.
Both, my lord.
Huh?
Both.
Second also.
Yes.
1 and 2. Cross title code. 1 and 2. Is the matter in the week commencing from?
28th of January.
Yes.
9. Bhargav Bhatt.
We've impugned the show cause notice issued by Vellore Town Panchayat, my lord, under which they have unilaterally declared that the katas issued to me are illegal and are purported to take action. Now, my lord, my grievance is no inquiry has been conducted to ascertain if there was any wrongdoing with respect to the katas issued, nor was I even given an opportunity. Now, my lord,
Where is the show cause?
page number 15, my lord, annexure A is the show cause notice. This is the Antima Tiluvalike Patra, my lord. There's a prior notice that is issued to me. That is in page number 80. If I may take my lords to page number 80 first and then come to this, my lord.
Now you have replied to the show cause notice.
In fact, my lord, I've replied to the show cause notice issued in page number 80. That is a preliminary notice. As soon as this notice is issued, my lord, I'm before my lords because I purported to take action and cancel my
No, correct.
katas.
Correct. We could only observe that till the proceedings not
BBN.
Huh? Who?
This is, yes, but
This is-
Nelmangla Taluk, Vellore Town Panchayat. I read as respondent number 2.
There is no standing council, is it?
No, my lord.
Vellore Town Panchayat. But let the inquiry go on. We'll only direct that no orders to be taken till completion of inquiry.
Yes, my lord. No precipitative orders with respect to the petitioner's kat.
Correct. Provided, but you must participate in the inquiry.
Yes, my lord. Indeed, my lord.
The petitioner has sought for issuance of writ of certiorari to set aside notice dated 30/10/2024 issued by respondent number 2 and further sought for necessary direction to restrain respondent number 2 from taking any precipitative action. The case of the petitioner that pursuant to the notice at annexure A,
Yes, my lord.
the respondent would take a precipitative action without even before petitioner makes out his reply and proceedings are taken to a logical end. Full stop. Now, why are you saying that they may do that?
My lord, because in the last line, what they say is last second line, 1964 column 112 111 to 113 ರಂತೆ ಕಾನೂನು ನಿಯಮ ಬಾಹಿರವಾಗಿ ಇರುತ್ತಿರುವ ಖಾತೆಯನ್ನು ರದ್ದುಪಡಿಸುವ ಸಂಬಂಧ ಕರ್ನಾಟಕ ಪೌರಸಭೆ ಅಧಿನಿಯಮ so and so column ರಂತೆ
Yes. The petitioner submits the notice appears to indicate the conclusion that Khata is liable to be set aside. It's made clear that till the proceedings pursuant to the notice issued, including annexure A, reaches a logical finality by affording opportunity to the petitioner to participate in the inquiry, no further no order is to be passed. Lord Counsel for the petitioner undertakes that he would cooperate with the inquiry. Accordingly, while it is made clear that there is no stay of the inquiry proceeding, it's clarified that no order to be passed till the proceedings pursuant to the notice at Annexure A reach a logical conclusion as per procedure.
Yes.
Emergent notice to respondent number 2. AG accepts notice for respondent number 1.
Grateful. 10, Sunil Kumar H. Sinchana Emma.
Appeal for petitioner, my lord. I appeal for the respondent. But in this case, my lord, the instruction is this, my lord, due to discontinuation of the band, they are transferred. That is the only.
But middle of the year, how do you do?
Lord, since they are not, since it is discontinued, band is discontinued, my lord, from now to June 30th, there will be no work for them, my lord. So therefore, they've been transferred to other places.
But then something must have to be worked out in the middle of the year. You have children
Yes, my lord.
studying.
They're all studying in Bangalore, and their parents and even wife, many of they are all taking treatment in Bangalore. And my lord, apart from the band duties, my lord, all personnel, my lord, they are doing gardening works, they are doing sentry works, they are doing administrative work, they are doing accounts work, which I have mentioned in my pleadings also. They are doing the work there.
But then you'll have to make some arrangement. Otherwise, it has to be deferred.
Please,
Unless
my
you
lord.
say there is provision even after the transfer is to pass order of transfer.
No, there's no provision. No provision.
There's no provision.
No provision.
Lord, even if they're here after discontinuation of the band, there's no work otherwise.
No, that you must work out. Something he will do. Or your existing band temporarily accommodate. There's already one band.
One band.
Earlier, you temporarily.
Lord, there are about 25 plus 22, 47.
No, correct. But in effect, if you can't transfer him in the middle of the year, you'll have to make a temporary arrangement which he'll be bound by. Only the point he said is wherever he goes, he'll have to work in a band which you say that's going to be the work.
No, my lord. Even otherwise, their appointment is as constable general cadre duty. So therefore, my lord, band is additional. So they can perform other duties also if they're transferred.
Correct. So till then, at least till the transfer period again opens, you employ him in some other duty. That's the only way. You can't now ask him to move out. That's on merits of the matter regarding abolition of the ban.
Please.
That's an administrative measure that's in your power.
Please.
Which we will not enter into, at least for now. But till the transfer period again opens, some arrangement is to be made. That you find out.
Kindly pass on.
Pass.
Please, grateful.
Great.
ಯಾವುದು ಬಂದಿದ್ದಾರೆ
Lords, because though his term is over, till another election commence,
we'll see.
in another college in the same city, he is ready to go.
Yes.
Lords, one submission regarding undertaking my lords had asked for. Lords, the complaint which was filed before police station, I had given the undertaking there also.
No, that we'll see. That we'll see.
May I forward the undertaking? On that note, it was closed. That undertaking may be.
Same undertaking.
My lord, as my lords on the last day observed, he will cooperate with the inquiry and will not unnecessarily drag on. Inquiry suspension will be kept in abeyance. Inquiry will proceed. He will work in Shimoga. He enter this campus only for purposes of inquiry. Not day to day, he cannot enter these campuses. That will be another big issue unnecessarily. It is for his own good.
I have already undertaken that, my lords. That's one more submission, if I may. If, Lords, I will cooperate with the inquiry. Lords, if they, articles of charges framed with respect to first and second allegation, remedy may be kept open for me to move in accordance with law.
All that is available, whatever in law is permissible to you, we will not tie our hands.
Once
Right.
charge sheet is issued, it is open to him to proceed in accordance. with
Then why don't, where joint memo can be filed? We can merely record it. Need not have the signature of the parties.
law. Very well.
You
Party
know-
is present.
No, correct, but I'm saying if
Not the law.
university is not there,
Mhm.
whatever terms.
But the
understood-
council will. have
Yes, that will do.
On behalf of R2.
Yes, that will do.
Not the joint.
So that there's no ambiguity, whatever's understand, you put it in the nature of joint memo, will
Correct.
record.
If I am not there, please excuse my,
Pass over.
because third court 2:30, there is a.
Yes.
Yes.
Obliged.
So now the petition. The petition will remain, but interim prayer in terms of the arrangement. Also,
Our petition itself can be disposed of.
yes.
If suspension order goes, Lords.
If suspension order is kept in abeyance till the inquiry is concluded,
Yes,
petition itself can be disposed of subject to these three.
the challenge is to the suspension.
Suspension order.
Lords, page
If
35,
that is
36.
kept in abeyance, he
Petition-
gets his grievance.
I dispose it of,
redressed.
I'll make a reference to the joint memo, let it be filed.
Very well.
The petitioner has sought for setting aside of the order at annexure A, whereby petitioner has been suspended from immediate effect, that is from 2/12/2024, pending inquiry proceedings to be initiated. Full stop. Upon suggestion of the court, both parties have made efforts for an amicable resolution of the dispute. Terms of understanding between both the parties has been reduced in terms of a joint memo. Next, in terms of the said joint memo, the order of suspension is to be kept in, order of suspension dated 2/12/2024 is to be kept in
Abeyance.
abeyance. Full stop. Inquiry as contemplated is permitted to be proceeded with. Needless to state, the petitioner is to be given an opportunity to make out his reply to the show cause. You have replied.
Not yet, my Lords, but show cause notice, third allegation is not at all there. They have to issue fresh show cause notice.
No.
Because first and second allegation is there in show cause notice. Third allegation is
No,
not.
in the inquiry, it will come in evidence.
Next, in light of the full stop, the petitioner, in terms of the joint memo, has undertaken to continue work in another college of the same university at Shimoga.
Yes.
In light of the said full stop. Next, all contentions regarding, all legal contentions and otherwise regarding legality of the inquiry and other proceedings are kept open. Accordingly, petition is disposed of. Contentions of both sides have not been adjudicated upon.
Lord, one sentence, that he shall enter only during inquiry. He cannot enter day to day into the campus.
To some extent, but still I am president, I have to go. Otherwise, if I commit a
He is no
conduct a
longer.
meeting of the association outside, again it will become a misconduct.
The problem will
Outside
be
the
again the
institution
same
becomes
problem.
misconduct.
The threat to the vice chancellor and.
I will
registrar.
not go
That will be the issue, my lord. His term is over already.
No, correct. But in the
until
event,
new election.
in the event he's elected.
In the event he is elected, that's a different issue.
Until election,
my
I
lord.
have to.
But the problem is, his being there and threatening the vice chancellor and the registrar is the main issue we are facing.
That undertaking will record.
No, but the problem, he comes there, my lord, and creates a nuisance there. Sorry to use the word.
Next,
Because I will explain this way, my lord.
no, I'll record that.
He had, yes, that may be recorded, but they have, my lord, only two grievances. One is, my lord, a reversion. That is subject to government's approval. What the previous vice chancellor had done was, he has given promotions to several people without there being a post available. Audit objection was taken by the state. Therefore, my lord, we were compelled to send them back. Wherever there is a vacancy available, that will be filled up, my lord, according to their ranking. Number two, my lord, we have also made a request to the government that certain percentage also can be kept open for these people, promotees, in the place of the direct recruits also. Such a request is also made. It need not be recorded, but I am on instructions making a submission. If this is the case, my lord, there being no grievance, we do not want him to come there and create a problem. We are agreeable for, my lord, keeping it an abeyance, inquiry to go on, his cooperation, even if he is outside somewhere in Shimoga or Kadur, wherever he wants to go. If he wants TADA, that will also be granted.
Correct, but suppose he's elected as a representative of the
Yes, my
employees
lord.
union. Then if he has to come to the office, we can't prevent him from doing.
No, there are offices in all the three places. He can work from the other campus.
But this would only be a temporary embargo.
No, this will be, my lord, once he is willingly going there, then, my lord, let it not be recorded. I will advise them to close the issue. But I cannot assure at this stage, but I am trying to advise them, if he is willing to go outside and work from there and not to come into this, I am even trying to tell them to withdraw the suspension and close the whole thing. But I cannot assure at this stage. But I have advised them to do that in his own interest. Therefore, my humble submission is, for the purposes of inquiry, he will have to come there. Inquiry proceedings will go on. He has every right to defend himself. But unnecessarily coming there as the president and creating again, my lord, the same nuisance will continue. Threat to these two officers. The problem is they will not use the bikes to go from their quarters to the offices. He comes there on the way, stops, threatens. These are all the allegations against him. May be proved, may not be proved is a different issue altogether. Therefore, my lord, my humble request is he shall enter during the inquiry. Otherwise, he can work if he is re-elected from campuses wherever he is. After all, if he is the president, if he calls for a meeting of the executive committee, the members will go there to attend. In the guise of coming in as a president to the campus, this will continue. That is the apprehension. Therefore, my humble submission is that. The other things what I submitted is only for, Lord, my advice to the authorities to amicably close everything. Leave him alone. Let him work in other place. Let him be president. Let him work from outside. Wherever campus, wherever there is an office outside the campus. Whole thing can be amicably settled. Once the government approves, my lord, whoever is eligible, depending on the vacancy, promotions will be given. It's not in my hands.
No, that what you say is correct, but I'm saying, suppose he needs to campaign, he wants to be elected. We can't prevent him from discharging those rights.
No, because the problem will be entering there, my lord. That's the issue.
That will put him on terms. That will
Lord, the same thing will continue. I can't come back for reopening the case. Again, I'll have to rush to the police. Unnecessary, my lord, the problem. In the other university college in Shimoga city, he can work from there. If he is elected as a president, absolutely no harm. Whatever he wants to do, let him do from there. It's hardly about 15 kilometers from the main campus, 10, 15 kilometers. Entering here is a big issue, my lord. There is a threat.
Correct, but we have to balance. It's a democratic right.
It is a right for him, true, my lord.
So he's put on terms. If he violates it, you're at liberty to move the court.
My lord, the problem will be again, will surface. This will not continue, my lord. This will not end here.
I have given undertaking before police also. I'm ready to give undertaking here also.
What is the undertaking you?
I have accepted that I had gone near his house. That is for the purpose of giving, when show cause notice was issued to me.
Correct, but what is the undertaking now you are going to?
That I had meant no such harm, but I will make sure no more I will repeat that.
No, correct. If you now you are going to work in a different university.
Difficulty is that,
So same university,
if I call for a meeting outside, any other place, not inside the institute about the employees, again, it may attract misconduct.
No, for the limited purpose, that's okay, but not beyond that.
I'll undertake to, my lords, only if any for limited purpose only, not to disturb any administration. That I have agreed,
You put it in the joint memo.
my lords. Only for the work of president, I will come, nothing else apart from that. I'll put it in the joint memo.
The problem. And except for visiting your office, you will not go to the other parts of the campus. Whatever office you have, you can enter the office, finish your work and go. You must not you must not go outside. Because now
And
you're
for
working.
campaigning,
No, that we'll see. That I'll keep it open. That way I'll make an observation.
obliged, that I will. Deeply obliged.
Serial number 11, Maruti S. 11.
For petitioner, my lord. But in this case, my lord, after granting maternity leave by the respondent number 2, my lord, the petitioner transferred to the place of respondent, office of the respondent number 4, my lord. Now the respondent number 4 appointed some other person.
Yeah, you take out
Yeah.
notice.
Please.
Emergent notice to the respondents. List the matter in the week commencing from.
20th of January.
Yes.
12. Sharath S. Code.
Annexure A is under challenge. Annexure A is an order of dismissal, dismissing the petitioner, my lord, without holding any inquiry. And my lords, the order of dismissal traverses beyond the scope of the show cause notice. Though, therefore, my lords, both on the count that it traverses beyond the show cause notice and also on the ground that no inquiry has been held, violating principles of natural justice.
Contract labor abolition.
He was a temporary employee, my lords, and he had previously approached this honorable court seeking for regularization of his service. Your lordship may kindly take annexure
Now
D.
you take out notice. We have to hear the other side.
My lords, the similar matters have been posted tomorrow, my lords, identical.
Who appears?
Geeta Devi Papana.
Counsel. Geeta Devi Papan is right to accept notice of the respondents. List the matter, relist the matter tomorrow.
In so far as temporary employees are concerned, my lord, the law is they can be dismissed implicit, saying your work is unsatisfactory. But if they impute any allegations, my lords, then they have to conduct inquiry as contemplated under Article 311. This is the law, my lords. I have cited judgments in the petition itself.
Correct, but they're not government employees.
No, not necessarily, my lords. Any temporary employees, even ad hoc employees, they can be simply removed from service, stating your service is not satisfactory. No reason is required.
Any authority on the point?
Yes, my lords. The authority, your lordship may kindly take this.
Paragraph?
Paragraph, my lords. Nine, my lords.
Yes.
Para 30, before para 9, my lords, at page 8, your lordship may also see the top paragraph 35. The above decision is, in our view, a clear authority for the proposition that the material which amounts to stigma need not be contained in the order of termination of the, but might be contained in any document referred to in the termination order or in its annexure. Obviously, such a document could be asked or called for by the future employer of the probationer. In such a case, the order of termination would stand vitiated on the ground that no regular inquiry was conducted. We shall presently consider whether on the facts of the case before us, the documents referred to us in the impugned order contain any stigma. Then, in the case of Pavanendra Narayan Verma versus Sanjay Gandhi so-and-so, reported in 2001 SAC, the court observed thus, one of the judicially evolved tests to determine whether in substance an order of termination is punitive is to see whether prior to the termination, there was a full-scale formal inquiry into the allegations of moral turpitude or misconduct culminated in a finding of guilt. If all these three factors are present, the termination order has been held to be punitive, irrespective of the formation of the form of terminative order. Conversely, if any one of these three factors is missing, the termination has been upheld. Here, my lords, a formal inquiry is held, show cause notice is given, and this order is passed, and this order on the face of it, if it is read,
Punitive.
it's punitive. Because of this reason, my lords, if he is a for a regular government employee, my lords, KCSR rules are there. There just be to a regular inquiry. The reason is this, because if he is dismissed on the grounds of stigma and punitive, he cannot avail another employment. Therefore, the courts have evolved that if it is so, it should be best with a regular.
Tomorrow.
And moreover, my lords, there are 95 persons working, my lords, in Mysore City Corporation. Only 6 of them, my lords, have been made scapegoat. Rest of them have been there.
Let us.
Please.
13, serial number 13, CM Nagapathan. BL Sanjeev.
They have to file objection, maybe taken after rotation.
So what is the matter?
The matter is, your lordship will kindly say, an incident take place. From that place, I have been shifted about 16 months ago. Even then, your lordship, they have kept me in my suspension. If I can bring to your lordship consideration, page 72, your lordship. Page 72 is an answer given by the department to the queries made by the police department. Here, your lordship will kindly, two kinds of people are there. When the incident took place, who are working as the
What
engineer?
was the incident?
The gate was collapsed, your lordship, and a boy has been died. That took place after 16 months after I have been transferred from there. And in fact, I was there only for 10 months.
What was the date of the incident?
22/9/24, your lordship.
The gate fell on that date.
Yes, your lord.
Now, when were you working?
I was working, your lordship will kindly say, 1/7/2022 to 16/5/2023.
The gates were installed during your time or
No, it is not, your lordship. And that's why I bring to your lordship consideration. If your lordship is kind enough to pay 72, police have asked for some queries to the department. The department gives in detail what is the incident, what happened, everything. At page 72, if your lordship is kind enough to take.
Yes.
Second serial number 10 ತಗೊಂಡಿರ್ತಾವು.
Yes.
ಸದರಿ ಗೇಟ್ ಅಳವಡಿಕೆಗೂ ಪೂರ್ವದಲ್ಲಿ ಡ್ರಾಯಿಂಗ್ ಅಪ್ರೂವಲ್ ಸಮಯದಲ್ಲಿ ಹಾಗೂ ಅಳವಡಿಕೆ ಸಮಯದಲ್ಲಿ ಸದರಿ ಆಟದ ಮೈದಾನ ವ್ಯಾಪ್ತಿಗೆ ಸಂಬಂಧಪಟ್ಟ ಕಾರ್ಯನಿರ್ವಹಿಸುವ ಮುಖ್ಯ ಅಭಿಯಂತರ ಸಹಾಯಕ ಅಭಿಯಂತರರಿನ ಹುದ್ದೆ ಎಲ್ಲ ಅಧಿಕಾರಿಗಳ ಹೆಸರು. ದಿಸ್ ಇಸ್ ದೇ ಗಿವ್ ದಿ ನೇಮ್ಸ್ ಯುವರ್ ಲಾಸ್. ಇವರು ಗೇಟ್ ಅಳವಡಿಕೆ ಸಮಯದಲ್ಲಿ ಮತ್ತು ಮೊದಲನೇ ಮತ್ತು ಭಾಗಶಃ ಬಿಲ್ ಅನ್ನು ಸಿದ್ಧಪಡಿಸುವ ಅಧಿಕಾರಿಗಳ ಇವರ ಶಾಂತಲಾ so and so, your lordship.
Your name is not there.
Not there. Next page, if your lordship kindly take. ಗೇಟ್ ಅಳವಡಿಕೆಯಾಗಿ 1 ವರ್ಷ ಆದ ನಂತರ ಮತ್ತು ಎರಡನೇ ಅಂತಿಮ ಬಿಲ್ ಅನ್ನು ಸಿದ್ಧಪಡಿಸುವ ಸಮಯದಲ್ಲಿ ಇದ್ದ ಅಧಿಕಾರಿಗಳ ಇವರ my name finds in the second page.
That is only at the time of the bill.
Yes, bill ಕೂಡ ನಾನು ಮಾಡಿಲ್ಲ. And the question of bill does not arise here because the question is with the gate has fallen down because of the bad fixation of everything. The gate was fixed, your lordship, long back. I have produced the photos also, your lordship.
Lord, investigation is going on. She has been suspended, my lord. Nearly about 5 of them have been suspended. Not the only officer, my lord. Page 18, my lord. Page 18, my lord.
Yes.
Lord, may I read that first paragraph? ಸದರಿಯ ಕಾಮಗಾರಿಕೆ ಮೊದಲನೇ ಮತ್ತು ಮಹಾಶಯ ಬಿಲ್ಲನ್ನು ಶ್ರೀಮತಿ ಶಾಂತಲಾ ಕೆ ಸಹಾಯಕ ಅಭಿಯಂತರು ಮತ್ತು ದೇವರಾಜ್ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು ಮತ್ತು ಶ್ರೀ ವೆಂಕಟೇಶ್ ಎಲ್ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು ದಾಖಲಿಸಿದ್ದು, ಎರಡನೇ ಮತ್ತು ಅಂತಿಮ ಬಿಲ್ಲನ್ನು ಶ್ರೀನಿವಾಸ್ ರಾಜು ಸಹಾಯಕ ಅಭಿಯಂತರು ಮತ್ತು ಶ್ರೀಮತಿ ಬೇಬಿ ಆಯುಷಾ ಹುಸೇನ್ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು ಮತ್ತು ವೆಂಕಟೇಶ್ ಎಲ್ ಕಾರ್ಯಪಾಲಕ ದಾಖಲಿಸಿರುತ್ತಾರೆ. ದಿಸ್ ಇಸ್ ದಿ and now, my lord, It is in the investigation, my lord. She has been suspended.
Correct, but the point remains.
And now the government has suspended. The order is, the government has passed an order. Because they belong to the A category, my lord. They have been suspended because the government has done it. Annexure A is passed by the government.
No, now government.
And now, my lord, the
Paragraph
inquiry
2.
has not been initiated yet, and that will be done, my lord. In the meantime, let the inquiry, let us submit her report, explanation.
Inquiry may go on, Your Honor. I will
Let
participate.
us submit her explanation.
No,
my
that
lord.
is
Let them
there.
take their stand, my lord. After 3 months, they will do it. Only on 14/11/24, this incident, after the incident, my lord, all this suspension has happened,
No, that is so.
my lord.
She's not working there.
No, she was working. She herself says,
Correct, when she was working.
my lord, at any
Between
point,
22 and 23, she worked.
my lord,
Paragraph 2 of page 18.
my lord, the
ಆಟದ ಮೈದಾನದ ಗೇಟ್ ಅನ್ನು ಅಳವಡಿಸಿ ಸುಮಾರು 2 ವರ್ಷ ಕಳೆದಿದ್ದು ಗೇಟ್ನ ಸಾಮರ್ಥ್ಯಕ್ಕೆ ತಕ್ಕಂತೆ ಕೀಲುಗಳನ್ನು ಅಳವಡಿಸಿಲ್ಲದೆ ಇರುವುದು ಹಾಗೂ ನಿರ್ವಹಣೆ ಕೊರತೆಯಿಂದ ಅಂದರೆ ಕೀಲುಗಳಿಗೆ ಲೂಬ್ರಿಕೇಶನ್ ಮಾಡಿಲ್ಲದೆ ಇರುವುದರಿಂದ ಕೀಲುಗಳು ತುಕ್ಕು ಹಿಡಿದು ವೆಲ್ಡಿಂಗ್ ಕಟ್ ಆಗಿ ಮುರಿದು ಬಿದ್ದಿರುತ್ತದೆ ಎಂದು ವರದಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
that is the, that,
so
my lord, they
how
have
is-
to take action against them, my lord.
No, that
They
means
let them take a decision, my lord. Not that within 1 month, my lord, they cannot be.
No, correct. The whole purpose of suspension cannot be punitive. She's working somewhere else.
First
She's
of
not
all,
working.
suspension order, they are coming and challenging the suspension order, my lord. Let them be given some time, my lord. Let them take action, whatever, the inquiry has to be initiated. Not saying that till the inquiry is over or let.
She's not working there even to
No, my lord,
destroy.
at one point of time, she was working, her own
Correct.
statement.
Correct, but now.
Her own statement says the man, my lord, here the heavy gate
Hmm.
collapsed because of the negligence of these officers. But for them, my lord, if they had looked after it, my lord, the hinges have fallen, my lord. And one person has died.
Now, she has been transferred
My
on
lord.
16/5/23.
Yes,
Incident is on 22/9/24, 1.5 years after that.
my lord, whatever it is, she is not the only person, my lord. The second petition also, he is also there. He also comes under the group A, my lord. The petitioner, the government has passed the said order.
We'll see case by case. Yes, government, what do you say?
After vacation, files the objection.
That is, the petitioners have challenged the order of suspension. Passed dated 14/11/24. In the case of the petitioners, that the incident of gate falling upon a child,
Yes, sir.
and the child having succumbed to injuries and died, had taken place on 22/9/24.
Yes, my lord.
It is further submitted that the petitioner was working in the said division between 1/7/22 and 16/5/23.
Yes, my lord.
It's
When
further submitted.
When the gate was erected, she was there.
No, no, no.
It is further asserted that the only role of the petitioner, even as per the report ordering suspension, is that the petitioner was an official at the time the bill was cleared. Full stop. Attention is drawn to the response of the BBMP at annexure H1 at serial number 10 and 11.
Page 72.
10 at serial number 10, and it is asserted that even the report of the BBMP would not indicate that the petitioner was there at the relevant time, except the petitioner's alleged role in clearing the bill. Next, it is noticed that the petitioner is no longer working in the division where the incident has occurred. Taking note of the role attributed while passing the suspension order, prima facie it appears that the only imputation of the petitioner is regarding clearing of bill. Subject to further consideration, there would be stay of the order at annexure A only insofar as the petitioner is concerned. while making it clear that the order passed is on the facts of the petitioner and cannot be used as a precedent in other matters. Needless to state, petitioners to take part in the, is to cooperate in the inquiry process.
Lord, and liberty may be granted, my
Liberty
lord,
is
so she be
reserved.
posted to any other place other than the
She is
place
already
now working.
transferred. She is not there.
Working
I
different.
understand, my lord. They want them to be posted to any other place. My lord.
That you take.
That is the discretion, yes, my lord. That liberty may be granted and the inquiry can go on, my lord, whatever disciplinary.
Inquiry may go on.
That should not,
Yes.
that is, he was there, my lord.
He was there.
He was there.
Lord, page 22, your lordship kindly see my lord.
No, you were the executive engineer of the place.
Yes, my lord. Yes.
Then you have to wait.
Lord, your lordship kindly see the second paragraph, page 22, my lord.
Yes.
Lord, ಮೇಲ್ಕಂಡ ಕಾಮಗಾರಿಯಲ್ಲಿ ಗೇಟ್ ಅಳವಡಿಸಿರುವ ಕಾಮಗಾರಿ 1ನೇ ಮತ್ತು ಭಾಗಶಃ ಬಿಲ್ಲನ್ನು ದಿನಾಂಕ 15/3/2023 ದಾಖಲಿಸಿರ್ತಾರೆ. 2ನೇ ಮತ್ತು ಅಂತಿಮ ಬಿಲ್ಲು ದಿನಾಂಕ 3/5/2023 ದಾಖಲಿಸಿದ್ದು 1ನೇ ಮತ್ತು ಭಾಗಶಃ ಬಿಲ್ಲು ಮತ್ತು 2ನೇ ಮತ್ತು ಅಂತಿಮ ಬಿಲ್ಲನ್ನು ಇದುವರೆಗೂ ಪಾವತಿಸಿರುವುದಿಲ್ಲ. They have not yet paid. ಮೇಲ್ಕಂಡ ಕಾಮಗಾರಿಯನ್ನು 17/1/2024 ಗುಣ ಭರವಸೆ ವಿಭಾಗದವರು ಸ್ಥಳ ಪರಿಶೀಲನೆ ಮಾಡಿರುತ್ತೆ. They have given quality assurance department has given that clearance, my lord. Then after, my lord, 22/9/2024 incident was happened. Lord, is bill is completely not cleared except the same allegations, my lord. The serial number 13, the third paragraph, my lord. 2ನೇ ಮತ್ತು ಅಂತಿಮ ಬಿಲ್ ಅನ್ನು ಶ್ರೀನಿವಾಸ ರಾಜು ಸಹಾಯಕ ಅಭಿಯಂತರು, ಶ್ರೀಮತಿ ಬೇಬಿ ಆಯಿಷಾ ಹುಸೇನ್ ಸಹಾಯಕ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು ಮತ್ತು ಶ್ರೀ ವೆಂಕಟೇಶ್ ಕಾರ್ಯಪಾಲಕ ಅಭಿಯಂತರು ದಾಖಲಿಸಿರುತ್ತಾರೆ.
No, correct. You are the executive engineer of the division.
Yes, my lord. Executive engineer.
He is in charge, my lord.
You have to
Lord,
wait.
in charge is executive assistant engineer is looking after, my
That
lord.
we'll see. That we'll see.
Lord, quality assurance is given a report stating that, my lord, is after, my lord, he's given reply also, my lord. Lord, 2/5/2024 is
See, that we'll see. You are suspended on.
same 14. Same date, my lord. We have received on WhatsApp on 9/12. Lord, suspension order, your lordship kindly see page 26.
That we'll see. But what we can only observe that after collecting necessary information, since suspension by itself cannot be punitive, liberty is reserved for you to pass appropriate orders of reconsidering the
Let
order
them
of
consider.
suspension.
Lord, annexure A, my lord, the petitioner himself is given initial report, my lord. Your lordship kindly see.
Let us see. Let us see. We'll ask them to reconsider it once they collect all the necessary information.
Lord, this serial number 13, same assistant executive is same putting, my lord. He is only released
not
part.
there.
No, that other person was transferred 1.5 years before the incident. In the other matter,
Yes, my lord.
you are working here now.
Let not be similar, my lord. She was not working. That
Let us see. The petitioner has challenged the order of suspension and raised various grounds. Good stuff. Learned counsel appearing for the second respondent, BBMP, as well as the state submits that they would file their statement of objections. Full stop. Suffice it to state that order of suspension has been passed on 14/11/24, and once the authorities have collected necessary information as may be relevant for the purpose of proceeding with the inquiry, if they so decide, the order of suspension could be reconsidered. It's made clear that the interim order is open for reconsideration in the next date. This is the matter in the week commencing from second week, 13th of January.
In this case, petitioner was working as a bill collector. He was dismissed from service, without holding disciplinary inquiry. I have filed a memo for quashing of the impugned order, my lord, reserving liberty, my lord, to hold disciplinary inquiry and pass fresh order. J and K are the resolution. J is the resolution, K is the order.
The petitioner has filed the project, has sought for setting aside the official memorandum passed by the fourth respondent at annexure K and the impugned proceedings at annexure J passed by the fifth respondent insofar as it relates to the petitioner. Full stop. The primary contention of the petitioner being that without inquiry,
Yes.
impugned orders are passed. Memo for disposal is filed by the respondent 4 and 5, which reads as follows. In light of the said stand, no purpose would be served by entering into adjudication of annexure J and K. Accordingly, same are set aside. Liberty is reserved to respondent 4 and 5 to hold disciplinary proceedings if required to be disciplinary proceedings as per law.
And
All
your lordship,
contentions are
madam,
kept open, petition is disposed of.
inquiry should not be an empty formality.
Needless to state, inquiry held ought to be after following the procedure and affording principles of natural justice and be consistent with the mandate of Article 14.
Please.
Much obliged.
14, vide TM.
You have filed the statement. But on that, I will submit for not on the statement.
Now
filed
we
by-
just take the whole.
Yes, yes, yes.
I've forgotten whatever.
Yes, yes. My lord, I have filed a synopsis.
On 13/11.
Yes, that is on, yes, 13/11. My lord, initially, Lordship kindly see, he was appointed. My lord, first one is 31/3/2006 order. Government order. Lord, your lordship get it at page number annexure K, page number 42.
Page
42, annexure K. My lord, here, this is a government order dated 31st March 2006. Annexure KG 4242, my lord.
Yes.
My lord, the paragraph unnumbered, paragraph 3 is relevant. We have not paragraph, in that paragraph, third line. The new system is applicable to all the new entrants to the central government, joining to government service on or before, after 1/1/2004. My lord, regarding Karnataka, my lord, 43. State government, 43, my lord.
So this is the new scheme.
New pension scheme, my lord. Contributory pension scheme, that is new defined pension scheme called.
Yes.
Now, can you look at, my lord, the order? The new defined contributory pension scheme shall be mandatory to all new recruits to the state government service joining on or after 1/4/2006. Joining on or after 1/4/2006. But joining is important.
Yes.
Now, coming to the petitioners, my lord, can you look at, my lord, the order of regularization at page number 17. The top of it, my lord, Ulleka. That is, my lord, the orders of the Supreme Court. directing the university to consider petitioner's case for regularization. My lord, I have produced that orders also, along with the memo.
Yes.
Lord, kindly, I'll read, my lord. But initially, these people have been appointed. Page of 17, my lord. Your last, well, I'm reading the order 17. But that may not be relevant, my lord. I'll give you that order, my lord. Now 17, my lord. Page of 17.
Yes. Yes.
But initially, they were the employees of University of Agricultural Science. Once, my lord, the university, veterinary university was established, they have been, my lord, posted to that university. My lord, kindly see, Karnataka Pashu Vaidyakiya Pashu Meenagaರಿಕೆ ವಿಜ್ಞಾನಗಳ ವಿದ್ಯಾಲಯ ಬೀದರ್ ಇಲ್ಲಿ ಇಂದಿನಿಂದಲೂ ಮಾಸ್ಟರ್ ದಿನಗಳು ಸಲ್ಲಿಸುವ ದಿನಗಳು ಕಾಯಮಾಗಿ ಸೇವೆಯಲ್ಲಿ ಸ್ಥಾಪನೆಗೊಳಿಸಿ ಕೋರಿ ಕರ್ನಾಟಕ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಸಲ್ಲಿಸಿದ ರಿಟ್ ಅರ್ಜಿಗಳು ನ್ಯಾಯಾಲಯ ವಿಲೇವಾರಿ ಮಾಡಿ ಅರ್ಜಿ 10 ವರ್ಷಗಳನ್ನು ಪೂರೈಸಿಗೊತ್ತಿರಲಿ ಉಲ್ಲೇಖ 2ರ ರಿಟ್ ಅರ್ಜಿಯ ಮೇಲೆ ಪ್ರಕಟಗೊಂಡ ಕರ್ನಾಟಕ ಉಚ್ಚ ತೀರ್ಪಿನಂತೆ ಉಲ್ಲೇಖ 1 ರಿಟ್ ಅರ್ಜಿಯನ್ನು ದಿನಗೂಲಿ ಸೇವೆಯಿಂದ ಕಾಯಮಾಗಿ ಸಕ್ರಮ ಮಾಡಲು ನಾಣ್ಯ ಆದೇಶ ನೀಡಿರುತ್ತದೆ. Lord, this is the order of the court, my lord. Then, my lord, there is a resolution of the board, paragraph 2. Then, my lord, next page, serial number 6.
Yes.
Mariswamy, my lord, he had completed 10 years. Let's kindly look at the column number 4 in that. 5. Sakramatiಗೆ ಅನ್ವಯವಾಗುವ ದಿನಾಂಕ. That means on completion of his 10 years of service. That means we had joined to service, my lord, during 1987. Can you look at, my lord?
Yes.
22-97. He joined to service in the year 1987. My lord, serial number 14 and 15, my lord.
Yes.
With effect from 1198 and 1898. My lord, kindly see the next line, my lord. ಸದರಿ ನೌಕರ ಹುದ್ದೆಯ ಮೂಲ ವೇತನದ ಜೊತೆಗೆ ಕಾಲಕಾಲಕ್ಕೆ ನಿಗದಿತ ಇತರ ಭತ್ಯೆಗಳು ಸಕ್ರಮಗೊಂಡ ದಿನಾಂಕದಿಂದ ಪಡೆಯಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. ಈಗಾಗಲೇ ನಿವೃತ್ತಿ ಹೊಂದಿದ ನೌಕರರು ಸಕ್ರಮ ದಿನಾಂಕದಿಂದ ಅನ್ವಯವಾಗುವಂತೆ ಸೌಲಭ್ಯ ಪಡೆಯಲು ಅರ್ಹರಾಗಿರುತ್ತಾರೆ. Even for retired employees also. But this is the order, man. Now, university, my lord. Kindly look at annexure H, my lord, page number 31.
Yes.
But this is a correspondence by the university to the government. I'd only read the relevant portion at page number 32, my lord. Unnumbered 3. ಸದರಿ ಸಕ್ರಮಗೊಂಡ ದಿನಗಳು ನಾಲ್ಕವರು ದಿನಾಂಕ 1/7/84ರಿಂದಲೇ ಕೆಲಸ ನಿರ್ವಹಿಸುತ್ತಿರುವುದರಿಂದ ಸದರಿ ಸಕ್ರಮ ಪ್ರಕ್ರಿಯೆ ಆಡಳಿತಕ್ರಮವಾಗಿ ತಡೆಯಾಗಿರುವುದರಿಂದ ವಿಶ್ವವಿದ್ಯಾಲಯದ ಆದೇಶದ ದಿನಾಂಕ 14/7/8 ಆಗಿದ್ದರೂ ಸಹ ಸದರಿ ದಿನಾಂಕರು ಹಳೆ ಪಿಂಚನ್ಗೆ ಅರ್ಹರಾಗಿದ್ದಾರೆ ಹಾಗೂ ಸದರಿ ಕಾಯಗೊಂಡ 12 ಜನ ದಿನಾಂಕರ ಭವಿಷ್ಯ ನಿಧಿಯನ್ನು ಪರಿಗಣಿಸಲಾಗಿದ್ದು ಅವರ ಮಾಸಿಕ ಸಂಬಳದಿಂದ ಕಡಿತಗೊಳಿಸಲಾಗಿದೆ. That means, my lord, they have deducted towards, my lord, provident fund in the direction of, my lord, applying the new scheme, old scheme.
Yes.
So, my lord, the government university being the appointing authority, my lord, had no issues with that.
Yes.
It's only when we filed contempt, my lord. Previously, we approached the Honorable Court, my lord, seeking a direction. And, my lord, when we filed for contempt, annexure B came to be passed.
Now, out of the 12 people who were recommended,
Yes.
12 people were recommended,
Yes.
out of which the present petitioners are 4. 3.
3 years.
Remaining?
Remaining are there, my lord, whether their case, my lord, I am not aware of what
Yes.
happened. Lord, kindly look at Annexure B, page number 19 now, ma'am.
Page
19.
yes.
This is from the government.
Yes.
This was produced in the contempt proceedings, served on me. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದ ಉಲ್ಲೇಖಿತ ಪತ್ರದ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ ದಿನಾಂಕ 13/23 ಸರ್ಕಾರದ ಆದೇಶ ಸಂಖ್ಯೆ 0 ದಿನಾಂಕ 1/4 ಅಥವಾ ದಿನಾಂಕ ನಂತರ ರಾಜ್ಯ ಸರ್ಕಾರ ಸೇವೆಗೆ ಸಲ್ಲಿಸುವ ಎಲ್ಲಾ ವ್ಯಕ್ತಿಗಳಿಗೆ ಕಡ್ಡಾಯವಾಗಿ ನೂತನ ಅಂಶದಾಯಿ ಕೊಡುಗೆ ಪಿಂಚಣಿ ಜಾರಿಗೆ ನಡೆಸಬೇಕಾಗಿದ್ದು ಹಳೆಯ ಡಿಫೈನ್ ಪಿಂಚಣಿ ಯೋಜನೆ ಕಡ್ಡಾಯವಾಗಿ ಸ್ಥಗಿಸಬೇಕೆಂದು ಆದೇಶಿಸಲಾಗಿರುತ್ತದೆ. ಈ ನೀತಿಯನ್ನು ವಿಶ್ವವಿದ್ಯಾಲಯದ ಸೇರಿದಂತೆ ಎಲ್ಲಾ ಸ್ವಾಯತ್ತ ಸಂಸ್ಥೆಗಳು ಸಹ ಪಾಲಿಸಬೇಕಾಗುತ್ತೆ. ಪ್ರಸ್ತುತ ಪ್ರಕರಣದಲ್ಲಿ ಸಂಬಂಧಿತ ದಿನಗಣಕರನ್ನು 14/7/2008 ಆದೇಶ ಅನ್ವಯ ಸೇವೆಯಲ್ಲಿ ಸಕ್ರಮಗೊಂಡಿರುವುದರಿಂದ ಈ ನೌಕರರಿಗೆ ಹಳೆ ಡಿಫೈನ್ಡ್ ಪಿಂಚಣಿ ಯೋಜನೆ ಅನ್ವಯಿಸುವ ಅವಕಾಶವಿಲ್ಲವೆಂದು ನಿರ್ದೇಶಿಸಲಾಗಿರುತ್ತದೆ. They say there was an order by the government on 14/7 in terms of which, my lord, these people have been regularized. But that is not at all relevant for the purpose because, my lord, the joining date and the effect of the order at Annexure A is relevant.
Yes.
My lord, now coming to the university, my lord.
Yes.
They have on parity, my lord. Now my first submission is.
You can't say they have joined after.
Yes, my lord. 1/6/14/2006.
1/1/2004.
6.
Huh?
2006.
1/4/2006.
1/4/2006.
So they're deemed to have continued earlier because they're working as daily wage and the order of regularization dates
Yes,
back.
ma'am. They were retrospectively appointed. That means the effect should be given from the first date.
Yes.
It dated back to 1997.
Yes.
That is for your lordship to interpret the
Yes.
issue. My lord, moreover, they were not the recruits. They were, my lord, appointed on the basis of regularization.
Yes.
My lord, kindly look at the parity aspect of it.
Yes.
My lord, the government has passed an order, issued, my lord, this filed objection statement stating that, my lord, I have taken a contention that, my lord, on parity also we are entitled. But I have produced certain orders before your lordship. That order at Annexure R, page number 60.
Page
60.
Yes.
Lord, these people have been regularized in the similar fashion with effect from 1997 and 2000. One of them was appointed with returns between 1 to 2000. And we'll kindly look at page number 62. Narsimurthy. For him, my lord, the old pension scheme made applicable. 6/2.
His date of regularization.
Is, my lord, Narsimurthy is with effect from 1/1/97. Last two gets is page number 61. Number 2. Serial number 2.
Order of regularization was passed on.
Passed on, my lord, 12/9/2013. Kindly see, my lord, page number 60. But next, yes.
That is serial number 9.
Serial number 2, page number 61.
Correct. So the order of regularization.
Order of regulation, my lord.
Reference number 9, is it?
Yes, reference number 9.
That is 12/9/2013.
That is Anumodan. Yes. Approval. But can you look at next order, page number 63.
Your approval was on 17.
Yes.
Yes.
Approval, none, the order is during 17.
Yes. Yes.
But can you look at annexure, yes, my lord, page number 63.
Yes.
Here also, my lord, the number 2, Chandrappa.
Yes.
My lord, for him, may I request your attention to page number 65.
Yes.
Chandrappa is given, my lord, the benefit of old pension scheme at 65. He was regularized with effect from, my lord, 19/2000. Ours is 97. 19/2000.
19.
2000. That is, my lord, number 2. Date of the order is 12/12/2012.
Yes.
My lord, then, last week kindly see the other order. Annex T. Before which, may I take your lordship to page number 68, my lord. Page number 68.
Yes.
Here is description of employees by the university, my lord, who are entitled and not entitled. My lord, kindly look at Kostaka 2, that is schedule 2, page number 69. For all these employees, what I have mentioned just now, Chandrappa is number 4, saying that they are not entitled. That was the university statement previously, my lord, that's not relevant. Chandrappa. Then, my lord, all these people, including Narasimha Raju, that is Narasimurthy, page number 17, I have referred to. Then a petitioner, my lord, page number 24. And, my lord, page number 24, then 31, 32, my lord, and 33. 32 and 33. Date of regular appointment, date of regulation, all is mentioned here.
So the,
Parigayasa Dinanka, appointment date, all are mentioned. This is relevant. My lord, kindly see. Now, my lord, page number 67.
yes.
T. This Gauri Shetty, number 2, who was appointed on 28/11/84 as per the schedule, finds place in, my lord, page number, paragraph, column number 11 in the schedule I have mentioned, next annex VL.
Yes.
And, my lord, Charles, who was appointed on 4/2/89 after us, and Ashoka Biradara, 390, 3 after years later than us, as a daily rated employee also. Then, my lord, Nagaraju, Sidrama, 23/3/89. My lord, kindly see, this is found. These are found in, my lord, page number 69. Last kindly see column 11, 12, 13, 14. I am pressing on this because they have come out with a new story now. Kindly see, my lord, date of appointment of Gauri Shetty. That is 11. My lord, column number 3 ಅಲ್ಲಿ 28/11/84. Then, my lord, Charles, 4/2/89. Other one, Biradar, my lord, 93/90. And yet another one, Siddharama, 23/1989. My lord, these people have been appointed after 1784 at par with the petitioners.
Yes.
Now, the contention raised by the university, my lord, next page I will read, I will come to that. 71.
Yes.
71. Yet another order by the university. Herein, my lord, they have stated specifically, I will read, my lord. ಮೇಲಿನ ವಿಷಯ ಉಲ್ಲೇಖಗಳಿಗೆ ಸಂಬಂಧಿಸಿದ ಮೇಲಿನ ಉಲ್ಲೇಖ 1ರಿಂದ 11ವರೆಗಿನ ಆದೇಶಗಳಿನ ನೌಕರಿ ಹಳೆ ಪಿಂಚಣಿ ಯೋಜನೆ ಜಾರಿಗೊಳಿಸಲಾಗಿರುತ್ತದೆ. ಈ ಆದೇಶ ಉಲ್ಲೇಖ 12ರಿಂದ 13ರ ಆದೇಶಗಳಿನ ಉಲ್ಲೇಖ 1ರಿಂದ 13ವರೆಗಿನ ನೌಕರರಂತೆ ಈ ಕೆಳಗಿನ ಉಲ್ಲೇಖದಲ್ಲಿ 12 13ವರೆಗಿನ ನೌಕರಿ ಕೂಡ NPS ನಿಂದ GPS ಗೆ ಸೇರ್ಪಡೆಗೊಳಿಸಲು ಸೂಚಿಸಲಾಗಿದೆ. ಯೂನಿವರ್ಸಿಟಿ have shifted for these petitioners and others from old new scheme to old scheme. My lord, now coming to the contention, this is, my lord, where petitioners are found in next para, page 72. There, my lord, 11, 19 and 20 in 72.
11,
11, 19 and 20, my lord.
yes. Now, what is the stand taken by the respondent?
In respondent is taking a stand, my lord, saying that, may I take your lordship to the statement made by them. Now they have filed. You know, the government at paragraph 9. That's the only thing relevant. Paragraph 9, my lord. It is submitted that the university has extended the benefits of OPS to those employees who were appointed on or before 110/84, whereas petitioners and others have been appointed in the year 1987. This is apparently, patently not correct, because I pointed out that Gauri Shetty, Charles, Siddharama and Biradar and others have been appointed, my lord, after 1984, even after the petitions have been appointed. But that apart, the date of 1784 mentioned by them is irrelevant. My lord, why they are mentioning that date? Because before this regularization judgment of Uma Devi, there was a judgment of Dharwad district workers case in the year 1990, where a cut-off date was fixed. Those who were appointed before 1784 were held to be entitled for regularization.
That was only relevant for regularization.
Regularization.
Now,
cut-off.
after regularization order is passed, it loses significance.
Now, yes, here the issue is whether, my lord, they have joined to service after 1/4/2006 or before that.
Yes.
Even otherwise, my lord, according to their own contradiction, all of them have been appointed after, my lord, 1784.
Yes, sir.
So, yes.
One more government order after that. It will be helpful to him.
Yes.
It says, my lord, persons who have been recommended prior to 1/4/2006, not joined duty.
Yes.
They are entitled. Then
Yes.
fourth,
Yes.
later, about 2 months back, 3 months back, that order.
Yes, that I have produced one of the copies, my lordship. Kindly see, I am grateful to the senior counsel, my lord. That may be at par 49.
Page?
49. And my lord, 47. This analogy can be drawn from this as well, my lord, as senior counsel pointed out, my lord. 47.
Yes.
Government order 24/1/24. ಪ್ರಸ್ತಾವನೆ ವಿವರಿಸಿದ ಅಂಶಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ದಿನಾಂಕ 1/4/2000 ನಂತರ ಪೂರ್ವದಲ್ಲಿ ರಾಜ್ಯ ಸಿವಿಲ್ ಸೇವೆಗಳಲ್ಲಿ ಖಾಲಿ ಹುದ್ದೆಗಳ ಭರ್ತಿಗೆ ಹೊರಡಿಸಿದ ನೇಮಕಾತಿ ಆದೇಶದ ಮೇರೆಗೆ ಆಯ್ಕೆ ಹೊಂದಿ ದಿನಾಂಕ 1/4/2 ನಂತರ ಅಥವಾ ದಿನಾಂಕ ನಂತರ ಸೇವೆಗೆ ಸೇರಿದ ಕಾರಣದಿಂದ ನೂತನ ಅಂಶದಾಯಿ ಕೊಡುಗೆ ಯೋಜನೆಯನ್ನು ವ್ಯಾಪ್ತಿಗೊಳಿಸುವ ಸರ್ಕಾರ ನೌಕರರು ಸರ್ಕಾರವು ಅವರ ಅಭಿಮತ ಮೇರೆಗೆ ಕೆಳಗೆ ತೋರಿಸುವ ಕೈಂಡ್ ಲುಕ್ ಎಟ್ 1, my lord. 1/4/2000 ಪೂರ್ವದಲ್ಲಿ ನೇಮಕಾತಿ ಅಧಿಸೂಚನೆ ಮೂಲಕ ಆಯ್ಕೆ ಹೊಂದಿ ಆ ದಿನಾಂಕದಂದು ಅಥವಾ ತದನಂತರ ರಾಜ್ಯ ಸರ್ಕಾರದ ಸೇವೆಗೆ ಸರ್ಕಾರಿ ನೌಕರರು ಹಿಂದಿನ ಡಿಫೈನ್ಡ್ ಯೋಜನೆ ಒಳಪಡಿಸಿದಲ್ಲಿ ತಮ್ಮ ಅಭಿಮತ ತೋರಿಸಬಹುದು. So, though the recruitment notification is prior, they were appointed in terms of recruitment notification issued prior to 1/4/2006, my lord. Though they joined subsequently, appointment orders have been issued subsequently, even they are entitled.
Yes.
That's what, my lord,
yes,
he pointed out.
Right. Para 7 of my statement of objection. Para 7. I read up.
Now, the orders of regularization are passed with effect from when they complete 10 years.
10 years.
Which would be the date on which their entry into service is to be recognized.
Yes.
So from that date, they are deemed to have been a part of the notional extension of service benefit. Now, though for seniority promotion, it's a different matter, but such benefits will have to be extended if it is dates back to the date of when they completed 10 years. Because if you were to consider them early, they would have been appointed immediately there. So as long as they've completed 10 years before 2006, they're entitled. Para 7.
Para
Yes.
7. Okay, submitted petitions were given the benefit of Karnataka daily wage employees of 2012. And it is also true that these daily wage employees join the service after 1784. Hence, they are not eligible to the regularized according to the Umadevi case.
That is welfare
However,
scheme.
these, because they have not fulfilled the Umadevi case conditions, my lord.
ಅದೆಲ್ಲ ಹಳೆ ಕತೆ.
ಹಳೆ
After
ಕತೆ.
they regularize,
ಅದೇ.
there ends the matter.
They are regularized. us. But I have produced certain
However,
judgments.
these wages employees of Karnataka Veterinary Animal and Fisheries University Bidar who were given a benefit of Karnataka Daily Wages Employees Welfare Act 2012 in 24/7/14. Since they do not fulfill the conditions of regularization of daily wages employees as per the judgment of the Supreme Court in a civil appeal number 3595 and so on. So they cannot be regularized as per DPAR orders. It is submitted petitioner does not fulfill the condition of regularization of daily wage employees as per the judgment of Supreme Umadevi case per decision of 78th Board of Management of the University and the delegation of the powers given to the Vice Chancellor of Karnataka Veterinary
Yes.
Animal and Fisheries Science University. The petitions are regularized. However, this decision is taken without bringing to the notice of the state government and ex officio representative of the state government, the Principal Secretary, Department of Animal Husbandry and Fisheries, Principal Secretary to the Government Finance Department, the Principal Secretary to the Government Law Department were absent during the 78th meeting of the board management. Copy of the board meeting is produced herewith and marked annexure R4. It is submitted to the university has extended the benefit of OPS to those employees who were appointed before 1/10/84, whereas the petitioners and Mariswamy and two others have been appointed in the year 1987 and were regularized by the university dated 1/7/2017. Hence, both the cases are not similar. It is estimated that the university has time and again communicated to the petitioner that they were regularized and appointed under the NPS, which was not challenged by them while in service. Copy of this such communication is produced annexure R5. These two are the very important. I taken the decision. Without
petitioner-
our knowledge, the university has taken the decision.
If you were not present in the board, who is to blame?
So they were present in the board.
No.
The only defense taken is they were not present.
We
in
are
the-
not.
No, the representative board ಅಲ್ಲಿ ಇದ್ದೇ ಇರ್ತಾರೆ. They are the representative. Board
Any-
decision ಅಲ್ಲಿ.
Anyhow, the minutes are later approved by the government.
Yes.
Minutes are sent to
ಅಲ್ಲ ಅವ್ರು ಸರ್ ಈ ನೆಕ್ಸ್ಟ್ ಅವ್ರ ರೆಪ್ರೆಸೆಂಟ್ ಇದ್ದೇ ಇರ್ತಾರೆ ಬೋರ್ಡ್ ಅಲ್ಲಿ ಇಲ್ಲದೆ ಬರೋದೇ ಇಲ್ಲ. But I have produced judgments also, Manoj.
Let us see now.
Yes, yes.
The petitioner has petitioners who are employees of the second respondent. Employees of the second respondent.
Yes, yes, Manoj. Yes.
Employees of the second
Yes,
respondent.
Manoj.
Having
Employees-
attained,
Employees of my lord, yes, second respond.
having attained superannuation, have filed the present petition seeking for writ in the nature of mandamus to direct the respondents to settle back wages and other consequential benefits to the petitioners in terms of appointment order dated 1/7/2017 at annexure A, comma. Petitioners have also sought for issuance of appropriate writ in the nature of mandamus. As regards, petitioners have also sought for appropriate writ to declare that the petitioners are entitled to benefits under the old pension scheme in terms of the government order dated 31/3/2006. Full stop. Petitioners also sought for washing of the communication dated 19/12/2023 issued by the state, as well as sought for setting aside of the endorsement at annexure C, whereby claim of the petitioners for old pension scheme has been rejected. Full stop. It is the case of the petitioners that they were initially working on daily wage basis
Yes.
and were subsequently regularized as per order dated 1/7/2017 at Annexure A. And in terms of such order, the petitioners were directed to be regularized from the date mentioned in the said order, which dates were prior to 1/4/2006. And accordingly, it is submitted that petitioners are entitled for benefit of the old pension scheme. Reliance is attention is drawn to the proceedings of Government of Karnataka dated 31st March 2006, wherein there is a reference that the new system would be applicable to new entrants to central government joining government service on or after 1/1/2004. Further, in the same proceedings, it is resolved that the new defined contributory pension scheme shall be mandatory to all new recruits to the state government service joining on or after 1/4/2006. Thus, it is pointed out that in terms of the proceedings, the applicability of the new pension scheme is only for new entrants after
New recruits, man.
1/4/2006.
New recruits.
New recruits after 1/4/2006. It is submitted that in light of the order of regularization dating back to the date on which they had completed 10 years, all of which dates were prior to the cutoff date of 1/4/2006, petitioners are entitled for benefits under the old pension scheme and cannot be equated to new recruits. Further submitted that the order of regularization cannot be reinterpreted as clearly the order of regularization dates back their service benefits from the date of they having completed 10 years of service as enumerated in column 4 of the order of regularization. Full stop. That apart, learned senior counsel appearing for the petitioners makes out a ground of parity and submits that many of the employees who had started working after 1/10/84 as well, 1/7/84 as well, were extended with the benefit of old pension scheme and relies on various documents to such effect and submits that there cannot be discrimination of similarly placed persons. Full stop. Attention is also drawn to the recommendation of the university at Annexure
Annexure, my lord, Annexure W.
H.
H and W, my lord.
At Annexure H and
W.
H and W, wherein the university itself, which is the appointing authority, had recommended for extension of old pension scheme to persons such as the petitioners.
Yes.
Full stop. The counsel for the university submits that the correspondences made by the university to the government are part of record and leaves it to the court to take an appropriate decision in terms of their correspondences addressed to the government. At Annexure
B,
H.
H.
at Annexure H. Third, AGA appearing for the respondents has places reliance on the statement of objection and contentions raised are one, that the petitioners were not eligible to be regularized as their joint service after 1/7/84, comma, 2, that that in the 78th meeting of the Board of Management, the ex officio representative were absent and were unaware of the decision taken, 3, that the university had only extended benefits of OPS to those employees who were appointed before 1/10/84. Next. Third, both sides. It must be noticed that admittedly, the order of regularization at Annexure A passed on 1/7/2017, which includes order of regularization as regards the petitioners, has been passed with a specific observation within inverted comma. Sadri Naukararu Huddeya pencil Arharagiruttare, full stop. Clearly, it is evident that the petitioners were entitled for benefits from the date on which they were regularized. Full stop. The table extracted in the order of regularization at Annexure A at column 4 mentions the date of regularization. Insofar as petitioner number 1, whose name is found at serial number 6, the date on which he is regularized is 20/2/1997, 20th February 1997. Petitioner number 2 has been regularized with effect from 1/1/1998. And petitioner number 3 has been regularized with effect from 1/8/1998. Unequivocally, the order of regularization would indicate that the orders regularizing their services would date back to 97 and 98. Perusal of the new pension perusal of the government order at Annexure K relating to adoption of new pension scheme would make it clear in the operative portion at point number 1 that the new defined contributory pension scheme would be applicable to all new recruits of the state government joining after 1/4/2006. Full stop. Point number 1 of the said order is extracted as below, page 43. Next, in light of the same, it cannot be stated that the petitioners were new recruits who had joined service after 1/4/2006. If the date of regularization has conferred service benefits with effect from the year 97 and 98, such conferment of benefit with retrospective effect cannot be defeated by any stand of the government contrary to the order of regularization. Further, it is also not to be treated to be a retrospective benefit conferred, but a benefit with effect from completion of 10 years from when the petitioners have joined. And that is the nature of orders passed while regularizing temporary daily wage workers. If that were to be so, petitioners are entitled for benefit from the year 1997 and 1998. Next. Insofar as contention regarding equity is concerned, it is seen that in terms of Annexure R, employee Shri Narsimurthy, who was regularized with effect from 1/1/97.
Yes.
has
And-
been,
And my lord, order is on 12/9/13. 12/9/13 order.
who has been regularized with effect from 1/1/1997. With the order of regularization on 12/9/2013 has been conferred benefit under the old pension scheme. Full stop. This fact is not controverted by the state and is made clear by the payslip at page 62. Full stop.
Annexure, yes, ma'am.
Insofar as the other employees were similarly placed as the petitioners, in the case of one Chandrappa, who again has been regularized with effect from 1/9/2000, has also been conferred with such benefit. Full stop. There are other cases as well, as is made out from annexure V, isn't it?
T, my lord.
V,
T. Page number 67.
at annexure T
These people have been
Of,
appointed after 84.
of annexure T of employees
Gauri Shetty.
who have been regularized with effect from 29/11/97, 27/2002, and 16/96 have also been extended,
But having joined after 17.
have been extended benefit of old pension scheme, as is evident from annexure V.
As they were, my lord, they were appointed 17.
Correct, V.
Yes.
It is to be noticed that such of the employees, it is asserted, had joined service after 1784, and orders of regularization were passed when they completed 10 years. And in light of the same, in light of such contention which remains uncontroverted, the contention of the state that university had extended old pension scheme benefits only for those who had joined service before 1/7/1984 cannot be accepted. Next, it must also be noticed that the question of validity of regularization is a question that cannot be reopened at this point of time. The order at annexure A is passed on 1/7/2017. It does not lie in the, it does not lie, it's not permissible for the government at this stage to state that the petitioners were not entitled for regularization, which is a closed issue. Full stop. The other contention taken by the state is that these employees have joined service after 1/4/2006. Full stop. Needless to state, the order of regularization at annexure A referred to above is clear that all benefits have been conferred from the date of regularization in 97 and 98. Obviously, such of the employees whose services were regularized would date back to the completion of 10 years in 97 and 98, and accordingly cannot by any stretch of imagination be construed to be new recruits. Full stop. In light of the above discussion, the order at the communication of the government first respondent at annexure B and the endorsement. What is this C?
C is
set
by
aside.
university, by the university.
B is set aside. The endorsement at annexure C,
Consequential, man.
which is consequential to the direction of the government at annexure B, requires to be set aside. And the respondent number, now who's to?
That is, my lord, that is, my lord, university and the government both.
Only
Both.
university has.
Huh?
Government has to give approval. We had sought financial approval by annexure H. That was turned down. Now
In
government
light,
has to-
in light of setting aside of annexure B as well as C, the proposal of the university at annexure H
H.
is required to be considered by the government. and necessary orders passed within a period of 3 months from today. In light of the observation and discussion made above, while making it clear, no fresh contention is permissible to be adverted to defeat the claims of the petitioners as the state, as the objections by the state as contained in the statement of objections have been dealt with.
May I request? Page number 17 approval agide government in
Page
17 serial number 9. Serial number 9 man. In the Ulleka. Hanakas Nyandan Adhikaran Sahamati. They approved it. Now they say it's not approved. Regularization ago approve agide.
that is okay.
That they say approval agilla government.
One sentence admin. The further contention of the state in the statement of objection regarding the validity of order of regularization is impermissible and the state is stopped once as per approval granted by the financial controller on 29/6/2017. State cannot now take up a contention that the regularization isn't done.
Prayer A, man. Prayer A. They have to consider it, man. I'm only saying let them consider it.
Prayer
A, man.
Regarding back wages.
Consequential benefits, not only back wages.
regarding
Consequential benefits flowing out of the order of appointment. ಮೂಲ ವೇತನದಿಂದ ಅಂತ ಹೇಳ್ತಾರೆ. So, my lord, all let them consider my representation.
so far as contention of the petitioner that back wages and other benefits as would flow from the order of 1/7/2017 at annexure A has not been extended to the petitioners. Petitioners at liberty to make a fresh representation and for the respondents to consider the same appropriately. Accordingly, petitions are disposed of. That annexure A, you can send a soft copy to the registrar. You can copy paste the table.
Please.
You send a soft copy. Yes.
Say number 15, Shilparani.
Oblige.
This is the daily wages matter. Initially, the writ petition has been filed.
May I make a submission before senior starts? This was actually linked with the other matters and posted after vacation. Then I think sir mentioned it got a dealing because those were cases, my lords, arising out of fresh causes of action. This was a matter, my lords, where earlier there were, I think, 1 or 2 rounds of litigation. My lords, we had mentioned that this matter relates to 1984 to 1990 batch of daily wages. 84 to 1990. Before 1784, my lords, we have regularized in terms of the 1990 government order. Then, my lords, in the meantime, there were 2 orders, my lords, of a coordinate bench pertaining to the same batch. One is, my lords, that they are relying upon of Justice B.M. Shamprasad, and another is of Sanjay Gowda, Justice Sanjay Gowda. Lords, in respect of both the matters, as on date, writ appeals are in the process of being filed. But in the meantime, my lords, I was able to lay my hands. Kalburgi bench, single judge, my lords, in respect of the same batch, writ petition was allowed. Thereafter, my lords, contempts were filed. We had filed writ appeals, my lords. In the writ appeals, my lords, in respect of the same batch, matter has been admitted and stay has been granted, my lords. So therefore, my lords, my respectful submission is if it could be deferred after vacation, we would.
Correct, but they were making a submission that between the petitioners and the respondents, matters already attained finality without reference to those 2 orders.
No, it is not so, my lords. What happens is this: in respect of matters, my lords, of the coordinate bench, matters pertain to horticulture department and sericulture department, where, my lords, we are yet to file writ appeals. But in respect of rural development, RDPR, which is the case in here, A matter in Kalburgi, my lords, RDPR similarly situated employees case was considered. Writ petition was allowed. In the writ appeal, we have a stay, my lords.
Okay, but is this not a subsequent round?
No, this is a case, my lords, earlier rounds were before Uma Devi and immediately subsequent to Uma Devi.
Let us see, Ali. If
Please.
it comes to that, then we'll decide.
Please.
You just give the copy of the writ appeal.
My lords, I have the order copy, my lords.
Let us see. But without reference to that, the case is can be made out.
Yes, my lord.
Without reference to the orders of the coordinate bench.
Without reference to any other orders, which are now as my learned friend has made a statement before your lordship. And we filed a writ petition. The writ petitions have been allowed. The writ appeals were filed by the government was also dismissed. The essay, then my lord, we filed a contempt petition. And they as against the contempt order, they preferred a writ appeal, SLP before the Supreme Court. The SLP, my lord, if your lordships kindly take 148.
Yes.
We direct that in the light of para 53 of the decision of this court in case of State of Karnataka and others, Uma Devi, 2006, 1 SCC, 4 SCC, page 1. And in case of these respondents, we have already completed more than 22 years of service, shall be individually examined by the authorities concerned. We hope and trust that the authorities will look into the individual cases and examine their continuation in the services in terms of the scheme or other provisions of law on the subject available in the state. The authority shall also take into consideration the law laid down by this court in case of electricity production. However, till the individual cases are not scrutinized by the authority, these respondents, incumbents will be allowed to continue in the services. Now, my lord, these two schemes which has been referred to by the Honorable Supreme Court.
Now the parties before the apex court,
We are parties.
you are the
Yes,
respondents.
we are parties. MN Venkatesh for MT Venkatesh versus State of Karnataka. We are parties.
Yes.
We are very firm.
Huh?
There is some dispute on that because this is a general order that is being cited everywhere, stating that in terms of this,
But when I am saying that I appeared
let them-
not only before the single bench, division bench and the SLP, my learned friend should at least trust me to that extent. And in a contempt also.
Yes.
And unfortunately, we did not, my lord, put the full cast title, but the writ appeals filed by them.
Anyhow, that is the point that could be sorted out.
That
Yes.
can be clarified, there is no problem.
Yes.
Now, my lord, the two schemes which my lord referred to by the Honorable Supreme Court, if your lordships kindly take page 89, sorry, page 85.
Annexure,
My lord, page 85 ink page, annexure E, my lords. That is the first judgment,
yes.
paragraph 22. In the result, these writ petitions succeed and hereby allowed, but only to the following extent. The respondent shall consider the cases of such other petitioners who are working against the sanctioned post for regularization, subject to the condition that they are served for a period of 10 years continuously. The government may, within a period of 1 year from the date of the order, constitute service for the Jilla Parishad in terms of 96(5) the Karnataka Panchayat Raj. In case the services are concerned, the cadre strength is determined, qualification and method of recruitment prescribed, such as the petitioner do not fall under one on account of the absence of a sanctioned regular vacancy, shall be considered for absorption against the vacancies becoming available upon constitution of the service in accordance with the relevant recruitment rules, subject to their being eligible for such consideration and appointment. The petitioner in that case shall be entitled for relaxation of the age, bar to the extent of their service as daily rated employee. In case, however, the government does not in terms of to a consult service, or the process which it initiate is not concluded within a time, the petitioner shall be considered for regularization in terms of the conditions stipulated by the government order pursuant to the direction of the Supreme Court in Dharwad case so and so, subject to the condition that they are put in continuous service on full-time basis for over 10 years from the date of their appointment till the date of this order. Conditions stipulated in the government order issued for implementation of the scheme in Dharwad case shall to the extent stand modified. The process of absorption of the petitioner shall be completed by 31/12/2000. But this judgment was challenged in the writ appeal. If your lordships kindly take the page 89, page 88 SLP was turned down. If your lordships kindly take page 89, this is the judgment dated 10/9/99. Writ appeal was dismissed on 23/1/2001. The writ appeal on 5/11/2001. Then we filed a contempt. In the contempt they implemented. Now, my lords, this is the scheme dated 19/7/2002. Page 90, my lord. ದಿನಾಂಕ 1/7/84 ನಂತರ ನೇಮಗೊಂಡ ದಿಲಗೂಲಿ ನೌಕರ ಸಕ್ರಮಗೊಳಿಸಲು ನಿಯಮಗಳಲ್ಲಿ ಅವಕಾಶವಿಲ್ಲದರಿಂದ ಸರ್ಕಾರವು ಈ ಬಗ್ಗೆ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟ್ ಅಪೀಲ್ ನಂಬರ್ ಸದರಿ ರಿಟ್ ಅಪೀಲ್ ಅಲ್ಲಿ ನೀಡಿದ್ದ ತೀರ್ಪು ಈ ಕೆಳಕಂಡಿರುತ್ತದೆ. We are entirely in agreement with the order passed by Learned Single Judge. The very fact that the respondents have worked for 10 years can show us the need is permanent. The claim for regularization of their service has to be considered after framing the issue. Their Learned Single Judge rightly. ಮೇಲೆ ತಿಳಿಸಿರುವಂತೆ ಕರ್ನಾಟಕ ಉಚ್ಚ ನ್ಯಾಯಾಲಯ ರಿಟ್ ಮತ್ತು ರಿಟ್ ಅಪೀಲುಗಳು ನೀಡಿರುವ ತೀರ್ಪು ಅನುಗುಣವಾಗಿದ್ದರಿಂದ ಆದೇಶವಿರದ ಸರ್ಕಾರ ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ SLP ನಂಬರ್ ಸೋನ್ಸು ಸರ್ವೋಚ್ಚ ನ್ಯಾಯಾಲಯ ಮೇಲೆ ಓದಲಾದ ದಿನಾಂಕ 5/11 ತೀರ್ಪು ನೀಡಿ SLPಯನ್ನು ವಜಾಗೊಳಿಸಿದೆ. ಈ ಮಧ್ಯೆ ರಿಟ್ ಅಪೀಲಿನ ಕೆಲವು ಅರ್ಜಿದಾರರು ಕರ್ನಾಟಕ ದೆನ್ ಮೇಲೆ ಕಂಟೆಂಪ್ಟ್ ಇಸ್ ಫೈಲ್ ಕೈಂಡ್ಲಿ ಕಮ್ ಟು ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ 19. ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸುವ ಕಾರಣಗಳ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಬೆಂಗಳೂರು ಗ್ರಾಮಾಂತರ ಮತ್ತು ಕೋಲಾರ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಗಳಲ್ಲಿ ಹಾಗೂ ಇತರ ಇಲಾಖೆಗಳಲ್ಲಿ ದಿನಗೂಲಿ ಆಧಾರದ ಮೇಲೆ ನೇಮಕಗೊಂಡಿರುವ ಈ ಆದೇಶಕ್ಕೆ ಲಗತ್ತಿಸಿರುವ ದಿನಾಂಕ 2ರಲ್ಲಿ ನಮ್ಮ ದಿನಗೂಲಿ ನೌಕರ ಅನುಬಂಧ ನಿಗದಿಪಡಿಸಿ ಷರತ್ತುಗೊಳಪಟ್ಟು ಮಾಸಿಕ ವೇತನ ಸಿಬ್ಬಂದಿಯಡಿ ವಿಲೀನಗೊಳಿಸಲು ಸದರಿ ನೌಕರ 10 ವರ್ಷ ಸೇವೆ ಪೂರೈಸಿದ ನಂತರ ಅವರ ಸೇವೆಯನ್ನು ಸಕ್ರಮಗೊಳಿಸಲು ಸರ್ಕಾರ ಆದೇಶಿಸಿದೆ. ಸದರಿ ನೌಕರರು ಕರ್ತವ್ಯ ನಿರ್ವಹಿಸುತ್ತಿರುವ ಇಲಾಖೆ ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಖಾಲಿ ಇರುವ ಹುದ್ದೆಗಳಲ್ಲಿ ಹಾಗೂ ಖಾಲಿ ಇರುವ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಹುದ್ದೆಗಳಲ್ಲಿ ಅವರನ್ನು ಅನುಬಂಧ 1ರಲ್ಲಿ ನಿಗದಿಪಡಿಸುವ ಷರತ್ತುಗೊಂಡು ಸಕ್ರಮಗೊಳಿಸತಕ್ಕದ್ದು. ಅವರುಗಳ ಸೇವೆಯನ್ನು ಸಕ್ರಮಗೊಳಿಸುವ ಆದೇಶ ಹೊರಡಿಸಲು ನೇಮಕಾತಿ ಪ್ರಾರಂಭ. ಈ ಆದೇಶವು ದಿನಗೂಲಿ ನೌಕರ ಮಾತ್ರ ಸಂಬಂಧಿಸಿದ ಜಿಲ್ಲಾ ಪಂಚಾಯತಿಗಳು ಹಾಗೂ ಇಲಾಖೆಗಳು ಸಾಧ್ಯವಾದಷ್ಟು ಮಟ್ಟಿಗೆ ಮಂಜೂರಾದ ಖಾಲಿ ಹುದ್ದೆಗಳೆದ್ದರೂ ಮಾತ್ರ ಸಕ್ರಮಗೊಳಿಸಲು ಕ್ರಮ ಕೈಗೊಳ್ಳತಕ್ಕದ್ದು. ಅನಿವಾರ್ಯವಾದಲ್ಲಿ ಮಾತ್ರ ಸೂಪರ್ ನ್ಯೂಮರಿ ಹುದ್ದೆಗಳನ್ನು ತ್ಯಜಿಸಲು ಗ್ರಾಮೀಣಾಭಿವೃದ್ಧಿ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ಇಲಾಖೆಗೆ ಸೂಕ್ತ. ಈ ಆದೇಶಗಳು ನಾವು
this scheme is framed pursuant to proceedings by other employees of the same department. Yes.
Now various departments, agriculture, rural development, panchayat raj. Now the government order says that this also applies to all other departments also. Now, if there is a sanction, now my lord, the direction was initially if there is a sanction vacancy, they should be regularized. If there are no sanction vacancy, the state should constitute a service, determine the cadre strength and the qualification upon identifying the number of the vacant posts based on the creation of the cadre strength, direction number 2 has to be worked out. Direction number 2. Direction number 3, if you don't do it within 1 year, then the scheme of the Dharwad shall be made applicable. This is on a default, my lord. Writ appeal is filed, writ appeal. Now, my lord, this is the first judgment. Then the other learned single judge, my lord, has followed. Kindly take, my lords, my learned friend was making a submission, page 92. After 1784. Those who are appointed after, all these people are after 1784. Then this judgment, my lord, was applied in case of a next batch of cases. Then, my lords, may I take, my lord, page 101. Totally 473 cases, 499 in this case. Then the learned single judge, my lord, applied 108. Both sides would agree that the issues raised and the relief sought for in these petitions are identical. With the issues raised and considered by this court in dated 10/9/99, following the observation made in the aforesaid, these petitions are also disposed of the same terms, observation, condition, directions. Now, my lord, the appeal filed as against this, it was rejected. Your lordships gets it at page 112. By applying the Dharwad case, and again, my lords, the first judgment, 23/1/2001, this is on 24/1. My lord, this, what happened? As again, first judgment, my lord, was implemented. As against this, the matter was again taken up to the Supreme Court. The matter was heard by 2 judges, referred to 3 judges. Then the matter has been referred to the 5 judges. And the day when the Uma Devi was reserved for order, may I take your lordship's minute, the matter was heard. Page 119. But so far as our petitions are concerned, page 118. Raju Ramchandran, learned counsel so-and-so, argued at so-and-so. MC Bandari, then Ashok Kumar Sharma, Baso Prabhu Patil made his submission for 15 minutes. That is Malad who appeared for government. The learned counsel commences his argument, concluded at 3:50. Thereafter, Kiran so-and-so. Then right side, the special petitions are barred by time. There is an erroneous delay of 451 days in preparing the petition, which in our opinion is not satisfactory explained. The prayer made for condonation of delay is refused, and the special petitions are dismissed as barred by time. But this is on 19/7/2005 minutes. This is an order passed on 19/7. Your lordship gets at page 119, bottom.
Yes.
Malad, this SLP, the same day, the judgment of Uma Devi was reserved for orders. Now the appeals have been dismissed. Now, Malad, this judgment has been implemented, page 120, by framing a scheme 29/12/2005. 29/12/2005.
So this appeal was by the state, is it?
Yes, my lord.
This appeal was filed against which order?
As against the His Lordship Justice Dattu J. order, my lord. So far as the judgment delivered by Justice Thakur J. 10/9/99 was affirmed by the Supreme Court on 5/11/2001, then 19/7/2002, the scheme has been implemented. The second batch of cases are Nagaraj and others, 499 in number. And the single judge allowed the petition. Writ appeals were dismissed. Then the matter went to the Supreme Court. The 5 judges have turned down the appeal filed by the government. Now, my lord, based on this, 29/12/2005, page 121, these are the 2 schemes which the Supreme Court referred to, my lords. 29/12/2005. Now, for a moment, my lords, the same, my lord, they whatever 19/7/2005, except the writ petition number, they put the same conditions.
You're
If you're-
saying, you're saying in terms of this scheme, their case must be
1
considered.
minute. Out of 499, except 74 were implemented as on 10/4/2006.
It was implemented as regards,
As regards the cases covered under the second case, Nagaraj and other.
how many?
First is Raghupati Gowda, 499, 74 was not implemented.
This is the employees of other department or including this?
All other departments, many departments.
Yes.
Now, my lords, if your lordships kindly come to page 150, 150. When Uma Devi was rendered on 10/4/2006, 73 people contempts were pending. Now, this is an order passed by this court referring to, my lords, this 10th of September 99 and 15/12/99, and ultimately, my lord, there is a direction that page 156, paragraph 9. Page 156. We are not satisfied with the endorsements issued by the state government. It is not in compliance with the order passed by this court. Now, my lord, the endorsement is 4 conditions, ಮಾಮೂಲಿ. ನೀವು regular postal appoint ಆಗಿಲ್ಲ. You are continued by virtue of an interim order that has been granted in case of association. And you are not completed 10 years of service. So many 4 conditions, ಮಾಮೂಲಿ. This endorsement was not accepted, and we feel it necessary to give one more opportunity to state and officers to comply by this court. Accordingly, we grant 2 weeks term to comply with the order passed by this court, failing which the case stands posted to framing the charges against the respondent. Not as against this, the appeals have been filed by the respondent, that is Malati Das case. This is how, my lord, Malati Das case, in paragraph 13, the argument before the apex court was by the government in Malati Das case, 7/3/2014, stating that in view of Uma Devi case, you directed not to regularize. We are under a misconception. Please clarify. Then the apex court said, since you have regularized many other people after Uma Devi on the principle of parity, we issued a direction to regularize them within 2 months from the date of the receipt of the order. Now, my lord, this is a position. So far as the present appeal are concerned, the petitioners are concerned, they filed a petition, my lord, the content petition, and the Supreme Court initially granted the stay order. And when the stay was, if your lordships kindly take page 131. The division bench said, 17th of February 2006. The content proceedings were dropped because the Supreme Court granted the stay order. This stay order SLP came to be disposed of on 25/2/2008, that is page 147. 148, which I read to your lordships. So the Supreme Court kept in mind 19/7/2002, 29/12/2005, two scheme plus Uma Devi's case. Individually, you will have to examine the case. Then we have pleaded before your lordships. Malti Das case, I will just read out only one paragraph. Page 214.
Now, just before, now if it is so that 148 order
Please, my lords.
is at the instance of the petitioners,
Please.
now the endorsement has to be tested in terms of the directions by the apex court
Two schemes.
without entering into any other question.
My lords, what happened was
Page 1, correct.
147.
So they're saying
Please, my lords.
that this was the final order passed against the contempt order before the High Court in which their parties.
My lords, if my
This
lords,
order,
147.
huh,
147, may I kindly see the cost title minutes? Petition for special leave, so and so, State of Karnataka versus MT Venkatesh. Now, kindly see, my lords, what the court has said. This is, kindly note the date of this order. It is on 25/2/2008.
We are the respondent before the apex court. I'll make available the cast title of the
No, no,
SL.
I'm not disputing that. Date may kindly be noted.
yes.
Lords, there have been orders pre-Uma Devi and post-Uma Devi. What happened was, if their petitions were pending before the Supreme Court, and in the meantime, my lords, Uma Devi's judgment was pronounced. After Uma Devi's judgments, directions that were issued by the Supreme Court were in a different manner. Now kindly see, this is dated 25/2/2008. Now kindly see the order, my lords, order portion.
No, when was Uma Devi pronounced?
10/4/2006.
10/4/2006.
Whatever it is,
Please.
finally, this, if this is the order passed inter
No, Supreme Court has said follow Uma Devi. That's what Supreme Court has said. Kindly see the next page, 148. May I read, my lords?
Yes,
Delay condoned, heard learned counsel for the parties. We direct that in the light of para 53 of the decision of the court in the state of Karnataka versus Uma Devi, the case of these respondents who have already completed more than 22 years of service shall be individually examined by the authorities concerned. We hope and trust that the authorities will look into the individual cases and examine their continuation in terms in service in terms of the schemes or other provisions of the law on the subject of, kindly note this, schemes or other provisions of law on the subject available in the state. The authority shall also take into consideration the law laid down by this court in the case of UP State Electricity Board versus Purnachandra Pandey. However, till the individual cases are not scrutinized by the authorities, these respondents incumbent shall be allowed to continue in service. Just, my lords, this Purnachandra Pandey was held to be per incuriam, my lords, in a subsequent judgment in official liquidators versus Dayanand immediately in 2008 itself. That is one thing. But nonetheless, my lords, it's the first
But
portion.
this judgment
one
must have been overruled in other cases.
No,
But
I just complete.
The order, let me tell, don't create confusion.
No, I'm not
If
creating
no,
confusion.
if an
They
order
are
is
trying to
passed,
take an order by creating
if that
confusion.
judgment is overruled by a larger bench, my lord, what is overruled is only principle, but not the binding decision between the two parties. There is no steps taken so far as the incorporation of the Supreme Court judgment in this order.
My lords, what the court has said is, in the light of para 53 of the decision of the Supreme Court. So therefore, ultimately, my lords, what Supreme Court said is, dehors what has happened in this matter, in view of now a constitution bench judgment of the Supreme Court in Uma Devi's case, para 53 is there, and whatever scheme you frame and other provisions of the law, you go as per that. So therefore, after Uma Devi, my lords, we have framed our 2006 scheme, the four conditions. So in terms of that, they have to come. They cannot go back now, because if they are relying upon Raghupati Gowda's judgment and Nagaraj's judgment, the 2002, my lords, and 2005 schemes, may I just also point out that those schemes attained finality, my lords, in the Supreme Court. Those orders attained finality in the Supreme Court. 2 SLPs were there. The state lost those 2 SLPs. We framed a scheme, my lords, to implement that because there were contempt petitions pending. On the basis of that, my lords, 2 schemes, persons were regularized. This is across departments. My lords may kindly note, this is across department. It is not one department. The petitioners, my lords, were sometimes belonging to different departments. One common petition was filed or club matters were there. Now, in pursuance of those two schemes, maybe similarly situated persons to them were regularized. No doubt about that. But at the same time, there was one other parallel litigation that was going on, my lords, where writ petitions were allowed against the state. Writ appeals were in favor of the state, where court said there is no right of regularization. So pre-Uma Devi, there were two set of judgments. One writ appeal orders, which were in favor of the employees, another writ appeal orders, which were in favor of the state. The association, my lords, which had filed those petitions, Association of Daily Wage Employers, then took up the matter before in SLP. In SLP, my lords, that was tagged along with, considered in Uma Devi's case, and law was laid down. Ultimately, my lords, before Uma Devi's case, whatever orders or judgments have attained finality inter partes, that is Raghupati Gowda's case and Nataraju's case, they were implemented. Incidentally, in Nataraju's case, my lords, 2005, when the order was passed, before Uma Devi was pronounced, we had regularized some people. After that, around other people were not regularized. So we, in view of the, my lords, the Constitution Bench judgment, we said maybe now we are not, we don't need to implement that. Then, my lords, contempts were filed. Finally, Supreme Court in Malti Das case said, see, this had attained finality prior to that. Please implement this. This Honorable Court had directed us to file an affidavit. Kindly see that affidavit, my lords, where we have narrated all this. My lords, affidavit dated 19/4/2021. Now, my lords, what happened was in the coordinate bench, this order also was cited. The order thereafter, my lords, we have considered in terms of our scheme, my lords, and we have rejected their cases because the continuation of persons in the 1984 to 1990 batch was in terms of interim orders is what is our case. Because initially, my lords, there was an interim order. I'll just pass on the 1990 government order, which will just throw light on this matter. This was the government order in terms of Dharwad PWD case.
Now there's another point.
Please, my lords.
Rightly or wrongly,
Please, my lords.
coordinate bench has taken a view.
No, my lords, what coordinate bench?
Considering
please,
all contentions that you have raised.
Please, my lords, all these contentions were urged. I will just be fair to the court also and to the other side also. My lords, the very argument that I'm advancing right now, my lords, I had advanced it. And my lords, court has actually said that if I had stated that in view of the change in law and it being a judgment of the constitutional bench of the Supreme Court, which where there were attempts to water it down, and subsequently, my lords, benches have also said, but my lords, equally so, if we check the jurisprudence, my lords, post Uma Devi, there have been, I'll get 50 judgments in favor of regularization, around 50 judgments against us. It's like 50-50, even of the Supreme Court and of the high courts also. We have judgments both ways. It is not that it has been in favor of the petitioners or it has been in favor of the state. And the fact that they were continued even more than 10 years, even after Uma Devi, also matters. But here in this case, my lords, we have brought them all under the provisions of the Daily Wages 2013 legislation and allowed them to superannuate, or some have superannuated or on the verge of superannuation, because they were all appointed before 1980. Lords, when I advance this argument, my lords, before a coordinate bench, in fact, the coordinate bench has gone to the extent of saying that if they were similarly situated to Raghupati Gowda and Nataraju's scheme itself, they're entitled to regularization. So that is what we are taking up in appeal. So if my lords were to just follow the operative portion and says it is covered by, then what will happen is, if I take it in writ appeal, I succeed, this also will file a writ appeal and it will go. But if they want to argue and try to get a different finding, no. I wanted to make a submission.
I don't intend to reopen it at this point of time.
Please.
In light of the orders of the coordinate bench, same treatment to the petitioners also.
But I just wanted to bring to my lord's notice, because my lords had deferred the other cases, my lords, post vacation. Only this case senior mentioned because of the, there has been a history of litigation in this. My lords were pleased to, my lords, take it before vacation. But incidentally, my lords, in respect of the same matter, there is an order, my lords, passed by the Kalburgi bench in respect of the same 1984 to 90 batch, similarly situated, very same department. There is a stay, my lords, by the division bench in that matter. Here we are yet to file writ appeals. There is a stay, my lords, by the division bench.
Employees of
Rural Development and Panchayat Raj. The petitioners, my lords, are all same department. But the orders that were passed by a coordinate bench, my lords, here pertain to sericulture and horticulture department. So I would request, my lords, one
you place that on record.
I just passed it on.
No, where the order of the single judge?
That I'll place it, my lords. I just passed on that order. My lords may kindly admit, list this petition for final hearing. In the meantime, the operation of the impugned order passed by the learned single judge is stayed. That was also a third round of litigation.
But let us have a look at the single judge's order.
Please, my lords. I'll get it tomorrow. My lords.
I'll relist it tomorrow.
Tomorrow, please.
List the matter in the same stage tomorrow.
If the, my lords, if finally after seeing that, if the court feels that the other coordinate bench judgment could be followed, my lords, I'll leave it to the court.
My lord, coordinate bench took note of this page 148 apex court order
No doubt.
and passed an order. The intent of the two schemes shall be made applicable to them. We are also asking for the same relief.
It is.
In fact, I just made out a list, my lords. Of course, I mentioned it about the only case numbers. What do you call it? This is Malati Dath case, my lord, 73. All these cases have been implemented. And some of the government orders also I just mentioned.
Let us see. Tomorrow.
Please.
I think, my lord, last time I made a mention about the latest judgments, 22/7/2024. Court officer, interim, 41. If a temporary employees, whether on casual or daily wages, working, my lords, discharging the duties of a permanent employee, then the regularization has been granted.
But all matters have to be consolidated. Time and again, I've been voicing the opinion.
But why I insist that
Not with respect to any case, sir,
Please, my lords.
but either in veterinary university, where
Please.
some people file in Kalburgi, some people file in Dharwad.
Please.
It has to be consolidated, and the only person who can do it is the state.
Will.
So there's uniform.
There is uniform. Either
Either-
everybody gets it or nobody gets it.
Huh.
Otherwise, there could be heartburn also.
So
That,
in one case of the veterinary university,
Please.
some employees lower down in the seniority list have got orders to be regularized.
Please.
What happens to the others who are waiting in the queue? Isn't it? Whether they come to court or not, latest judgment of Supreme Court, what benefit to one should go to all similarly placed.
Please.
So who are that's why the scheme, why was the scheme directed to be framed? So even without them coming to court, the government must suo moto take note of those who are working and prepare a consolidated seniority list in all of the departments and then see what the law is and see what is to be done.
Please.
Without waiting for people to
Please.
come to
Keep
court.
litigating.
my lord, His Lordship Chief Justice Chandrachud J. my lord, then 2019 4 SCC 290, para 24. If juniors are, the regularization has to be granted. That is reiterating Beliappa versus State of Karnataka, 79 Supreme Court.
No, larger view may have to be taken because what the cutoff date was fixed
Please.
of 984
Please.
by change of by length of time
Please, ma'am.
has lost its significance by virtue of continuance of many of them, even without orders in many cases.
In fact, this is what
For 20, 30 years, you have,
No, my lords.
so you must frame some scheme and see what is to be done.
It's from
that in
1990.
Premakala Shetty's case, Justice Ravindra J. said, no doubt the cutoff date has been prescribed, but these people have put in 10 years of service. And once they complete 10 years, It is not the cutoff date, it is the 10 years. That Premakala Shetty was challenged by the government in writ appeal. That came to be dismissed, SLPs are also dismissed. Again, Premakala Shetty's case has been applied in University of Agriculture Science by the same bench. There are 10 judgments of the division bench where it said cutoff date will not come in the way once an employee puts in 10 years of service. This is a old song, my lords.
Let us, yes, tomorrow.
But I am just passing on, my lord. 2021 also there is a pass, an order.
You make
Same scheme.
make a thing of at least consolidate.
Please.
Appoint a
Sir.
special officer
Please.
and get all matters
Let's-
consolidated. So
We had-
let it be heard.
We had some writ appeals pending in respect of the university's regularization matters.
ಅಲ್ಲಿ ಏನಾಗುತ್ತೆ ಗುಲ್ಬರ್ಗದಲ್ಲಿ ಹೋಗ್ತಾರೆ
ಹಾ.
ಧಾರವಾಡದಲ್ಲಿ ಹೋಗ್ತಾರೆ ಪಾಪ ಅವ್ರಿಗೆ ಬ್ಯಾಕ್ ಗ್ರೌಂಡ್ ಏನು ಗೊತ್ತಿರಲ್ಲ ಒಂದು ಅಡ್ಮಿಟ್ ಮಾಡಿ ಸ್ಟೇ ಕೊಡ್ತಾರೆ.
Just look into it.
Please.
Yes, next.
2020 ನಲ್ಲಿ ನಾವು ರಿಟ್ ಹಾಕಿದ್ವಿ 24 years ಆಗಿದೆ. That is how, my lord, I appeal to your lordship, my lord,
Let
to
us,
be taken up before vacation.
let us,
16. Gautam Dev.
ಅದು tomorrow, ಅದು ಯಾವ್ದು? Same department. Club ಮಾಡಿ, tag ಮಾಡಿ.
My lord, in
Tag ಮಾಡಿ. Called along with ಅಂತ ಮಾಡಿ.
my lord, in this matter,
My lord, with the.
Notes ಇಲ್ಲಿ? Notes. Huh? Taking notes.
my lord, in this matter, I have to file objection because
Now, who's the employer
Take
now?
my-
Who's the employer?
apply is Mangalore.
So
Second.
let us see.
Because
But the order.
Order was
confirming
passed
order is
by-
Government.
Government.
Government is a confirming order, right? Go on with it.
Government is?
Confirmation is by the government.
That we'll
Annexure
see.
X is I have filed.
No, fine, correct. Finally, we met the most is ask them to pass appropriate order. You make out your case. Now you are contesting, isn't it? Now you are contesting.
No, equally government is also on the same footing.
Huh?
Equally government is also on the same footing.
So that we'll see. Let us see. At the end of it is, if there is an if there's an ambiguity,
Yes.
so what are the remaining judgments you said you were?
My lord, with regard, they had, under section 10, my lord, there was a, notification issued by the government
Yes,
prohibiting contract labor, my lord.
yes,
The effect of that order, my lord,
yes.
I have produced a list of judgment, my lord, 3 judgments, my lord. On 28 November 2024, my lord.
Yes.
My lord, this question, my lord, what is the effect of prohibition of abolition of contract labor? Is at page number, para 37 is the question raised by the Honorable Supreme Court in Air India Statutory Corporation, my lord. Page number 38. Page number 38, internal page, my ink page 38. Para 37 of the judgment.
Para?
Para 37, my lord, is the issue raised by the Honorable Supreme.
Yes.
The pivotal question for consideration is on abolition of the contract labor by the publication of notification.
Para 30?
Para 37, my lord, page number, ink page 38, my lord. Judgment page is 414, my lord.
Yes.
My lord, the pivotal question for consideration is on abolition of the contract labor by publication of a notification in the Gazette under subsection 1 of section 10. What would be the consequence? It is seen that so long as contract labor system continues, the principal employer is enjoined to ensure payment of wages
to contract labor and to provide all other amenities envisaged under the Act and the rules, including provision of food, potable water, health, safety, and therefore visits a penal consequence. This was the question, my lord. Then this was answered, my lord, at in para 65, my lord. Thus,
Page,
para 65, my lord, page 63, ink page 63, my lord, judgment page 439, my lord.
yes.
Thus, we hold that though there is no express provision in the Act for absorption of employees whose contract labor system stood abolished by publication of the notification under section 10(1) of the Act, in the proper case, the court as sentinel or qua VA is required to direct the appropriate authority to act in accordance with law and submit a report to the court. Based thereupon, proper relief should be granted. My lord, and then, my lord, they discuss the entire discussion is at para 68, 66, my lord, next page, 64. Then at page, in page 65, my lord, held, therefore, it stand,
Page?
page 65, my lord.
Yes,
Page 64 is the discussion about the previous judgment of this honorable court, which is analyzed, my lord.
yes.
From I start, therefore, it stands over. Moreover, Bombay High Court has correctly held that the High Court under 226 the Constitution would direct the principal employer to observe the contract labor after its abolition, even though some of the contractors have violated Section 12, appellants have violated Section 7 of the Act. In the judgment under appeal, the High Court has directed to observe the service of the workman from the date of judgment. The respondent union did not challenge it. We are therefore constrained not to grant the relief to the respondents union and abolition of contract labor system. We therefore uphold the direction issued by the High Court to regularize their service with the effect from respective dates of the judgment of High Court, judgments of the High Court with all consequential.
So what is the effect? That
Effect is, it will be automatic regularization, my lord.
from the date
On
which it was abolished.
Yes, my lord. But this judgment, my lord, came up before the Honorable Supreme Court in sale authority, my lord, which changed this position, my lord. Why I cited this is, by the time this Honorable Court rendered the judgment in my favor, my lord, in 2000, my lord, that is, this judgment was in operation, my lord. Air India.
On that date.
Yes, my lord. Then thereafter, my lord, by the time 6 years had passed and that 6 months was fixed for them to complete the report, my lord. By that time, Sale Authority of India, my lord, page number 71. Steel Authority of India, Limited and others was National Union Waterfront
So what is the
Workers.
change now?
The change is at, my lord, page number 130, my lord. Page number 130. My lord,
Page 130?
yes, my lord. 130, page number, my lord, page 125 is the apex court marks 3 category of cases, my lord. In page 125, judgment page 56, my lord, para 107.
107,
my lord, of the judgment.
yes.
There, my lord, an analysis of the cases discussed above shows that they fall in 3 classes, where contract labor is engaged in the connection or in connection with the work of an establishment, and the employment of contract labor is prohibited either because of the industrial adjudicator court ordered abolition of the contract labor, or because the appropriate government issued notification under section 10(1) of the CLRA Act. No automatic absorption of the contract labor, automatic absorption of the contract labor working in the establishment was ordered. Where the contract was found to be a sham and nominal, rather a camouflage in which case the contract labor working in the establishment of the principal employer were held. In fact, and in reality, the employees of the principal employer himself, indeed, in such do not relate to the abolition of contract labor, but present instances wherein the court pierced the veil and declared the correct position as fact at the stage after employment of contract labor prohibited. 3, where in discharge of the statutory obligation of maintaining canteen in the establishment of the principal employer availed the services of the contractor, the court have held that the contract labor would indeed be employees of the principal employer. My lord, then the conclusion, my lord, is at para 125, para 125 of the judgment, my lord. Page 130, my lord. The upshot of the above discussion is outlined thus. 1A before 20, my lord, this is regarding appropriate authority, my lord. What is the appropriate authority for? My lord, can I straight away come to para 2A? Para 2A, my lord.
Yes.
Because this will relate to us, my lord. A notification under section 10.1, that is at page 62, my lord. A notification under section 10.1 of the CLRA Act prohibiting employment of contract labor in any process, operation, or other work in establishment has to be issued by the appropriate government after consultation with the so and so, my lord. Then B, my lord, in as much as the impugned notification issued by the central government on 9/12/1976 does not satisfy the aforesaid requirement of section 10, it is quashed. But we do not do so prospectively from the date of this judgment and subject to clarification that on the basis of this judgment, no order passed or no action taken giving effect to the said notification on or before the date of judgment shall be called in question in any tribunal or court, including High Court, if it has otherwise attained finality or it has been implemented. Second part, my lord, para 3. Neither section 10 of the CLR Act nor any other provision in the Act, whether expressly or by necessary implications, provides for automatic absorption of contract labor on issuing notification by the appropriate government under section 1 of section 10, prohibiting employment of contract labor in any process, operation, or other works in any establishment. Consequently, the principal employer cannot be required to order absorption of contract labor working in the establishment concerned. Then, my lord, para 4, we overrule the judgment of this court in Air India case prospectively and declare that any direction issued by any industrial adjudicating court, including the High Court, for absorption of contract labor following the judgment of Air India case shall hold good, and the same case need not be set aside, altered, or modified on the basis of this judgment in case where such direction has been given effect to and it has become final. 5, my lord, this is most important, my lord. On the issue of prohibition, notification under
Just 1 minute. What is the date of that order of the High Court?
High Court, my lord. My
That abolition order
yes, my lord.
was prior to the order in sale.
Yeah, abolition order is in 6 years later after sales judgment. 2001 is the judgment in sale, my lord. But the Honorable High Court, my lord, which granted, which I relied, my lord, earlier. Page number 79, annexure R, my lord.
Just finish up 5, let us.
Yes,
You finish this page 133.
yes, my lord.
Finish.
Yes, my lord. My lord, this is very important in to me, my lord. On issuance of prohibition notification under section 10.1 of the CRL Act, prohibiting employment of contract labor or otherwise in an industrial dispute before it or in contract labor in regard to conditions of service, the industrial adjudicator will have to consider the question whether the contractor has been interposed either on the ground of having undertaken to produce any given result for establishment for supply of contract labor to work of the establishment under genuine contract, or is a mere reuse, camouflage to evade compliance with the various beneficial legislation so as to deprive the workers of the benefit thereunder. If the contract is found to be not genuine, but a mere camouflage, the so-called contract labor will have to be treated as employees of the principal employer, who shall be directed to regularize the service of the contract labor in the establishment concerned, subject to conditions which may be specified by it for the purpose in the light of para 6 the hereunder. Para 6, if the contract is found to be genuine and the prohibition notification under section 10(1) of the CLRI Act in respect of the establishment concerned has been issued by the appropriate government, prohibiting employment of the contract labor in any process, operation or other work of any establishment, or wherein such process, operation or other work of the establishment, the principal employer intends to employ regular workman, he shall be given preference to or the erstwhile contract labor if otherwise found suitable, and if necessary by relaxing the condition as to maximum age appropriately, taking into consideration the age of workers at the time of their initial employment by the contractor, and also relaxing the condition as academic qualification other than technical qualification. My lord, next para, my lord, I cannot avoid this. I have to submit, my lord. We have to use the expression industrial adjudicator by design, as determination of the question aforesaid requires inquiry into disputed question of facts which cannot be conveniently be made by the high courts in exercise of jurisdiction under 226. Therefore, in such a case, appropriate authority to go into those issues will be industrial tribunal, whose determination will be amenable to judicial review, my lord. But my lord, these two judgments, my lord, was considered in ADA case, my lord, which I have already produced before your lordship. My lord, this ADA case, my lord, Aeronautical Development Authority case, my lord, which I have produced as Annexure A along with my rejoinder, page number 11, my lord. This is the second round of litigation, my lord. In ADA, my lord, the facts was that, my lord, they were employees, the employees were under the contract, my lord. At that time, no rules was framed, my lord. And they were not regularized. They approached this honorable court. In the first round of litigation, my lord, the ADA judgment was passed, and relying upon that judgment, I was given this order, which I have produced as annexure 2000 order, my lord, in my favor. First order in my favor, my lord. Annexure. My lord, Annexure R, page number 79, my lord. This relies upon the same at page number 83, my lord. It relies upon Raman and others versus Aeronautical Development Agency, etc., confirmed in so and so writ appeal, my lord. The observation there was followed, and I was given a direction to in my favor, and there was a direction to the under section 10, my lord, to prepare a report. Then some of the employees were not regularized, my lord. Then this was ADA 2, my lord, second judgment. In this judgment, my lord, all of them were regularized. My lord, there the honorable only two paras I will rely upon, my lord. Then thereafter I'll go straight away to the last portion, which is very crucial, my lord. My lord, my lord, in it the facts, it is page number 19, my lord. It will.
Sale case is 2001.
Yes, my lord. This both the case are considered by in this case in under 226 only the workers had approached this honorable court, my lord, and these two judgments are referred in para 2 of that said judgment, my lord. And before that, my lord, they also mention it will indeed be a travesty of justice when courts decline to protect the livelihood of a person who has the good fortune to receive employment. There is so much debate on whether there can be any meaning or substance in the fundamental right to life if it is bereft of assurance of income through work. The Republic of India should rightly be proud of schemes guaranteeing even to a limited extent of rural employment. If the progress of our country cannot be lauded, it is on account of manifestation of a rich getting richer, while lot of vast majority remains.
We'll continue post.
Yes, obligation.
Your Lordship. Your Lordship.
230 mentioning yes, yes, yes.
The serial number
ಯಾವ್ದು ಸರ್?
26 ಇದೆ.
ಒಂದ್ ನಿಮಿಷ ಸರ್,
330.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಸರ್, ಸರ್ ಎಷ್ಟು ಸರ್ ಸೀರಿಯಲ್ ನಂಬರ್ ಸರ್? 46 ಸರ್? 46
ಕಂಟಿನ್ಯೂ ಮಾಡ್ತೀರಾ?
ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಇದೆ ಸರ್, ಅದು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬಿಟ್ಲೆ.
ಕಂಟಿನ್ಯೂ
9
ಕಂಟಿನ್ಯೂ.
ಹಾ 230 ಆದ್ಮೇಲೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿ.
ಸರ್ ಲಿಸ್ಟ್ 3 ಯಾವಾಗ ತಗೋತಾರೆ ಸರ್?
ಸರ್ 38 ಇಲ್ಲ ನೋಡೋಣ ತಾಳೆ ಮಧ್ಯಾಹ್ನ ಸರ್. ಇಲ್ಲ ಮಧ್ಯಾಹ್ನ ನಾನೇ ಲೇಟ್ ಆಗೋಯ್ತಲ್ಲ ಅದಕ್ಕೆ. ಸರ್ ಮಧ್ಯಾಹ್ನ ನಿಮ್ದು ಆಗೋಗುತ್ತೆ. ಮಧ್ಯಾಹ್ನ ಹೇಳಿದ್ರೆ ಮಧ್ಯಾಹ್ನ ಮಾಡಿ ರೀಚ್ ಆಗಿರಿ, ಈಗಲೇ ಮುಗಿದೋಗ್ಬಿಡೋದು. ನಾನು ಬೆಳಗ್ಗೆ
ಲಿಸ್ಟ್ 3 ಯಾವತ್ತೇ ಅಂದ್ರೆ ಲಿಸ್ಟ್ 2 ಲಿಸ್ಟ್ 3 ನಾ? ಲಿಸ್ಟ್ 2 ಲಿಸ್ಟ್ 3 ನಾ? ಲಿಸ್ಟ್ 2 ಆದ್ಮೇಲೆ ಲಿಸ್ಟ್ 3.
ಸಾಹೇಬ್ರ ಇಲ್ಲ 57 ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಒಂದು ಹಾಕು. ಯಾವ ಇಮಿಡಿಯೇಟ್ಲಿ ಆಫ್ಟರ್ ವೆಕೇಶನ್, ನಾಟ್ ಆಫ್ಟರ್ ಅಬ್ಸಾರ್ಪ್ಷನ್ ಇನ್ 2 ತಿಂಗಳು ಉಳಿಯುತ್ತೆ ಅವನಿಗೆ. ಅಲ್ಲ ಫ್ರಮ್ 6th ಅಲ್ಲ ವೀಕ್ ಕಮೆನ್ಸಿಂಗ್ ಫ್ರಮ್ 6th January. ಇದು ನಾನು ಕೆಳಗಡೆ ಕೊಟ್ಟಲ್ಲಿ ಹೇಳ್ತೀನಿ ಸತೀಶ್ ಅವರು ಮೆನ್ಷನ್ ಮಾಡ್ಬೇಕಂತೆ ನಾಳೆ ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಇದೆ ರಿಟೈರ್ ಆಗ್ತಾರೆ ಅಂತ ಹೇಳ್ಬೇಕು ಪ್ರಮೋಷನ್ ಮಾಡ್ರು ಅವ್ರು ಬರಕ್ಕೆ ಎಲ್ಲಿದ್ದಾರೆ ಅವರು
ಇಲ್ಲಿಂದ ಬರ್ತಾರೆ.
ಸರಿ ನನ್ನ ಹತ್ರ ಬರಕ್ಕೆ ಹೇಳಿ ಇಮಿಡಿಯೇಟ್ ಆಗಿ ಹಾಕ್ಸ್ಕೋಬೇಕು ಪ್ರಿಲಿಮಿನರಿ ಹಿಯರಿಂಗ್ ಅಲ್ಲಿ ನಾಳೆ ಇಲ್ಲ ನಾಳೆ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಆಗತ್ತಾ 57 ಅಲ್ಲ ಫಸ್ಟ್ ವೀಕ್ ಅದು 57 ಫಸ್ಟ್ ವೀಕ್ 28 ಮೆನ್ಷನ್ ಅಂದ್ರೆ ನಮ್ದು ಫಸ್ಟ್ ರೌಂಡ್ ಅಲ್ಲಿ ನಮ್ದು ರೆಗ್ಯುಲರ್ ನಾವು ಇದು ಮಾಡ್ತಾರೆ ನಮ್ಮನ್ನ ಇದ್ರಲ್ಲೇ ಡೈರೆಕ್ಟ್ ಎಂಪ್ಲಾಯೀಸ್ ಮಧ್ಯದಲ್ಲಿ ಕಾಂಟ್ರಾಕ್ಟ್ ಚೇಂಜ್
ಸರ್ ಇವತ್ತು ನಮ್ಗೆ ಅದೃಷ್ಟ ಇದೆ ಅನ್ಕೊಂಡಿದ್ದೀನಿ ಸರ್ 17.
ಒಂದೇ ನಿಮಿಷ
ಸರಿ ಸರ್ ಅಷ್ಟಾದ್ರೆ ಸಾಕು ಸರ್. ಥ್ಯಾಂಕ್ ಯು ಸರ್.
Yes.
Submission, your lordship.
Yes,
Serial number 28, your lordship.
yes.
ಇದು ಪ್ರಮೋಷನ್ ಇದೆ ಲಾರ್ಡ್ಶಿಪ್ ದಿಸ್ ಮಂತ್ ಲಾಸ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ರಿಟೈರ್ಮೆಂಟ್ ಆಗ್ತಾ ಇದೆ ಪ್ರಮೋಷನ್ ಕನ್ಸಿಡರೇಷನ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ ಕೈಂಡ್ಲಿ ಹ್ಯಾವ್ ಇಟ್ ಆನ್ 28 tomorrow in preliminary hearing your lordship.
Who is the employer?
28.
Your lordship.
Who is the employer?
ಅದು
Prakash Chebba.
Huh?
your lordship,
Who is the employer?
employ-
How we can issue orders for
ಅದು ರೆಸ್ಪಾಂಡೆಂಟ್ your lordship, ರೆಸ್ಪಾಂಡೆಂಟ್ ಅಪೇರ್ ಆಗಿದ್ದಾರೆ ಅವ್ರ ಅಬ್ಜೆಕ್ಷನ್ ಏನು ಹಾಕ್ಲಿಲ್ಲ ಸ್ವಾಮಿ ಅದಕ್ಕೋಸ್ಕರ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಪ್ರಮೋಷನ್ ಆಗ್ಬೇಕು ಸ್ವಾಮಿ
correct? How we can order promotion?
ಅಲ್ಲ
Huh?
ದಿಸ್ ಮಂತ್ ರಿಟೈರ್ಡ್ ಆಗ್ತಾ ಇದಾರೆ ಅವರು ಪ್ರಮೋಷನ್ ಆಗ್ಬೇಕು ಪ್ರಮೋಷನ್ ಆಸ್ ಪರ್ ದಿ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಇದೆ ಸ್ವಾಮಿ ಅವ್ರಿಗೆ ಕ್ವಾಲಿಫಿಕೇಶನ್ ಪ್ರಕಾರ ಆಗ್ಬೇಕಾಗಿತ್ತು ಕೊಡ್ತಾ ಇಲ್ಲ ಅವರು
I really don't know how we can now do anything. Let us see if it reaches today. We'll see.
Wait.
Let us.
Serial number 49. Lordship may remember that two professors were dismissed without holding inquiry. Lordship granted interim order at that stage, respondent submitted, will keep the order in abeyance. Then your Lordship said the of the submission, the matter was recorded. Then after the order being kept in abeyance, when they went and gone for report for duty, the chambers have been locked. They have not been allowed to work in spite of the order. I have filed an application for interim direction. It's not clear tomorrow morning preliminary hearing, it may be taken. They are not being allowed to work.
Who's the employer?
Employer is my Ramaya Institute of Technology, Ramaya MS Engineering. Morning, if your Lordship, tomorrow morning it is posted so that they can also come. Otherwise, urgency is there, otherwise they will not be allowed to work.
Serial number?
49.
List. You have filed an IA, is it?
I have filed an IA on the IA order, may be posted for order.
List the matter in the orders list tomorrow. 49 and 50
49 and 50.
and 50.
Lordship's kindly serial number 74, B group, it relates to retrospective promotion. Kindly have it after, it may not likely to reach 74, I appear for the petitioner.
List after
The date may kindly be
winter vacation in the week commencing from,
13th of January.
yes,
13th.
13th of January.
To appoint chairman and pollution control. The urgency is the person who is acting as acting chairman in the pollution control board is also the chief secretary. As principal secretary, he directed the pollution control board to release 136 crores. Pollution control board, government order is passed, finance department budget. One more letter is written to grant 200 crores. He acting as the chairman, is supposed to release the funds. The same person,
no, but now correct.
that the urgency is only this. Your Lordship are aware, as an discharge officer, he can't exercise statutory or financial power. No, divorce all of that. Crores in hundreds of crores, money is thought to be sent from pollution control board on loan. Pollution control board is being turned into a bank to advance.
No,
loan.
but correct. But now we are only on the service my aspect.
That's right, so he's acting as the chairman. Your Lordship had heard us to say that there was no post of principal secretary at all, without the cadre being formed.
But then the matter has to be heard finally.
Even if there is no money spent, that's what the objective to the financial department. Would you have considered this as post? I'll make a request.
It is, but I'm saying those are aspects, internal matters of administration. They're now only on the appointment validity or otherwise.
Yes, that's
So any decision taken, how we could intervene on that? Unless his appointment is set aside.
there. Financial.
But then that you have to seek on his higher ups only.
May
Let us see.
I make a request?
Yes.
My lord, serial number.
minutes, 80 minutes. Serial number 80 minutes.
Yes,
On the last occasion, 80 minutes, 80.
yes.
On the last occasion, the minutes are pleased to hear, and with respect to the minutes interim period is concerned, that minutes, he has been acquitted minutes in a criminal case, minutes on the by virtue of a department inquiry minutes, he has been, punishment of compulsory retirement has been ordered upon.
Punishment of?
Compulsory retirement minutes has been ordered upon.
Huh.
For the sake of minute, other side minutes, it was posted today.
Hmm.
Not because of some inconvenience minutes of senior counsel minutes, may just have tomorrow minutes, for preliminary hearing.
No, this has to be heard finally.
For consideration of interim period in the last time, the order ಮಾಡಿದ್ವಿ.
How we can unless we hear the other side?
The step, with the understanding the note that interim period can be taken into consideration on the next date of hearing. The notes are pleased to post it matter.
Compulsory retirement, how we can order in interim stage? It has to be heard finally only.
Tomorrow minutes, I'll engage the service of senior counsel.
That itself is no reason. That itself cannot be a reason.
80.
Now, where notice is issued to you.
Minutes, the last occasion notes, Srinivas Gowda minutes, appearing for the KPTCL notes had made an appearance.
Huh.
At my request.
List the matter in the orders list on.
Tomorrow minutes.
I don't know. Tomorrow, day after tomorrow.
Yep.
Yes.
Lord,
Please.
serial number 7, joint memo which my lord had directed to file.
Just
Lord's condition.
Just wait.
Serial number 72, my lord,
Huh.
appear for the respondent university.
Huh.
This matter pertains to single post reservation, my lord.
Huh.
We are in consonance with the interim order passed by this honorable court where it has stayed the notification. So we are in consonance with the petitioners, my lord, that we want to withdraw the notification and permit the court to notify fresh, madam. So that is the reason these three matters have been, we have moved the matter.
You file a memo.
Please, ma'am. We have got, already the statement of objections has been filed, but we will not be pressing for the statement of objections, my lord, and we'll be filing a fresh.
You'll file a memo.
Please, ma'am.
So when do you want? Today?
Today or tomorrow, my lord. Tomorrow at any point.
We'll take it up. You give the memo.
Please, my lord.
After the arbitration list,
Please.
we'll record the memo and we will dispose.
Please,
it.
please.
Lord, I appear for the petitioner in that matter, Lord.
Yes.
Perhaps not the university will have to file an affidavit withdrawing the notification which has been challenged. If
If they
that
file-
is done, Lord, the writ petition may be closed.
So if they file a
The
memo,
list would be closed.
we'll take note of the memo. There ends the matter.
Please, even if it is a memo, Lord, if it is
Yes.
taken on record, it could be closed.
Yes, let us
Please.
take it up.
They have to withdraw the notification.
Correct. So we'll take,
Right.
we'll record their undertaking.
Great,
We'll
please,
take it after the arbitration list.
please.
Lords ended up in 2 different memo where they are not agreeable for condition number 5 is what they are.
File good. File good.
All that I have asked for, my lords, anything impermissible under law, respond number 3 shall not act.
Lord,
Just take me through your memo now.
Lord,
Take
we
me
have,
through your memo.
My lords, please, my
I
lords.
have placed it, my lord.
Lords,
Lord, that's
First,
the first. Right.
Lords, first thing, lords, which the only objection there, first thing I have mentioned that my lords petitioner shall be reinstated back to service pending contemplation of
no-
inquiry by the respondent number 2 and 3. And petitioner undertakes he shall cooperate with the inquiry. And my lord, second is with respect to my lords, respondent number 2 and 3 along with petitioner agrees for reinstatement on the term that petitioner on reinstatement will be posted to the constituent college of respondent number 2 university in Shivamogga town. Lords, third is petitioner agrees to the contention of the respondent number 2 and 3 that petitioner shall not enter the campus at Shankarghatta except during called upon for the inquiry and only to the employees union office and union related work only. Lords, fourth, it is further submitted that it is agreed upon among the parties that petitioner shall enter the campus for the purpose of campaigning for election of the employees association. In the event, calendar of events are released for the same. Lords, fifth, they are disputing. On agreement, the petitioner and respondent number 3 undertakes to not to involve in any of the undesirable activities which is impermissible under law. And my lord, sixth is accordingly we are.
My lord, this is the
Just 1 minute, just
please.
fifth one you deleted. What is that?
My lords,
Fifth one,
my lords,
what is the fifth one?
my lords,
we
I am
have such-
alleging malafides against respondent number 3
Correct,
and despite which my lords,
correct. Now
that is the reason. Then my lords, I pray for one more relief, my lords. Let the suspension order be quashed, my lords. That keeping in abeyance makes no, my lords. It would not give meaning in the eye of law for the reason that inquiry is continued and they are empowered to take any action to that course of action. And my lords, if I conduct any other misconduct, they can again keep me under suspension. So keeping suspension order in abeyance would not indulge to anything
Yes.
when I'm reinstated.
These are the 5 points we have proposed to the other side. But this is except it has been advised by senior, my lord. The 5th point, my lord, what they say, we are asking him to not to indulge any undesirable activities in the campus or in the service. Instead, he is returning, he is questioning us this thing.
Not
Being an
responsible.
employer, I cannot keep quiet whatever he is doing in the service. So therefore, we have advised and we have advised the other side not to indulge any other activities. So that the 5th point, it is not at all relevant. And the question of reinstatement, if it is been dismissed, and we have categorically said that we will give a posting at Shimoga. And these are the words which is not necessary to be included in para number
What is
1
your
and 2.
memo?
I have placed it, my lord. That it is submitted that the petitioner hereby undertakes that he will work at Shimoga Town College run by university or any college affiliated to the Comp University.
That I have not agreed upon.
That it may be in the Shimoga Town only. And the petitioner herein undertakes to appear before the inquiry officer whenever they call for inquiry by the inquiry officer. The petitioner herein undertakes to not to enter the university campus at Shankaragatta except inquiry only union office for the union related work only. The petitioner herein undertakes that he will not indulge any undesirable activity. And 5th one, my lord, the impugned order is suspension will be kept in abeyance.
Now the impugned order of suspension now will have to be set aside by virtue of.
But if he indulge in the same activity, it should come on.
No, that in case there's a violation of undertaking.
I'll be violating court order.
Undertaking,
So if there is any violation of undertaking, this again it should come back to the same position without even there being notice to him. He will be deemed suspension.
In case there's any violation of the undertaking given to the court, liberty will be reserved to move the court. In the event, he could record his undertaking not to do any illegal activities. If there's any violation of that, liberty is reserved to approach the court to seek for revival of the order of suspension.
Please.
1. 2, the order of suspension now will have to go. If we are going to dispose of the writ petition in light of the terms now as a part of the joint memo, the order of suspension will have to go. I'll also keep it open that in the event of any circumstances so arise, parties are at liberty to seek for reopening the proceeding.
That is fine.
Now this joint memo given by them.
Mine only 5 they are disputing.
No, correct. So first one,
My lords.
Shimoga town, the remaining we can remove it.
Or any other, it will go.
Shimoga town, at any college run by the university in Shimoga town.
Lords.
That is the first one. Any other colleges will remove that.
Yeah, indeed, my lords.
Then 2, petitioner undertakes to appear before inquiry officer whenever called for inquiry.
Agreeable.
Petitioner herein undertakes to not enter the university campus at Shankaragatta except for inquiry and union and for union related work.
Agreeable. Why only petitioner?
So just 1 minute. Then next, petitioner undertakes he will not indulge in any illegal activity. We'll put it as illegal.
Please, my lord.
Illegal activity. Then last, impugned order of the suspension. Court to pass appropriate order. No, then in terms of the above
Joint memo.
court, in terms of the joint memo, the court may pass appropriate orders.
Please.
And then I'll give liberty and set aside the suspension order.
Please. Please.
Obliged.
Isn't it?
Please.
The code file code. So this joint memo will have to be retyped and signed.
Yes.
Huh?
Yes, ma'am.
Retyped and signed. I've made that small thing. Then in terms of the joint memo, court may pass appropriate orders. I'll pass order recording it. Also mentioning if there's any breach of the undertaking, it will amount to contempt. And parties at liberty to move for revival of proceedings if circumstances are so made out. Please. We have actually disposed it, isn't it, in the morning? Please.
Already disposed
One
with,
paragraph.
in terms of joint.
The joint memo filed. Petitioner, respondent number 2 and 3 reads as follows. Next. Taking note of the joint memo, the order of suspension at annexure
A.
A is set aside. Next. Both parties to adhere to the terms of the joint memo. In the event of any breach, parties would be exposing themselves to contempt of court proceedings. Full stop. Needless to state, in the event circumstances so arise, parties may move for revival of proceedings in the event there is non-adherence to the joint memo. Please. So the joint memo you can file. All other contentions and merits are kept open, and morning whatever I've dictated regarding inquiry will remain.
Deeply obliged. Deeply.
Hmm. 20. 21.
Next one, serial number 21, Satish K. PA Kulkarni.
I beg to appear for petitioner in the other petition.
So then I will have to dictate. That's all. Anything else?
So I have one request to make before your lordship start dictating. May I make a request, my lords?
Yes.
My lords, yesterday, your lordships are directed to produce the records.
Yes.
To the KPTCL Council, Mr. Chandrachud.
Yes.
He has produced the records only with reference to the first his writ petition and not in my case.
I'll consider, but whatever is produced, he's given a copy, isn't it? Same
No,
note sheet.
Whatever is produced only in with reference to his writ petition means that is between Lokesh and Dhananjay.
That would suffice for the time being. We'll see.
My request to your lordship is, unless as far as mine is concerned, it is a memo for approval by the chief minister. Thereafter, it was referred to the department. Department referred it to the KPTCL for further action in accordance with the direction. So therefore, it is necessary for your lordship to see what action they have taken with reference to my case.
Correct. There is a serious question mark regarding the relief that you have sought for. So in
I leave it to your lordship. I am not telling you that.
So in light of that, if I were to go on the merits, then definitely I will adjourn the matter and call him. Let me see how the order comes out. If I'm going to go on merits and considering your request as being maintainable that could be considered, then I will definitely call upon him to produce the records and I'll have a look at it.
My humble submission to your lordship is that as far as records memo, as far as merits of my case is concerned, your lordship may have to go into the merits of my case for a simple reason, because on 3rd December, Dhananjay's transfer is approved. Whereas on 27/11, my matter was before the KPTCL authority for taking necessary action in accordance with the direction issued by the chief minister.
I'll consider.
Kindly, this may be considered, and it is your lordship's prerogative to consider that.
Let us see.
I am obliged to my lords.
I had only one question. The reference to what powers that the minister has under the transfer guideline.
Please, Manoj.
What
Manoj,
power? Because in the note sheet, it says approval of minister.
please, Manoj. If your lordships could kindly take Manoj.
Earlier,
Page 84.
Minister was in charge for some time up to 15/6/24.
No, with reference to general transfer, this thing exercise, the minister was empowered. Thereafter, with reference to other things, when there is a complaint against anybody and chief minister's approval is required, that is any time thereafter with the chief minister's approval.
No, after the last date for general transfers,
Yes, my lords.
under the guideline appears to indicate chief minister's approval.
Yes,
is
Lord,
required.
31/7/24.
Under 5.3, under
transfer
5.3, my lords.
shall be approved by chief minister.
Then what is the role of the minister?
My
Minister,
lords, in
before
the-
that, my lord,
In clause 4,
under the very guidelines they have issued, minister in charge can
make necessary
make
transfers.
necessary orders.
But where is that?
Clause 4, my lords.
Clause 4.
Restrictions on transfers and responsibility
Just
of,
one.
please, my lords. My lords, first I would like my lords to take
No,
clause
just-
2, competent authority, the
just
scope,
what- Which page
page number 83
of
of writ petition filed by BC Lokesh, 32799,
page number?
83. Here, my lords, the clause 2(1), competent authority has been enhanced, the scope, which says the appointing authority or such other authority authorized to make transfer or deployment. Now, your lordships may kindly take page 84.
Yes.
At clause 4, the heading is, my lords, restrictions on transfers and responsibility of competent authority and government servants. Minister in charge of the respective departments are hereby delegated the power to make general transfers from so and so to so and so, and number of transfers or deployment made during the year 2024-2025 in respect of Group A, B, C, and D. Post shall not exceed 6% of the working strength in a unit of seniority. Now, if it is beyond general period of transfer, then, my lords, your lordships may kindly take clause 5(3). 5 commences at page 85.
So it says approval of chief minister.
Please,
Yes,
my
my
lords.
31/7/2024 is the cut-off date fixed by the cabinet.
Only then,
31/7.
31/7.
only then, my lords, it goes before the chief minister.
3/24 of the order. That too is emanated from chief minister. It is not approved by chief minister.
So what do you say regarding the?
My lords may kindly take, my lords, the very judgment or the very birth of this particular petitioner in this particular cadre, my lords, at Chandapura was by the benefit of a certain similar order, which has been confirmed by the division bench.
That's okay. I'm only on the point.
Please, my
Only
lords.
on the point that admittedly the transfer order is passed after the general period
Please, my
permits.
lords.
In the note sheet, it goes to the minister and then there ends it. After
lords,
which-
The entire action, my lords, it has come from the office of the Honorable Chief Minister itself. My lords, it is not in my instance. Since there were certain complaints against him, or the local, the representative, elected representative had made a representation to the Chief Minister, the Honorable Chief Minister felt it necessary.
Correct. Are you saying that the 1911-24 approval that was granted
Please, my lords.
in your favor
Please, my lords.
would be sufficient?
Please, my lords.
That is your stand.
Please, my lords. Why so, my lords, is because if your lordships can take the previous judgment, my lords, between Chandrasekhar and BC Lokesh in writ petition at page number 41.
No, so for all practical purposes, the approval of the minister is to be ignored.
Please, my lords, the approval,
For
Yes.
insofar as the contention of a transfer after general period of transfers, the approval of the chief of the energy minister is of no consequence. If at all, it has to be by the chief minister.
please, my lords.
So you are saying that the 1911-24 approval of the chief minister is sufficient insofar as such contention is.
Please, my lords. And also in the light of the fact that this particular order has been upheld by the Honorable Division Bench, where Chandrasekhar MB's contention was also identical.
So that we'll see. I was only on the first part. They have raised contention saying that the procedure followed is wrong. The file could not have emanated from the chief minister and it was premature. Those were
Please,
the
please.
last of their contentions raised was since it's beyond the transfer period, you should have, your order should have obtained chief minister's consent. So you are saying that the 1911-24 is the approval.
Please, my lords.
So the note sheet then referring to energy ministers, that will have to be ignored.
My
The
lords,
energy minister no role.
My lords,
Technically,
he has
that's
the
only
role.
internal, that's an internal procedure. no doubt.
Procedure,
But
because
under the transfer guidelines, the energy minister is not contemplated except for that limited 6%, etc.
please, my
But
lords.
insofar as after the cutoff period, energy minister has no role.
My lords, my respectful submission will be, my lords, that it is in two parts. One, the minister is empowered with that authority during general period.
Correct.
And then after general period, the minister still holds the authority, but the CM's approval is required.
Correct. But under the note sheet, if you look, procedure is CM is given the approval in 1911.
Please, my lords.
Subsequently, again, it is put up to the minister at a subsequent point of time.
Please, my lords. So the entire procedure narrated, my lords, in the transfer guidelines, it's followed.
Let us see.
Milords, I have to make
This
a
announcement
clarification.
tomorrow. Yes,
I have to make a clarification. In my case, my lords, your
Yes.
lordship kindly see under the memo what I have produced, the last page, for a
Yes.
second. Under the memo, last page, what I have produced. Last page, my lords.
yes,
The after the stage of the approval from the chief minister, the
Yes.
file has gone to the department concerned, inter-alia concerned. Your lordships are seeing at serial number 2 there.
yes,
Then he has said that Agatya Kramakkagi, he has referred it to the Vyavasthapaka Nirdeşakaru KPTCL.
yes,
Then your lordship may kindly see the next serial number 3. Vyavasthapaka Nirdeşakaru KPTCL writes there, please put up. Thereafter, nothing is there.
yes.
Therefore, I requested your lordships, if your lordships are to decide both the matters together,
Let
your
us see.
lordships may have to peruse the file relating to mine, what happened on 27/11. Because on 27/11 only the Dhananjay's case is put up for approval. Means the for issue of the order.
If the KPTCL wants, still they may do that.
Anticipatory writ, this writ will not lie.
Let us see, let us
No,
reserve.
that I leave it to the, your lordships. But my submission to your lordship is, in my humble submission, in the interest of equity, both the files are to be seen and your lordship may pass a common order.
Reserved.
I am grateful to my lords.
Interim order may be.
The
Until
modern operation is extended till the next day, till the pronouncement of orders.
grateful.
List 2. Serial number 1.
But 22, my lord, next matter.
Yes,
Parity of, my lord, in the interim order, in the parity, my lord wanted to grant it. Time is given to the BWS. My lord,
list,
22, my lord. List 1, next matter. My lord will remember, in parity interim order is granted several writ petition, my lord, I have produced 358.
repatriation.
Not repatriation.
What is it?
Senior promotion and seniority list in the PWSSP, my lord, where this court entertained several.
I file my objections, my lord, I'll have to file. Moreover, my lord, they're all in charge.
In charge only, my lord.
Claiming, my lord, not to disturb them. Now, my
Yes, my
lord,
lord,
an
that
in
is the
charge.
interim order only that protected.
No, let us, huh?
They're all on in charge, my lord. Now their prayer is not to disturb them from the in charge post.
Yes, my lord.
My
358
lord,
is
in
the
charge
same, my lord.
cannot be taken as permanent, my lord, now.
Condition page 359.
So let us
Take
see.
interim order.
Let us see, let us, let them file their objection, we'll see.
Not parity, not 3 interim orders are there, not 1 or 2. Condition, otherwise, but in the vacation, this will happen, my lord.
My
I cannot
instructions
move
is
your
that,
lordship, my lord.
My instructions is that, my lord, they're in charge, my lord. Now I cannot.
Correct, actually, we adjourned it on the ground.
Yes, my lord.
That there were 2 orders on, and they're seeking on parity. Now, if it is so, if the 2 mistakes in terms of interim order, right or wrong, and protection is given, then the third person is also entitled till the matter is finally decided.
My lord,
They're only on that point.
my
So
lord,
if
now,
such interim orders are there, then he also has to be.
now
given-
3345,
But
double three
there
five
are
four
3
five, my
interim
lord.
order.
He's
350.
he's an in charge engineering in chief, my lord. He's in charge also, my lord. Now,
Yes,
my
my
lord, in charge,
Correct,
my lord. Now,
right.
if he claims on this interim order, if he claims, my lord, that he's he's been made permanent, then there'll be a problem.
But I am not
Now, if
teaching any
if
permanent.
I have an,
It's a final order.
I have a person to put up for an in charge, for a permanent engineering in chief, my lord, then I will not be able to replace him because of this
No,
interim
no,
order.
it's only for in charge.
This is only in charge, even he's been placed in charge.
Correct. So in case any substantive appointment is to be made, nobody is coming in your way. For the
That can be recorded.
for the present, in charge protection to be continued.
My lord, if at all there is a candidate for a permanent, my lord, that can be
I am the
recorded. my lord.
senior
If I,
person, my lord. I am the senior most.
if that has a,
Then you give him a hearing and you decide.
yes, that can.
Not in the vacation, my lord.
No, now we'll protect.
Yes, my lord.
And then,
Yes, my lord.
in the event they are making
Yes, my
any
lord.
substantive appointment, they can hear you and then.
Substantive appointment is concerned, I am the first person to be considered, my lord. That is serious, at least. As on now, as it is.
Put it. So now on parity, we'll extend.
Yes, my lord.
Where are those orders?
Lord, one, page 3,
354.
54, 58, 59, my lord, kindly see. There are 3 orders. The last order is, my lord, the very senior list is questioned, my lord.
Page 350.
9.
354, there's another seniority list.
Yes, other senior, yes. other senior.
359 is.
Yes, same seniority list. Instead of chief engineer in chief, that's all, nothing else.
The senior counsel appearing to the petitioner submits contention raised is identical as that raised in the case in WP 22116 of 24. Full stop. Interim order in this aforesaid writ petition reads as follows, page 359. Next, accordingly, taking note of the assertion that the petitioner stands on parity and deserves extension of similar interim order as passed in WP 22116 of 24. Till the next date of hearing, the respondent shall not remove the petitioner
On the post of engineer in chief.
from the post of engineer in chief.
That's all.
Engineer in chief without obtaining orders from the court.
That's all.
Lord, then my lord, then I'll have to.
Engineer in chief. Full stop. Full stop. However, respondent is liberty to implement the seniority list in accordance with law, and if any person.
Same, my lord.
However, respondent is liberty to implement the seniority list in accordance with law.
Yes, sir. Next is not a regular chief engineer.
Correct.
Stay of reversion from post of chief engineer project is a regular chief engineer, nothing else. Next matter.
Which one?
Point 1. 22.1.
What is that matter?
It is same Lord seniority list. He is regularly promoted to the post of chief engineer. He is apparent he will be reverted to the post of chief engineer project. Interim prayer is only protection, not to revert him to the post of chief engineer project. That's all.
No, reversion on what ground?
From the post of chief engineer project.
On what ground they're going to revert you?
Because for seniority list, there is a difference not now.
No, but then we have granted liberty for them to implement.
Let them implement it. But I have been promoted in 2022. Not regular promotion, not in charge us. 31/7/22.
Lord, 27-24 is the seniority list, my lord.
Yes, my lord.
Now, my lord, over
27-24
is the seniority list.
Now,
my lord, now, my lord, that has been implemented and then they have become senior, my lord. Now this has been implemented and they've become chief engineers in this.
But we my lord, kindly see the order of promotion.
That has been
according
challenged
to-
now.
No, correct. Now, what is the apprehension now?
But reversion may take place.
On what ground?
My lord, seniority list, there is a ranking now. My lord, a provisional seniority is published in one manner. In final list, my lord, entirely view is taken.
No, final seniority list has been passed.
Correct, my lord. See, provisional seniority is published, combining assistant engineer together, graduate and non-graduate.
So that you have validity of which you have called.
Yes, yes.
So then we have to hear the other side.
But only status quo of the petitioner.
How we can stay how we can stay the seniority?
No, no, I am not saying that not. They are reversal. No, I am not saying anything.
If on finalization of seniority list, you have to be reverted, you have to be reverted.
Not not continue. If on the count of Lord, the very seniority list is illegal, contrary to law laid down by
Correct.
this
So
court.
that we have to hear. We have to hear them and then decide the matter. Let them, you file your objection.
My lord, may I kindly then call it for continuity after vacation on date, Lord.
This is the
One
matter.
date.
Consideration of interim order is kept open. He submitted that the seniority list has been challenged, and accordingly, any action that may be taken would prejudice the present position of the petitioner. In light of the same, the request for interim order is kept open to be considered on the next date. This is the matter in the week commencing from.
Lord, both the matters they have challenged the seniority.
Both the matter, my lord.
Both the matters they have challenged the seniority.
Both the matter, same seniority it is questioned.
No, correct, but in the previous one, the coordinate bench has given some relief. While
Lord,
giving you
this
liberty, no, in that, by giving you liberty to implement seniority list, protection was given, same thing.
Yes.
Yeah.
Wait.
Much obliged.
Serial number 1, Sunday R.
My lords, I am appearing for petitioners, my lord.
Yes.
My lords, there are 6 office objections, my lord. Last one I have already come. I have
Complied.
complied last one, my lord.
The rest,
The rest of 1 and 2, the copy of the agreement is with the respondent, my lord. I may be requested to produce it afterwards, my lord.
no, seek for dispensation. You file an IA for
I
dispensation.
have already filed, my lord. I have already filed. Even after that, they have raised office objection, my
No,
lord.
correct. The other office objection you have to.
Please,
comply.
I will comply it by tomorrow itself, my lord. There is an urgency because the project is over, my lord.
Correct, madam. Now I can't, unless you comply, I'm not going
Kindly
to.
notice may be issued. I will comply it tomorrow, my lord.
If you have not paid, have you paid court fee?
Yes, I have paid, my lord. I will
When
produce
you-
it tomorrow, my lord. I have paid it already.
Now, no, now I'm in a hurry. I'm not going to take up any fresh matters tomorrow and day after
Kindly
tomorrow.
post it tomorrow. I
Let
will
it
comply
come.
tomorrow, my lord. Please, I
No,
request, my.
No, now I'm not going to accommodate any requests for reposting. I've got other parted matters. It will come on the reopening day. List the matter on 7th of January. Office objections to be complied with in the interregnum.
Serial number 2,
Obliged.
List the
I appear for the petitioner, my
Arvind
lords.
DS.
My lords, will comply with the corpus objections, my lord.
week's time granted for necessary compliance.
3,
Grateful, my
My lord, this office objection has been raised, my lord.
Huh?
After scrutiny, my lord, this office objection has been raised, my lord. My lord, the office objection number 1, my lord, regarding furnish the agreement deed, my lord. My lord, the said agreement deed, my lord, along with the respondent.
Other office objections, have you complied?
Yes, I comply the office objection.
Week's time
Kindly
granted
dispense the
for necessary
original agreement.
compliance. Insofar as office objection at serial number 1, counsel for petitioner files a memo and submits that the original agreement is with the
respondent.
In light of the same, office objection serial number 1 is kept in abeyance. Yes. File a memo.
4.
Petitioner, the original joint agreement is in safe custody, my lord. It is the only office objection. I'll file an IA for dispensation by tomorrow.
In light of the submission made, office objection is kept in abeyance. Yes. Which is the clause?
Regarding the joint development agreement,
Which is the clause?
21.
Page?
Yes, sir.
28.
Yes, you have now issued notice.
Yes.
Page? That notice, the cover has come back.
Yes, 47 page.
Huh?
47 page.
Issue notice to the respondent.
5, Manjulati.
My lord, there is one office objection, my lord, in respect of work order, my lord. I'm producing the certified copy, my lord, but they are raising the objections, my lord. Original produced, my dear. I'm thinking.
You have filed the certified.
Certified copy are produced, my lord.
The office objection is
Only one, my lord.
kept in abeyance in light of petitioner. You have filed the certified.
Yes, my lord.
Page,
Page is that, my lord, Annexure C. Annexure C, my lord, in respect of page number C, 38, my lord. Page number 38.
in light of in light of copy attested by the Assistant General Manager having been produced.
Please.
What is the clause?
Clause is that, my lord, as per
Clause,
class is that, my lord, 33. As per Annexure A, my lord.
page,
Page is that, my lord, please. It is on 33, page number 24, my lord, arbitration class,
20,
24.
clause number
33, my lord, arbitration. It's a tender notifications, my lord.
yes. You have sent a notice.
Please, my lord. I have sent the notice also, my lord. As per annexures, please.
Annexure.
Please, my lord. P, my lord. Annexure P.
Now that is, you have sought for the invoking the arbitration clause. Now that has been served. They have
Yes.
sent a reply.
Please, my lord, they have sent a reply, my lord, through mail. That
Page,
is annexure yes, my lord, that is in page number 71,
issue notice.
please.
Yes.
6. Serial number 6.
Seeking directions of your lordship to appoint a sole arbitrator, my lords, in this matter.
What about the office objection?
Lords, I'll comply within 24 hours, my lords.
Court fee?
Court fee, my lords, has to be made, court, my lords.
Without court fee, I cannot take it. Office objections to be complied with, list the matter on date code. CMP 7. Yes.
Serial number 7.
For the petitioner, my lords. My lords, there is only one office objection, that is annexure B. My lords, we have produced a typed copy of the arbitration clause. We have furnished the copy, my lords.
In light of the submission of counsel, office objection is kept in abeyance regarding production of legible copies of annexure B. Full stop. Counsel for the petitioner undertakes that in the event legible copy of the entire document is to be produced at the time of hearing, same would be done. Which is the clause?
My lords, clause 11, it's produced at page 13. And my lords, we have also produced it in the petition in page number 5.
But this document is not legible.
My lords, we have furnished a separate document altogether, which
Page?
page 13, my lords.
No, correct.
One.
So this is not legible. So where is the legible portion?
The legible portion is produced at page number 5, my lords.
Page 5.
5.
No,
Para
that-
number 7, my lords.
That you can't say. You have to
My
give,
lords,
after the agreement, you have to give a typed copy of that portion. You can't type it in your petition.
my lords, we have also produced a typed copy of the,
Where is that?
my lords, we have filed in the count. We have given,
No,
Fine,
it must
same.
be before the court, isn't it? Office objections.
my lords, kindly notice may be issued, my lords. My
How-
lords,
how
we'll
it
do
can
the
be
needful,
done?
my lords.
That is the only office objection.
Yes, my lords, we have done the rest. We have followed.
Everybody, the office objection. Learned counsel for the petitioner submits portion of the document relied upon. Typed copy of the relevant portion would be filed in the registry. Full stop. Yes, now which is the clause?
Clause 11, my lords.
In light of such undertaking, the office objection is kept in abeyance for the present. Clause?
11.
That I can't read. Anyhow, that What
My
does it
lords.
say?
My lords, if I could read out from page number 5, it reads as, any dispute or difference or claim arising in connection with this contract shall be resolved by reference to arbitration
Yes.
by sole
Now, you have
arbitrator.
issued a notice. Have you issued a notice
My lords, the order.
invoking the arbitration clause?
Yes, my lords.
Page?
My lords, it's at page number 22. Annexure E.
Now that has been served.
Yes, my lords.
Issue notice to the respondent.
Grateful, my lords.
8.
Taken the paper publication.
On 3 occasions, you have taken out notice previously.
Yes. I've also served them on the registered address as available on the MCA website, my lords.
On 3 occasions.
On 3 occasions.
Counsel for the petitioner filed a memo. An enclosed copy of the newspaper containing notice that was published as regards the respondent. Respondent called out. Cost,
Terms of technology private limited.
no representation on behalf of the said respondent. Office to show the name of the said respondent as served in the cause list. Service is held sufficient. You have enclosed both the newspapers.
Both the newspapers.
This is the matter in the week commencing from.
13th of January.
Yes.
Grateful.
9.
My lords, I'm appearing for the respondents, my lord.
Yes.
My lords have not filed any caveat petitions in the matter. So the name of Mr. Anup Hanali may be deleted, my lords.
Notice. What has happened? Notice is served, not served.
It's served, your lordship.
My lords, I have verified the records. I have not filed any caveat petitions, my lord.
No, we'll delete your name. We'll delete.
Please, my lord.
Office to delete the name of Learned Counsel Anup Harnally, shown in the cause list as representing the respondent. The notice served.
Notice.
No, but notice
Notice has been served, your lordship. Page number 60.
through court.
Not through the.
And then? Unless anybody appears on their
Your
own,
lordship, previously they were appearing.
but they're saying they have no instruction. So notice will have to go.
Please, your lordship.
Though name of Learned Counsel Anup Harnally is shown in the cause list as appearing for the respondent, counsel for the counsel represented by colleague through VC submits that there are no instructions to appear in the matter. Please notice that notice through court has not been issued. Accordingly, issue notice to the respondent.
Please.
Office to delete the name of Learned Counsel Anup Harnally. Yes.
Please, your lordship.
This is the matter in the week commencing from.
Lord, I appear for the petitioner, Lord. Lord, the office has stated that, my lord, the respondents number 2 to 15 have been made as parties, whereas they are not parties to the joint development agreement, annexure A, my lord. My lord, I have stated in my petition, my lord, respondent number 2 to 5 are the persons and entities claiming under respondent number 1, my lord. Respondent number 1 and the petitioner had entered into a JDA, my lord.
Office objection regarding arraying of respondent 2 to R2 to
R15.
R15. is kept in abeyance. Now, where have you stated you made in light of the submission made in response to such office objection as noticed in the order sheet, office order sheet,
I have also stated in my petition.
office notes. Yes. Yes, now, what is the clause?
My lord, class 34 is the arbitration clause, my lord, page 55, my lord.
Yes, have you issued notice?
My lord, I have issued notice, my lord, at
Yes.
page number 70. my lord.
Page,
Number 70, my lord, 70. To all the respondents, my lord.
what has happened?
My lord, some of the respondent it is served, my lord, some of the respondent it has come back returned, my lord, unserved. I have produced the postal acknowledgements also, my lord, and also tracking sheets.
Issue notice to the respondents.
Please.
Yes,
Matter was allowed on 11/11. However, they are filed in IA. We haven't received the call for modification of the order.
request is made that the appointment of an arbitrator at Mangalore.
Maybe.
Both sides submit that an arbitrator at Mangalore may be appointed. Mangalore may be appointed. IA is filed by the petitioner to such effect. Counsel for the respondent submits that they have no objection. In light of the same, so and so retired district and session judge Mangalore is appointed as a sole arbitrator. In light of such order passed on this day, the order dated 11th November 2024 would stand modified to such extent. Full stop. Further, it's clarified that the proceedings would be in terms with the rules of the Arbitration and Conciliation Center, so and so, at Bengaluru. Rules will be the same. Accordingly, the reference to arbitrator in paragraph 4 of the order, as well as observation at para 4 Roman 2 is to be read in terms of the changes, modifications made as per the order passed on today. Further clarified that the venue of arbitration will be at Mangalore. Accordingly, IA is disposed of.
I'm sorry to interrupt, my lord.
Yes.
Serial number 11, my lord.
Yes.
The matter was incorrectly filed as CMP, my lord. I have filed a memo for category conversion. It's a petition under section 9 of the Arbitration Act in relation to an international arbitration, my lord. I have moved a memo on 27/11/2024 for conversion of the category, my lord. From
Otherwise,
CMP.
no amendments. Otherwise, no amendments.
Otherwise, no amendments, my lord.
In light of the memo filed, and as counsel for the petitioner submits that except for the wrong classification, no other amendments required to be made to the petition. Accordingly, The registry is directed to register the present petition as arbitration petition interim measures, APIM category. Full stop. Present petition is disposed of for statistical purposes. Registry to take appropriate action forthwith. Yes.
Obliged, my lord.
Respondent 2 and 3, my lord.
Yes.
May I make a submission?
Yes.
But I'm permitted to file power for R2. But R2 has been not been served, my lord. Since there was a criminal petition yesterday, my lord, by the client was verifying his name in that petition, my lord, he come to know that this petition is listed today. Hence, he had directed me to file power for R2. And he is not a managing director, my lord.
Learned counsel so-and-so undertakes to file wakalat for R2. You
Copy
serve
me.
him a copy.
He has been served thrice, my lord. We also picked up a paper advertisement in English at Kannada as well. It's been done. All the process has been complied.
No, anyhow, right now you serve him, he's filing wakalat. I'll fix a date.
Maybe heard in 2 weeks' time.
Office to show the name of so-and-so as representing R2. This is the matter immediately after winter vacation.
Obliged.
Yes.
Please, my lord, it's the matter. My lords were to kindly see from 14/11/2024, first listed before my lords.
Your lordship,
Consistently,
argument, your lordship.
10 dates have gone, my lord, where each time I have obliged as well. Yesterday, it was in fact the Learned Senior Counsel who asked for it to be listed today at 2:30.
Your lordship, from past 1 year, they have not moved, your lordship. We are ready now, your lordship, for a short pass.
Where are you ready? Don't
From-
say that.
Please, your lordship.
Don't say that. Don't say you're ready. He's been appearing and every time it was adjourned. We'll accommodate, that's a different. Don't say you're ready, nor make any allegations against him. Pass over.
Much obliged.
Respondent, please. Lords, yesterday I have filed my objection. I may be permitted to hand it across.
Yes.
Objections with the memo adopted.
Yes, what are your objections?
My lords, the objections are that the arbitration clause, my lords, is alleged to be contained in a lease deed between the petitioner and the respondent. The petitioner, my lords, is not the signatory, admittedly. Petitioner is the legal heir of the lesser under the lease deed. Now, admitted me, my lords, the lesser is not the owner of the property, nor is he a sublessee, nor is he enforcing any independent right on the scheduled property. The scheduled property is under the ownership of a company called Monarch Citadel, which is not before, my lords.
Now, the registered lease, it's a lease deed.
Lease deed.
So this lease deed is between Padmanabhan and?
There are two petitions before, my lords. So if my lords have CMP number 87, if I may trouble my lords. At page 82, they've produced the lease deed under which they are claiming that arbitration clause is the 82.
Yes, you represent?
I am for Silverline Resorts.
Correct.
Now, my lords, Sham Sundar is no more. It is his legal heirs who are before, my lords, who say they are the legal heirs of Mr. Sham Sundar. Now, Mr. Sham Sundar itself, my lords, reads para 1 at page 82, whereas Messrs. Monarch Citadel Private Limited.
Correct, madam. Now you are a signatory to the agreement, the registered document. There ends the matter.
No, my lords, the reason
remaining you go and raise there.
My lords, the remaining is that a very important third-party rights are being adjudicated, which the arbitrator cannot. And my lords, it's settled position today that when there are third party rights which are crucial to be involved and adjudicated upon, then the clause itself becomes non-arbitrable. And that is my submission. Today, this monarch citadel, who is admittedly the owner of the scheduled property, and admittedly, if my lords kindly takes in this compilation itself, in the petition, if my lords kindly takes page 100 at Annexure G.
No, you are the lessee.
I am the lessee, my lords, of the owner. Now, this arrangement of this lease deed, where Mr. Sham Sundar executed it.
No, you are a lessee to an agreement entered into with Sham Sundar.
Which the opening paragraph itself says, my
forget
lords.
that. Why did you sign this document?
My lords, the reason being this. The way the scheme worked, my lords, is that Sham Sundar, who is a shareholder.
That's all you raised there.
My lords, may I just...
If the subject matter is not arbitrable, it's kept open.
May I just make this submission, my lords, and my lords may see if it is arbitrable at all. This monarch citadel.
That question also can be decided there.
My lords, in the absence of monarch citadel, whether they are the owner, let us, my lords, let's.
The arbitrator decide that.
My lords, let us, my lords, take an occasion where let us say that the lease deed is held to be terminated. And arbitrator says, please hand over possession. To whom do I hand over possession?
The arbitrator, all contentions.
My lords, may I just submit one judgment then, my lords? Because Vidyadrolia itself says, in a case.
After Vidyadrolia also, much water.
No, my lords, of course, my lords, much water flowed. But the proposition on the third party rights is intact. And what it says specifically in a footnote, in such a context, where it says where there are subtenants, tenants, and lessors, lessees, in the context of a tenancy, if such complicated issues arise, then it becomes non-arbitrable. Because today, my lords, Sham Sundar is not the owner. He's a shareholder in Monarch Citadel.
That question also can be decided.
My lords, Monarch Citadel has filed a suit against them.
That question can also be decided by the arbitrator.
As to whether it can even adjudicate, my lords, my humble submission is that will be before my lords in section 11.
No.
Because what has happened, my lords, whether the party is necessary or not.
What did the last judgment that Arif case hold?
I appreciate, my lords, but may I also submit that there is equally
all other issues.
All other issues provided, my lords, that my lords find this arbitrability of the clause valid.
Is it given in that judgment?
Because may I cite Vidyadrolia?
No, come after Vidyadrolia. Come after Vidyadrolia. And then you point out. Now nothing remains.
Arif Azim.
Give me a copy. Arif Azim has settled the issue. You go to the last one and then we'll go backwards. Now you point out. They in fact considered everything and said all other issues. Which paragraph?
I'm just. I'm not wrong, page 337, my lord.
Page?
Because, my lords, the majority of this is in the context of limitation, which is also a ground I've raised.
No, somewhere there's an observation. It clarifies once again. Clarifies all other issues.
My reading was entirely on limitation. I'll point out that paragraph if I. Paragraph 57 is what my lords are referring to.
Yes, petitioner, which is that paragraph?
My lord, it is at page paragraph 70,
70.
The aforesaid decision in Vidyadrolya Supra was relied upon and reaffirmed in another decision of this court in NTPC
I think in the
versus.
copy I have given, my lords, it will be para 71.
Yes.
The standard of scrutiny to examine the non-arbitrability of a claim is only prima facie. Referral courts must not undertake a full review of the contested facts. They must only be confined to a primary first review and let facts speak for themselves.
You're reading at para,
Lord, I am reading at my.
it starts with the
The aforesaid decision in
Para
Vidyadrolya.
71.
In that, there's within that, there's a paragraph number 27.
Yes.
The standard of scrutiny to examine the non-arbitrability of a claim is only prima facie. Referral courts must not undertake a full review of the contested facts. They must only be confined to a primary first review and let facts speak for themselves. This also requires the courts to examine whether the assertion on arbitrability is bona fide or not. In the present case, in the before the commercial court, they mock us for not initiating arbitration. And here they say that arbitration cannot be issued.
And then it says, if
The
there's a
prima
doubt.
facie scrutiny of the facts must lead to a clear conclusion that there is not even a vestige of doubt that the claim is non-arbitrable. On the other hand, even if there's the slightest doubt, the rule is to refer the dispute to arbitration. The limited scrutiny through the eye of a needle is necessary and compelling. It is intertwined with the duty of the referral court to protect the parties from being forced to arbitrate when the matter is demonstrably non-arbitrable. In this particular instance, they have signed the agreement, the lease deed. It has been termed as a legitimate interference by courts to refuse reference in order to prevent wastage of public and private resources. Further, as noted in Vidyadrolya, if this duty within the limited compass is not exercised and the court becomes too reluctant to intervene, it may undermine the effectiveness of both arbitration and the court. Therefore, this court or a high court, as the case may be, while exercising jurisdiction under section 11(6) of the Act, is not expected to act mechanically, merely to deliver a purported dispute raised by the applicant at the doors of chosen arbitrator, as explained in DLF Home Developers versus so-and-so, in Geo Miller, so-and-so.
Yes, all questions now are to be decided there. Even if there's a doubt regarding arbitrability, if there's a doubt, then it has to be referred.
My lords, may I submit that these two paragraphs, para 71, in no manner dilutes my position under Vidyadrolya, my lords, which states.
Arif Azim is a reiteration of the other case.
Please, my lords.
By the same bench.
And also of Vidyadrolya, my lords. They are not contradicting Vidyadrolya in any manner.
No,
My submission is only this, my lords. As of today, there is a company called Monarch Citadel, which is the owner, and these are not anything beyond prima facie, my lords. I'm reading from the petition. I've not even taken my lords to my objections. I'm reading purely from the petition. At para 1 of the lease deed itself, it says that they are not the owners, that they're shareholders of this company. Admittedly, my lords, that company has filed a case against them saying, please don't hand over possession. My lords, may I take my lords to page 100 of their petition? I'm not touching my objections, my lords.
My lord, but there is no reason for the respondent to be so concerned about a third party who is not even bothered to file any case against either the respondent or the petitioner.
A case is
Why are they
already
worried?
filed, my lords. There is
Then
an OS,
he
is
will-
what I understand.
Then he will.
Just 1 minute. Now, Monarch Citadel and the petitioner have disputes.
Monarch Citadel is not before my lords.
Correct.
Monarch Citadel is only concerned to the extent that they are the owners, and today the purported lessors before my lords are claiming possession over a property that doesn't belong to them under a lease deed.
Who have you been paying rents to?
My lords, till some time back, I was paying the rents
To me.
directly to the petitioner's predecessor, that is parents,
Huh.
or
No,
the original
me.
lessors,
The
as I
lessors.
may say.
Anything I say will only damage your case.
My lords, may I just make one more submission? My lords, may kindly take page 100.
No,
My
no,
lord,
you have
all
been-
that remains.
You have been paying rents to them.
I've been paying rents, my lords, because they are also shareholders just like I am.
So all
The
this-
entire, my lords, today, if there is a company,
No,
all
no.
of us are shareholders in the company.
Are you a tenant?
Inst-
Are you a tenant or not?
I am a tenant, my lords, to some extent. I am part owner of the property as well. We are all shareholders
So that
of,
correct. That is a question of fact and law, which we cannot decide.
my lords, my only submission is this. today, what contentions can they or we take before the arbitrator in the absence of monarch? If I may take my lords to page 100, I will just show my lords what issues they
arbitration,
have
not a
raised.
full-fledged trial here. What contentions I take is what I take before the arbitrator.
No, I cannot take any contention today.
In their
Half
statement
of
of
those
objections, they
contentions
say
will be in
we
the
have not
absence
made
of
any,
the owner.
in the statement of objections, they say we have not made any attempt to commence arbitration.
Now suit was filed earlier.
No, my lords, they had filed a section 9 petition against me, which got disposed.
What was the stand taken by you there?
Same, man. Same, that they are not the owners, that they are only shareholders, that they're claiming to be owners and seeking, in fact, my lords, subsequent to that, before filing of the CMP, after the section 21 notice, they have tried to evict me and take possession of a scheduled property which doesn't belong to them.
No, but you have signed the lease deed.
My lords, I cannot hand over possession to a person who is not the owner, admittedly, as per the lease deed itself.
That somebody else will recover possession from him if he is not entitled. That's a different matter.
No, so my lords, then we will create a situation, my lords, where the award may possibly hold in their favor to say hand over possession to them, which will become a final award, which cannot be challenged by the true owner.
No, why are you bothered about
I'm the true owner, my lords.
Then she can initiate it through the true owner, my lord, if she is
I'm a shareholder in Monarch Citadel. Monarch Citadel has already initiated an OS. I have placed the order.
What this means is that Monarch Citadel is an avatar of her, my lord.
Just wait. Yes.
No,
So
they are
what-
shareholders also, my lords, in Monarch Citadel.
Yes, yes. What other objection you have raised? Let us go through your objections.
My lords, may I just take my lords to page 100, my lords? I'm only reading from the petition. I'm not going beyond the petition. Page 100 of their own petition. And this is in their narration itself, say these are the contentions that they have raised.
But her objections are that it is barred by limitation.
Kindly take page 100, my lord.
Yes.
Please see, my lords, these are the other shareholders, Dawood Mohammed, Mariam Mohammed. Serial number 4, Monarch Citadel. And then silver line, which is me. We're all shareholders of Monarch Citadel. And they raise multiple issues, which my lords, just as an illustration, page 102, kindly take I. For the smooth development and completion of proposed project and development, a deed of venture partnership was signed between all 4 of you on so and so, where all of you are treated as partners with the right of sharing ratio of the property and the firm accounts profits lost therein. The said partnership is still in force and not dissolved. Firm name is Monarch House. Partnership defined so and so share. They allege that their share is incorrect in Monarch. The dissolution of the firm happens thereafter. This is their own letters. Kindly now, my lords, take the next page, 104. Para O in 104, my lords.
No, but why you took 2 years almost to file a statement of objection?
My lords, we were attempting settlement on the last occasion that we had submitted, my lords.
Yes, now you take me to the lease deed first. Let's have.
My lords, may I just finish reading their own claims, my lords?
No,
I'm
that
reading
means-
their letter.
No, let me understand the lease deed.
Please, my
Then we will. Yes.
page 82, my lords.
Yes.
Very first parameters, whereas Messrs. Monarch Citadel Private Limited formulated a scheme whereby purchasers of shares of the said company would be entitled to constructed area corresponding to such purchase of shares as recorded in the articles of the company. And whereas the lessors herein has acquired 33620 shares of the said company, as a result of which and by virtue of the memorandum and articles of association, lessor has become entitled to 8 units in the building constructed as the property bearing number so and so, measuring so and so, more fully described in 1 to 8.
Now this 1 to 8 has been allotted to the petitioner's share.
Yes.
They that their shareholding corresponds. Their name is not shown. It is one khata.
No,
As of today, there is one khata,
I'm
1
saying
unit.
a reading of the lease deed says this lessor becomes entitled to 8 units.
8 units in the building constructed. May I also point out the nature of the building, my
That's
lords?
okay.
It is not an apartment complex where it can be distributed.
Yes, just one.
It is a hotel.
No, just one. 1
Please.
to 8 of the schedule are the 8 units.
1 to 8 of the schedule here.
Are the 8 units.
Are the 8 units.
Now you are in occupation of 1 to 8.
1 to 8.
You have been paying rents to Sham Sundar.
Yes.
I was paying rents to Shams.
After this, when did he demise?
But if I'm not wrong, 2021, my lords.
After that, you have stopped paying, is it?
No, my lords. Their allegation is that from 2010, which is why my second contention on it being time barred. their computation of dues starts from 2010. They allege even before his demise from 2010 that there are dues.
No, after the demise of Shyam Sundar, you have been paying rents or no?
To his account, I paid his rents, my lords.
We
Only, yes, only after, because that is equivalent to a dividend he is receiving against his shares.
That will.
So as shareholders, we have been,
So in the agreement, where is your dispute? You are saying that now it's a monarch is the owner, etc. In the agreement, that doesn't come out.
in the agreement, my lords, para 1 itself shows that they are not owners. Today, without Monarch Citadel, who is the owner of the property? If today, what grounds do they have? Of course, my lords, rental apart. That's why I was taking my lords to
No,
page
no.
100.
No, we are only on the rental aspect of
My
it.
lords, what is the consequence of the rentals? If my lords, their contention is that they are limiting their claims solely to the purported due rentals, then my lords, I appreciate what my lords are
So the
saying.
dispute
Today-
as of now,
Is
as
the-
of now,
As of now is on the lease deed.
lease deed.
Is on the lease deed as of now.
Lease deed what, my lords? The square footage, the rentals, the eviction.
Just now the dispute that is sought to be referred for arbitration
Yes, ma'am.
in terms of your notice
Yes.
is with respect to,
Is with respect to non-payment of lease.
just take me to that.
Kindly turn to page number 175, my lord.
175.
Annexure R. This is a notice dated 6th of December 2022. It's not on page number 176, my lord. We are the legal heirs of late Mr. So-and-so. Kindly refer to the above lease deed dated 30/8/2008 executed between late Mr. So-and-so and the respondent wherein the properties held by late Mr. So-and-so were given under lease for running a hotel business for the consideration agreed by the parties. The lease deed was executed for a period of 15 years commencing on 8/8/2008. Therefore, the same is valid under 7/8.
Quick matter of reference.
It is submitted that clause 2.3 of the lease deed specifically deals with the enhancement of consideration. However, it is understood that you have not been complying with the terms of the lease deed, particularly with respect to the rents payable and the periodical enhancement to be made. It is with respect to payment of rent.
Yes.
As per clause 31 of the above mentioned lease deed dated so and so, any dispute differences between the parties arising out of in connection with this deed shall be settled in arbitration.
Same petition will be filed there
Yes.
My lords, may I
on reference.
just that sentence, my lords, which says, however, it is understood that you have not been complying with the terms of the lease deed, particularly with respect to rentals. If today their contention is, yes, it is only with respect to rentals, my submission is this. Today there is a suit, I understand, by Monarch. There is a stay operating against them and me from handing over any possession to them. Today, if they are going to make that also a part of the claim before the learned arbitrator to say, I want possession, because there is a violation of the terms of the lease deed, my lords, then will there not be a conflict where there is an OS filed by Monarch, where there is an injunction operating against me from handing over, and there is also an award stating handover. If their submission is that their dispute is only limited to the purported rental dues under the lease deed, my lords, I'm in my lords' hands. I appreciate what my lords are saying on that. But their claims, and that is why I was emphasizing on page 100.
Let us see and consider. The petitioner.
My lords, may I only submit on page 100 for one.
Yes.
That is their preceding notice, my lords, which has the details of claims.
No, we don't know what claim is going to raise before the.
I appreciate, my lords. I appreciate what my lords say. My only concern is if these were the claims, my lords, then in the absence of the necessary party and when then they have already filed another suit, it should not lead to conflicting situations.
But why is the respondent does not explain why she is so
I'm a shareholder, my lords, majority shareholder. I don't think there's any malevolence, my lords.
Then the
in
majority
arguing for a
shareholder.
majority shareholder in a company that owns.
Terms of. Sought for appointment of an arbitrator, sole arbitrator for adjudication of disputes that have arisen between the petitioner and respondent. Full stop. Reliance is placed on clause 31 of the lease deed dated 30th August 2008 at annexure F. Peruse the lease deed at annexure F, which is a registered lease deed entered into between Mr. C. Shyam Sundar and the respondent herein. It is submitted by the petitioners that after the death of Shyam Sundar, the present petitioners are the legal heirs. In this case. Present petitioners
Claim
are
to be
Yes,
the
my lord.
legal heirs, my lords, because
My lord,
I,
claim to be the legal heirs.
She is the mother of the,
It's okay. Claim to be the legal heirs. It's further submitted that disputes have arisen in relation to the relationship which is in relation to the lease deed of lease between the parties, and in light of which the reference to arbitration is sought to be made. Perused clause 31, which provides for reference of disputes for arbitration. Learned counsel appearing for the respondents submits has filed detailed statement of objections. The objections raised are that the owner of the property is one Messrs. Monarch Citadel Private Limited, in which Shyam Sundar and Padmanabhan were shareholders. It is specifically contended that the petitioner herein is not the owner of the property. Further submitted that a suit has been filed by Monarch Citadel against the petitioner and respondent in OS 220 of 2024, which is pending adjudication, and in which there is an order of restraint against the petitioners from interfering with the possessory rights and possession and ownership of Messrs. Monarch Citadel. It's further submitted that the claims, that the substantive claim made by the petitioner is barred by time. Comma. Various other contentions have been raised. Full stop. Learned counsel appearing for the respondent submits that in the absence of Monarch Citadel, reference cannot be made as it would interfere with certain orders passed by the civil court. Next. It is to be noticed that the lease deed, registered lease deed, has been entered into between Shyam Sundar and the respondent herein. It is not in dispute that it is also a matter that comes out from the deed of lease that units number 1 to 8 are in possession of the respondent. The respondent had been paying rents to Shyam Sundar, and later, after his demise, to his account.
please move.
To his account, which is the stand by the respondent. Next. Though various contentions have been raised regarding Monarch Citadel, all such contentions cannot be adjudicated upon in the present proceedings. Prima facie, full stop. Prima facie existence of agreement with a clause for arbitration would by itself be sufficient to make a reference to arbitration. When the deed of lease, when a plain reading of the deed of lease makes out a relationship of lessor and lessee, and the respondent has been paying rents earlier to Shyam Sundar and subsequently depositing it in words of the respondent in the account of Shyam Sundar. All other contentions, including that of ownership, are matter as well as implication of proceedings before the civil court in a suit, are matters to be decided by the arbitrator. Fact that there is a dispute is borne out from the notice of the petitioner at annexure R. Petitioner specifically asserted regarding disputes that have arisen regarding non-complying with terms of lease. Accordingly, case is made out for exercising power under section 11(6). All contentions, including limitation regarding claim made, are matters to be left for adjudication before the arbitrator.
May I request, my lords, that there are some contentions we would like to raise as to the lesser-lessee relationship as well as the square footage that they claim to be owners of, because some shareholding was thereafter transferred.
All
Those contentions may also be left open, my lords.
contentions regarding relationship as raised, relationship between the petitioner and respondent as raised in the statement of objections, comma, the area of occupation, as well as other objections raised in the statement of objection, are kept open and would be subject to adjudication in the proceedings before the arbitrator. Accordingly, see so and so retired,
Leave it to my lords.
retired district judge.
District judge.
District judge is appointed to enter upon reference. Yes,
Before the Bangalore Arbitration Center.
yes. Now, what is 16 and 16.1?
Yes, my lord. They were two brothers,
Both are identical,
both identical.
separate orders though.
Yes, my lords, because they're
Separate.
separate lease deeds.
But before the same,
Same order.
Please.
same order,
My
same
lords,
arbitrator.
I
Same order.
filed a memo adopting the objections, my lords,
Yes.
instead of duplicating the
The
papers.
counsel for the respondent has filed a memo adopting statement of objections filed in CMP 86 of 2003. Objections are filed in 86.
87, my lords. 87, the objections are filed.
To
86.
the order in 86, first.
Mr. Shyam Sundar is in 87, my lords.
Order in 87 of 2003. Order. Now I've dictated in 87. 87 of 2023. 86 only, same order. Counsel for the respondent in CMP 86 of 2023 has filed a memo and adopted statement of objections filed in 16.1.
Obliged.
Lords, I appear for the respondents' minutes.
Order sheet. Yes. 17. I think I'll have to adjourn these matters. I have some urgent part-heard matters. Any matter only by consent you can make a mention. The rest dates will be allotted in the first week of January.
Serial
Yes.
number 26, my lord, there is a slight urgency. The
Hmm.
service agreement that I've annexed out of which the dispute resolution clause actually elapses on 29th of this month, my lord.
So notice must go.
Yes, my lord.
I'll take up that. First time notice matters I'll take up.
Yes,
One by one. List the matter in the week commencing from. Yes.
Great.
My lords, for the petition, my lords, similar orders may be passed how it was passed in the earlier CMP, my lords. In this, the notice has already been issued. It's just that the respondent has once again refused to accept the order, my lords. This honorable court was pleased to allow a CMP
We'll have it tomorrow.
much obliged, my lords.
It's
My
a
lords, tomorrow.
same respondent.
My lords, different respondent. However, my lords, similar purchase contract and everything, my lords.
Tomorrow, let us.
My lords.
17, I'm sorry. The second list. Second is first.
Serial number 24, my lords.
No, just only 19.
I appear for the petitioner in this matter. It's arbitration clause, it has, at page number 27, 20.6A subclause B, page number 27.
Clause
20.6A subclause B.
International arbitration.
That is A, B,
Uh,
on the right hand side.
No, this is
Domestic,
domestic.
please. It's in Mangalore. Domestic contract arbitration shall be conducted in accordance with the laws of the employer's country. Place of arbitration is at Bangalore. I invoke the arbitration clause on 4/5 May 4th, annexure J, page number 57. There was a variation in the bills of quantities. Hence, they were supposed to pay me the amount. By suggesting the name also, page number 61 is the,
Take out notice.
please, respondent number 1 is the state government, let the,
AG is directed to accept notice for the first respondent. This would be in addition to emergent notice
please.
to respond. Number 1, emergent notice to respondent number 2. List the matter in the week commencing from.
Please.
Yes.
20 minutes insofar as other shore is concerned. There were 2 contracts.
Good.
This page number 98 is the arbitration clause.
Page
98 minutes. 20.6. On the left hand side, 20.6B. If the contract
Yes.
contract is with the domestic contract, arbitration in the proceeding conducted in accordance with the law of the employers, that is Bangalore.
You have sent
Minutes.
a notice.
Yes, annexure K to both the respondents by invoking arbitration clause as well as suggesting the name. However, even though it is served, they have not responded. Annexure L page number 122.
AG is directed to accept notice for the first respondent. This would be in addition, same order.
Obliged.
Here for the petitioner, please.
Yes.
This matter was directed to be listed today, my lord, from last week.
For respondent in this matter. Mr.
That
Ajay
is-
he was right here.
You're correct, but now I'm not able to pass orders. I'll have to give a date only.
My lord, simple agreement of sale, my lord, wherein there is an arbitration clause, my lord. This
What is your objection?
My lords,
Have you
it's,
filed?
there's no
objections are
privity of
filed, my lord.
contract, my lords. There's
Objections
between
are filed, my
deceased
lord.
person. It is Mr.
Just one. We'll repeat these other matters, which I'm not taking today. I'll repeat it tomorrow and day after tomorrow.
Please.
My lords, can it be?
22 in the 20,
21 and 22 both. my lord.
I detailed bit. 21 in the 21 tomorrow, 22
22 is also similar.
tomorrow, 23. You know done.
I'm
23.
appearing on behalf of the petitioner in this matter on serial number 23, Your Lordship.
Can we take it up immediately after winter vacation?
Please, Your
Let me
Lordship.
list the matter in the week commencing from. Yes, 24.
My lords, 24, I appear for the petitioner. My lords, a similar matter was there yesterday. My
Much
lords,
obliged, your lordship.
under a lease agreement. My lords, and clause 15.2 at page 29 is the arbitration clause. Notice can be issued, my lords, is between the same parties also.
Page agreement.
Page
clause.
29, my lords, clause 15.2 is the dispute clause.
18 point.
My lords,
Clause?
15.2, my lords.
Page
Page
numbers.
29.
Page numbers are missing. 29 is not there. After 19, it straight away goes to page 30. You
Just
rectify.
before the 30th page, my lords.
No,
20.
before 30th, from 19 to 30, no pages only. I don't know what scrutiny they've done. All pages are missing. I don't have one page up between 19 and 30. List it is noticed that between page 19 to 29, pages are missing. Petitioner to rectify such defect. List the matter on. Yes. Next. Yes.
The dispute is pertaining to an agreement of sale, my lords. Page
Clause,
number 14,
Page.
number 14, my lords. Clause number 23, my lords.
Page.
14, my lords. Clause number 23.
You issued notice.
I have issued notice, my lord, as annexure B, my lords, dated 19/9/2024. The acknowledgement is at page number 24
Issue notice.
of that.
The dispute resolution clause is at page number 50, my lords. It does not have a clause number. It is in internal page 23 of the agreement. And I've also issued notice at page number 90, my lords.
You issued a notice.
Yes, my lords. Page number 90, my lords.
Issue notice. Great.
Hearing for the petitioner is a matter arising from a tender agreement. Lordship may find the general conditions of contract, clause 24 at page 81.
Page?
Page 81. Clause number 24, bottom of the page. Procedure for resolution of disputes. This was an institutional arbitration clause. Page number 81. In furtherance of this, if your lordship were to kindly turn to page 91.
Now you have issued notice.
I have issued notice that your lordship will find at page 451 in volume number 2. I have issued notice through email and through regular course. I have written to the Indian Council of Arbitration in Delhi because that was the institutional arbitration center. Now they separately communicate and call upon the respondent herein for concurrence for appointment of an arbitrator that your lordship finds at annexure AE page 457. However, pursuant to that, there is no response. Now that email by virtue of which ICA says there is no response is at page number 462. 462, lordship may kindly see. Please find attached postal track report of letter dated 17/10/2024 sent to the respondents.
To take out notice.
Please, one submission, your lordship. If I may also be given liberty to serve Mr. Viresh Budihal, who also appears for the instant respondent in other matters.
Issue notice, petitioners at liberty to serve learned counsel.
Viresh Budihal.
So and so. Who stated to appear on behalf of the respondent corporation in other matters.
Please.
Yes.
I'm grateful.
My lords, appearing for the respondent in this matter.
Appearing for the petitioner, my lords.
My lords, I'm filing the minutes of meeting, my lords, held by the Principal Secretary of the Housing Department
No, now what, some settlement has happened?
Yes,
No.
my lord.
No,
In that
no,
matter-
absolutely no talks have taken place in relation to the claims, my lords.
Lords,
There
I
is
think
no
finding a
attempt
memo-
that has been made till date, my lords.
Okay, I'll fix a date, but I can't hear it now. I'll fix a date.
my lords, I am filing the minutes of
It's,
meeting, my lords.
Filed by the respondent are taken on record. Petitioner, you also want to file
We'll
something?
also be filing one memo, my lords. Response be
Petitioner.
issued to these minutes.
Petitioner,
My lords, the
Fine.
principal secretary intends to hold another meeting, my lords, for further settlement.
petitioner files.
My lords, absolutely no communication has been made to us, my lords, about any meeting.
Just one, petitioner files a memo and produces the communication exchange with the petitioner and response. Same is taken on record. This is the matter in the week commencing from.
My lords, kindly date in mid of January, my lords, or last week, my lords.
My lords, matter has been filed.
In the second week. also. Yes.
Much obliged.
Petitioners are seeking for compassionate appointments. In the light of death of first petitioner's husband while in service,
AGA is directed to accept notice for respondent 1 and 2. Mysore City Corporation,
Geeta Devi Papa.
Geeta Devi for 3 and 4. This is the matter immediately after winter vacation. Yes,
Petitioner applied for a post of Anganwadi worker. Our application is submitted successfully. Though they are successfully, they issued an endorsement that your application is not e-sign verification. Kindly see page number 15 at Annexure C for a moment. What happened, petitioner is a widow and was secured 87.66%.
take out notice. Huh? Take out notice. Issue notice to the AGA. Is directed to accept notice for respondents 1 to 4. Emergent notice to respondent number 5. This is the matter in the week commencing from. Yes.
Interim order may consider.
No, that we'll see. Only after hearing. Yes.
Just a mandamus to consider releasing the petitioner's death cum retirement gratuity. Petitioner was working in the Public Works Department. He retired on 31/7/21. Annexure B, typed copy of my lordship, could find page 15.
AGA accepts notice for respondent 1 and 2. This is the matter in the order.
My lords, just a mandamus to consider because
But let them at least find out what will happen if we give a mandamus. They will
Because
not see.
it is their own communication, which is just pending from the last 1 year, 16th,
Let them
16
verify.
verify.
One date, let them verify. It's
please.
the matter in the orders list in the week commencing from.
Great,
I'll tell you why mandamus I don't issue.
please.
So there was a representation to rename a heritage lake and we issued a mandamus. Then the corporation said, we'll consider. And then they filed contempt. So can we rename Kabban Park or something?
I understand.
So one date, let's.
No,
Yes,
great.
yes, next.
4. Serial number 4, sorry.
I appear for your lordship, this is the matter I mentioned. In fact, seeking regularize the similar matter in so far as English lecturer is concerned.
Yes, yes.
That is
So it's not covered by in the sense, there was a recommendation. Here, there is no recommendation. But the operative portion could be modified to that extent. Because kindly see that order.
lordship,
No, these are all granted aid. They wanted to be admitted to granted aid, but the prayer is structured as a regularization prayer. So in the earlier round, where my lords, in one of the cases, this was also connected. The court heard it separately, my lords, and that was pronounced. My lords have that order, my lords.
Yes.
yes.
WP number 42847.
Yes.
There, my lords, paragraph number, I'll just point out. my lords.
Paragraph number 9.
My lords, may kindly see para 5 minutes, para 5.
Yes.
Para 5 minutes, the last 5 sentences, my lords. Citing the recommendation made by the joint director, which is evidenced as per Annexure F, he has vehemently argued that petitioner is entitled to gain benefits of regularization as she was appointed against the sanctioned post and she possessed all requisite qualification to be considered to the post of English lecturer. Now, my lord, subsequently, para 9, court has considered, my lords, that they have worked for some time. And finally, in page number 10, last 3 lines, my lords, even if regularization may not strictly apply under the circumstances of a grant in aid institution. Para 10.
Can I have it tomorrow in the preliminary hearing?
Please.
Please,
The matter tomorrow,
please.
the preliminary hearing list. I have some parted notice.
Please.
5,
I'm for the petition, my lords. There are 2 office objections, minor office objection that may be overruled. Legible copy of the annexure E and page number 42A is repeated, my lords. That may be overruled, my lords. Annexure E, I have produced it in a similar petition.
Date of events,
That is all complied, that is complied.
will comply.
Complied. Only 2 objections are left out, my lords.
Manjuna.
We have complied everything and the office has raised 2 more office objections.
First,
Notice may be issued, my lords.
no, first complaint. No, but the office has raised that those 3 office objection, including date of events, not chronological.
It is compliant, my lords. Now the registry has raised 2 more office objection after the compliance, my lords. Page number 42.
Onwards is not correct.
No. 42, after the 42, we have mentioned 42A, my lords. It should be in a continuous.
No, but first one, date of events, I don't.
That is compliant, my lords. After the complaints, we have annexed all the documents, legible copy, typed copy, everything.
AGA is directed to accept notice.
1, 2, 3, 5, 6, my lords.
Respondents 1, 2, 6. Office objections to be complied with before within a week. Is the matter after winter vacation.
Similar matter, notice was issued last week, that may be connected with this.
List along with WP number
30046 of 24.
6, serial number 6.
Much obliged.
Office objections are complied. Actually, I have taken hand summons also. But the respondent number 4 and 5 have not appeared in spite of taking hand summons. They have received court summons also. But I've been working since last 13 years. Well, my interim relief is not to disturb me till next date of year. Because on 14/10, without informing, they have conducted an interview. I was not called for.
no, but now unless
ಅಲ್ಲ ಅವ್ರಿಗೆ ಬರ್ತಾ ಇಲ್ಲ.
no, correct. Unless you are selected, how you can continue?
No, my lord, I have
Only
produced-
say till regular appointments are made, you
No,
can
no,
be permitted to.
No,
continue.
I have completed my NET also. I'm a MA graduate. I have completed my NET. I have produced all the certificates.
No,
I have
but-
been working since last 13 years
Correct.
without any break.
No, that is on what temporary basis?
No, it may be on temporary basis. Maybe on, but the nature of work is full time. Nature of work is full time.
No, but in case somebody is selected.
No, my only my relief is not to disturb me till next date of year. Because vacation is coming,
The respondents are restrained.
not to
from-
disturb my service.
Restrained from terminating the services of the petitioner in the next day. This is the matter in the week commencing from.
7.
Miller, kindly have this matter day after tomorrow. There is some urgency, Miller, because the salary is not paid to the petitioner for the last 6 months, Miller. Therefore,
Now he has transferred to some other college. That is the investment I have got it.
I will
He has to
inquire,
go and report to some other college now.
I will inquire, Miller, for that
Okay.
purpose only kindly have.
Got
it tomorrow.
Your lordship on
Salary is not paid for the last 6 months.
2/12/2024. Government has to 2/12/2024. He has transferred to some other college. By virtue of this transfer, your lordship, he need not be party to this, my proceedings.
Just read it. Just read it.
ಮೇಲಿನ ವಿಷಯಕ್ಕೆ ಹಾಗೂ ಉಲ್ಲೇಖ ಸಂಬಂಧಿಸಿದಂತೆ ಭಗತ್ ರಸಾಯನಶಾಸ್ತ್ರ ಉಪನ್ಯಾಸಕರು ಕಾರ್ಯಭಾರ ನಮೂದಾಗಿರುವ ಸಲುವಾಗಿ ಸರಿದೂಗಿಸುವ ಸಲುವಾಗಿ ಅಗತ್ಯ ಇರುವ ಅನುದಾನಿತ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜುಗಳಿಗೆ ವಾರದ 6 ದಿನಗಳು SMS ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜು ಬ್ರಹ್ಮವರ ಕಾಲೇಜು ನಿಯೋಜನೆ ಮಾಡಲಾಗಿದೆ. ಕಾರ್ಯನಿರ್ವಹಿಸಲು ಆದೇಶಿಸಿದೆ. ನಿಯೋಜಿತ ಕಾಲೇಜಿನಲ್ಲಿ ಕರ್ತವ್ಯ ಹಾಜರಾಗಿರುವ ವರದಿಯನ್ನು ಈ ಪ್ರತಿಯಲ್ಲಿ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿದೆ.
Memo filed with the letter of the Deputy Director, School Education,
ಅಲ್ಲ,
Shala Shikshana Ilakha. Huh?
Deputy Director, ADP, PU.
School Education. School
Deputy
Education.
Director, Public Instructions.
Public instructions, which prima facie indicates petitioner has been transferred. For the say of the petitioner, list the matter in the week commencing from. Yes, interim order in operation in 7.1.
Yes, sir. 2.59.
To continue till the next date.
My lord, salary is not paid from June, my lord. My lord, there, I
But
reported
till-
that college, my lord.
No,
where-
but till 2/12, his salary must be paid.
ನಾವಲ್ಲ,
Government.
ಅಲ್ಲಿ ಹೋಗಿ ರಿಪೋರ್ಟ್ ಆದ್ರೆ ಅವರು ರಿಪೋರ್ಟ್ ಮಾಡಿದ್ರೆ ಇದು
No,
ಮಾಡ್ತಾರೆ.
no, that's a different. No, till needless to state, is the full stop. If the petitioner grievance, that salary has not been paid, government to verify until the order of 2/12/2024 for the work done by the petitioner. Needless to state, steps must be taken for payment.
Salary not paid from June, my lord, June.
No, done.
He has transferred one college, there he has not reported. He again another transfer now.
Yes,
8. Shivshankar is
this is the matter after in the week commencing from. Yes.
pass out matter, serial number 4, Ajit PP. MR.
Petitioner in this matter, my lord.
Yes.
The representation has reached the concern, but when to consider the representation, my lords, they have visited the spot. The same kind of building was being constructed over there. So they couldn't identify on which PID number needs to be notice should be issued. And my instructions, they have tried to contact the concerned petitioner also, but there was no response from the petitioner to show that building. So it not been considered, his representation has not been
So
considered.
we'll call it after vacation.
Please, my lords.
Meanwhile, I'll observe that on the basis of their complaint,
Please, my lord.
action may be taken as per law.
Please.
Where is the complaint?
My lords, the complaint is at page number 66, my lords, annexure J. We've given 3 representation, my lords, one to the Assistant Commissioner, Joint Commissioner. Yes,
The
annexure-
petitioner submit.
annexure J1, page 68, they have given representation to AEE, he is the concerned person. The
petitioner
68,
submits
my lords, J1.
That representation is made to the Assistant Executive Engineer BBMP regarding the illegal construction of respondent 4 and 5,
Please, my lords, 4 and 5.
and no action has been taken. Third Council, Inchana accepts notice for respondent 1 to 3, emergent notice to 4 and 5. In the interregnum, the respondents to take necessary steps as regards J1 as is permissible under law. List the matter in the week commencing
Order.
from.
Interim order may be granted, my
So that
lords.
we'll see, let them do it. We'll record that and there ends the matter.
Very,
Yes. Shorter date, shorter date. Yes.
great, my lords.
You have to go and see the officer.
Very well, my lords. I will follow it up, my lords. I've been instructed that my client has gone and followed it up, but then nobody has come and visited the spot is what
Three
my
buildings on the
instructions are.
same side, so the-
Can't simply,
There are 3 buildings across, my
no,
lords.
they're saying something else.
Please.
10. Sunil Kumar H.
Petition, my lord.
Yes.
That I pay for the response.
Yes.
Lord, my instructions are that, my lord, their tenure, they've been here, working here for more than 20 years, my lord, so the tenure, my lord, would not count. My lord, the rule says, my lord, if your lordship may kindly take the rules, my lord.
Yes.
May I pass on the rules, my lord. Lord, the rules, my lord, your lordship, Lord, I'll just read the rule number 2, my lord.
Last time it was given to lordship.
These rules shall be called as Border Security Force. Your lordship got it? Page 11 of the petition, huh?
Yes.
Please, my lord. This rule shall be called as Border Security Force Rules, Deputation 2002. These rules shall apply to all members of the force except the following: sportsperson who are the members of the central team of various disciplines, members of the band team of the frontier headquarters and training institution. Therefore, my lord, these rules shall not be applicable for the band personnel. This is my first submission. The second submission is this, my lord, they have served in this frontier for more than 20 years. There's only 2 submissions of mine, my lord.
The rules don't apply.
The rules don't apply for the band. Third submission, you know?
Discontinuation of the-
And the third submission is this, my lord. In view of the discontinuation of the band, they've transferred, my lord.
2 submissions, my lord. In the same rules, lordship may see, these rules shall apply to all the members of the force except the following. In that last, my lord, provided that the Director General shall issue departmental guidelines regulating the transfer or tenure of the personnel mentioned at clause 1 to 5. So there are separate guidelines which are issued to these people. These are all band personnel. Second, my lord, my respectful 2 submissions.
No, but those guidelines we don't have.
So that they will have to produce, my lord. Next, my lord, I have challenged the very order. Lord, even the Honorable Supreme Court says any administrative order passed by any authority should also contain reasons as to why such action is taken. I'll produce 2 judgments right now before lordship. Now, there are 2 bands which are operating in Bangalore. One was the original band which started in the year 1999.
So that is on
Lord,
merits. That
please, may I make one more submission, my
is
lord.
on merits.
May I make one more submission. My lord, the order was passed, when is that? 21 November 24, that is at Annexure C, page 41. After that, my lord, the petitioners, they've given a representation which is not dated. My lord, for the time being, my lord, we'll consider this representation and pass orders that
Page?
page 41. It starts from page 17, my lord.
Presentations.
These representations, undated representations, my lord, anyway, these are the part of the
Yes.
petition, my lord. We'll pass orders thereafter, my lord,
Till A10. Till A10.
till A11, my lord, till A11.
Let us see, let them consider.
Please let them consider. Till then, let them not. give
Therefore,
effect
my
to
lord,
the order.
Petitioner.
I just wanted to inform my learned friend, since, my lord, I also know it is in the mid of the year, June 31st, as per the guidelines also, my lord. Therefore, my lord, since they've given the representation, we'll consider and pass orders. My lord, till then, let the matter be pending before this court.
Petitioners. Shall we dispose of, keep it pending?
Let the matter be pending.
Petitioners. Called in question correctness of the order at Annexure C insofar as the petitioner is concerned. Whereby petitioner has been placed at the disposal of FTRS which in effect is an order of transfer. Several contentions have been raised by the petitioner, including the transfer is effected before in the middle of the academic year. Third, DSJI Shri Shanti Bhushan submits that pending further proceedings, without prejudice to contentions raised.
Lord, let that be the order of the court.
Correct, without prejudice to contention, full stop. DSJ Shanti Bhushan submits that petitioners have no vested right. Full stop. However,
Court officer.
matter requires
Court officer.
a stand by the respondents in writing. In the interregnum, in light of the submission of counsel for the petitioners, that is, representations have not been considered. The representations at annexure A to A11 are directed to be considered during the pendency of the present proceedings. Needless to state, till such consideration, the respondents are not to give effect to the order at annexure C.
Please.
Matters, list the matter in the week commencing from. Yes.
Please follow. Grateful. Grateful.
Great or grateful?
Grateful. Sorry, my lord, it was
Yes.
not audible, sir.
Yes, yes.
My lord. This ADA case, my lord. My lord, may I read that first para, my lord? Only two paras, then I'll go directly to the observation of the court, my lord. My lord, if the progress of our country, may I read, my lord? If the progress of our country,
Page,
my lord, page number 19, my lord. If the progress, my lord, in the mid, my lord.
yes.
If the progress of our country cannot be lauded, it is on account of manifestation of rich getting richer, with the lots of vast majority remain stagnant. Reasons for regret. Eagerness for engagement in service cannot become a crime unless it is produced by illegal means. This is how we preface the present litigation initiated by the petitioners, praying for their absorption in the workforce of the applicant. There is no dispute that respondents were employed by the Aeronautical Development Agency without any coercive and without coercion or without transgression or in any of its rules or practice between year 1985 and 1989. That the ADA issued a circular dated 29/9/1989 proposing to engage a contractor for supply of labor, leading to filing of writ petition assailing this device, with which had regrettable results of metamorphosing their initial temporary or casual employment into an amorphous and legally tenuous one, dependent entirely on the whim and will of the contractor or the employer. There was no backdoor engagement, no nepotism, no infraction of rules, because none were in existence. Rue the day when the court turned a blind eye to the use of stratagems by employers to deprive a simple, impoverished and lowest rungs of the society of their right to live. What respect will our constitution then demand? And the situation is all worse, since the employer is the creature of the government, who must already have expended in this protracted litigation what the petitioners would collectively earn throughout their years of employment. Then they refer to the two judgments, my lord, Air India and Steel Authority, my lord. Then Uma Devi is also referred, and related judgments, my lord. Then, my lord, I will straight away come to the para 6, my lord, page number 38, my lord, ink page number 38, my lord.
Para 6, my lord. The judgment page is 28, my lord. We reiterate that there is a plethora of precedents prescribing that the contract labor cannot be regularized contrary to the rules and regulations binding on the employer. There is a second category of case, the dichotomy having been removed of Uma Devi, where daily wages, casual employers, and other persons who have taken on the roles contrary to the rules and regulation applicable at the time of their entering service. In these cases, it has also been held that they are not entitled for regularization. However, there is a third category of employees, also such as those engaged in private corporations, private business enterprises, etc., who have been legitimately engaged by the persons having authority to do so simply because recruitment rules and regulations were then not in force. If their services are not legally protected and rationale behind labor laws would be rendered otois and redundant. So far as this third category is concerned, the Apex Court has given several rulings, including that continuance of duty uninterrupted for a period of 160 days or 240 days would entitle them to security of service. These rulings are possible only because there are no rules and regulations to the contrary, and security or permanence of tenure of service is accepted as integral and unavoidable human right. Unlike the first category, where the employer as well as employer act in consort and design, irregularity or illegality in engagement is absent, and employer not in pari delicto, having pondered on the points that arise in this dispute, we think that the petitioners falls in the third category. In Satya Prakash versus State of Bihar, SCC Umadevi has again discussed in detail, and their lordship have clarified that whilst the directions for transforming and ad hoc service into permanent character through absorptions ought not to be mandated by writ court, wages equal to those payable to regular employees can be ordered. Even, my lord, may I skip, my lord? Now, my lord, they have at para 7, my lord, they have discussed about in this case, my lord, how they were initially engaged as contract labor. The facts of the case, my lord, in this case was observed, and then lordship's judgment, my lord, that is in page number 31, middle, my lord, the learned single judge has his lordship H.L. Dattu by order dated 29/5/1996 directed that central government to take suitable action under section 10, similar to our case, my lord. Until such action was taken, the employment of respondent would continue. Dissatisfied by this decision, petitioner filed WA 7641. This is referred in my case, my lord. Then, my lord, ultimately, my lord, the notification was issued. Next page, my lord. Page number 32, notification was issued under section 10, my lord. Then the Honorable Court at para 10, para 8 of the said judgment, my lord, has passed the para 8, the obdurate, if not refusal of the appellant to abide by the orders of the division bench constrained in the writ petitions to petitioners to file second salvo of writ petitions on which impugned order dated 18/3/2005 came to be passed. The learned single judge has inter alia found that the attempt of the appellants clearly established that there are vacancies in the ADA to absolve the petitioner, that during the year 1985-89, the petitioners were appointed on daily wages. They continued in service till their retirement on 2/3/1999, and after 14 to 15 years service with the appellants, the learned single judge thereafter concluded that the petitioners were entitled for absorption and their termination by the appellants were illegal. The learned single judge thereafter directed appellants to absolve the petitioners.
Now, this appeal was filed against the single judge's order.
Yes, my lord, single judge's order. It was confirmed, my lord, by this. Ultimately, the appeal of the ADA was dismissed.
What was the direction of the single judge?
To regularize or absorb them, my lord. This is observed here, my lord. Last 4 lines, my lord. Learned single judge thereafter concluded that the petitioners were entitled for absorption, that the termination by the appellants were illegal. They observed, and this was confirmed in this judgment. Same judgment has been referred to in my case, my lord, and the same, in the similar fact situation, my lord, I have given a chart in my next page, my lord, annexure AB, how my case is similar to this ADA, my lord. First one, who appointed the petitioners at the first instance, my lord? ADA appointed on daily wages, para 1 of the judgment, my lord. In Mangalore Corporation, I have Mangalore Corporation appointed the petitioners. The petitioner at para 2 and 3 of annexure A, my lord, they say that I was appointed as initially on daily wages. Then in 1997, I was a contract was introduced, my lord. Initially, my entry was as a daily wager, my lord. Only in 1997, it has been converted into a contract by the corporation, my lord. That, my lord, I want this. My lord, just I have already produced the commissioner's report, my lord, before this honorable court. Only additional report of the contract labor system, which I have already produced as an annexure. This is the complete report, man. I am not adding any facts. It is the same which says about annexure A, my lord. It gives details about what annexure A says. My lord, may kindly see. This was the report, my lord. Initially, my lord, this report refers to how this was constituted, my lord, in the beginning. Then page number 1, it mentions about the members. Then it mentions about the questionnaire at page number 2, my lord. Then, my lord, observe, it also refers to the judgment of this honorable court. In relevant portion for me is page number 8, my lord. Mangalore City Corporation, my lord. In case of Mangalore, Mr. J.T. Jinkalappa, Deputy Labour Commissioner Hassan, has already prepared a well-studied report, which is enclosed herewith as document number 12 and 13. There are 176 contract workers employed in Mangalore. Municipal Corporation has not registered their establishment under Contract Labour Regulation and Abolition Act 1970. It is found that 6 contractors at Mangalore have filed an application before the Assistant Labour Commissioner, Mangalore, for obtaining the license under Section 12 of the Contract Labour Regulation Act. Hence, there is no license held by the contractors. Therefore, contract workers are to be treated as workers of the municipal corporation itself. The dispute regarding the regularization of these workers are pending before the Honorable High Court in WP, which is the same writ petition, my lord. My lord, my lord, there is a table at page number 12, my lord, along with questionnaire, my lord. Page number 12, my lord, ink page number 12. So far as Mangalore, my lord, on the right hand column 11, my lord, remarks. It says, it is found that where water supply management and maintenance is an essential service, as enunciated in Schedule 2 of Karnataka Municipal Corporation Act 1976, the corporation has engaged contract labor with effect from 1497. Prior to this system, the workers were working for more than 10 years with the KW, Karnataka Water Sewage and Supply and my lord, which was handed over to the corporation with effect from 1497. Then these workers were paid by the assistant engineer, junior engineer, and logbook maintained by the work executed. They were given 1 day weekly, staggered one day. There is a contract labor union named Municipal Staff Union, Felix Pai Bazar, Mangalore, who is struggling for regularization of this for 4 years, my lord. Then, my lord, it also the other documents, my lord, which is supplied by the municipal corporations, my lord, all the municipal corporations in answer to the his enclosed, my lord. Then, my lord, I will straight away come to the report, my lord. Jinkalappa report, which is referred at document number 12, is at page number 46, my lord. My lord, at page number, first they introduce and they say about how it is a local authority, what is its main functions, my lord. Then, my lord, they come to in next para number 2, page number 48, my lord. They refer to.
We'll continue tomorrow.
Yes, my lord.
Tomorrow I won't. Function is there.
But then we have heard it, we're in the midst of it. We're in the midst of this.
Functions.
Day after tomorrow? Let him argue tomorrow, day after tomorrow, you give your reply.
Day after tomorrow. Day after tomorrow.
But then we may
But
not. be
may I
able to
continue
keep-
my, only I have 2 or 3 points, that's all, my lord.
You send your colleague tomorrow, let him complete.
Yes.
I'll hear you day after tomorrow. If everything is complete, we'll see, otherwise we'll see what is to do. Relist tomorrow.
Tomorrow.
You send your colleague, we'll see. I will accommodate you day after tomorrow.
Your lordship, serial number 30.
Serial number 90, part 3% appearing. Petition number 28 to
All dates,
number 19.
all dates will be given.
Tomorrow morning.
Serial number,
Let it come after vacation, my lord.
serial number,
Serial number 90. 90.
just wait,
My lord,
just
I
wait.
appear for the.
17 Vijay.
After
My lord, for
vacation.
respondent, so that reinstatement matter which my lord has.
But the order is.
Interim order has been passed.
Along with an affidavit, I have filed with-
After vacation,
Huh?
but the
After
difficulty is.
vacation, but.
Batch. Reinstatement, of order of reinstatement has been discharged to the, all the response, private response to the. Not and also not have filed an
Fine,
affidavit
fine.
to that effect.
Malas, serial number 59, Malas.
Just one.
Only difficulty which I will be facing, my lord, the affidavit has been filed.
Lord, what,
my learned friend.
what best can be done, Lord, I have done it at present.
The
Lord.
difficulty is at
Lord,
para 4, which has been filed.
There is a procedure, my lord. There is a order.
I
In
am
view of
not
this
on
sort,
that, my lord,
this court order, my lord, we have reinstated them.
but I do
My lord,
not have worked.
with the
on-
approval of the, with the approval of the director of the pre-university, my lord, we have to proceed with it, my lord.
I will
And my
not
lord,
get
in
my
my
salaries.
affidavit itself, my lord, I have stated that I will be forwarding the proposal to the director of pre-university. My lord, yesterday itself, my lord, while passing the order, my lord, the deputy director of public instructions have been already, my lord, served with the copies of the reinstatement order. And the dispatch is also done yesterday itself, my lord. I have the copy of the acknowledgement receipts of the postal receipts.
What was the interim order that we had passed?
Lord, staying the EAT orders as well as the execution petition order.
And then there was also a rider that they would reinstate me with the workforce, my lord, workload.
What?
Now, my lord, there is no.
Lord, there is a
workload.
procedure, my lord. In
I am only.
all of a
saying
sudden,
that
my lord,
I'm-
it cannot be.
Lord, I am saying, my lord, that the college is closed. Where I was working, my lord, the college is closed at para 4. They themselves have stated the college is.
Yes, my lord.
Now, my lord, they also say that they will include them to this, for salary grants, my lord, the government has to grant it. Now, my lord, if government takes its own time, my lord, I will be nowhere. If there is a reinstatement also, my lord, I have no salaries for this, my lord.
There is a procedure, my
there-
lord, but that will, my lord, will
The
forward it
college
to
and
the
the government, my
government.
lord, both have to work and granting some work. And
But
my lord, and salaries every month, my lord. If there's
At-
no
at-
workload in their colleges.
At the
my lord,
present,
they
my
will
lord,
not be-
all the respondents are, my lord, accommodated, my lord, with regard to, my lord, first two numbers, my lord, serial number 1 and 2. My lord, they are accommodated in a vacant post, not in a institution where the very management is, my lord, is running the institutions. Lord, that may I have placed before you. Lord.
1 and 2.
Yes, Lord. Serial number 1 and 2 in the order of the reinstatement. Lord.
How many are there now?
4, my lord, four different writ petitions, 4 EAT orders, 4 execution petitions filed.
It's also a rider in the affidavit saying that the reinstatement is subject to the approval of the director of PU board. man.
Subject to,
PU boards,
yes,
Lord, if that is not been
Lord,
done.
the authorities,
Correct. Now that will direct the government to take note of this.
please, my lord,
And then I'll have it after vacation. We'll see what is to be done.
very well.
Pursuant to the order dated 9/12/2024, the respondent has filed an affidavit.
Petitioners.
The petitioner has filed an affidavit. And it is stated that Management has taken steps for reinstating the private respondents. And that insofar as Shiv Kumar and Somnath,
Yes, ma'am.
the said petitioners, said respondents have been reinstated in the college of the same management.
Yes. Run by the same man. To a vacant post also, no?
What about C and D? C and D?
They are reinstated to their own posts. Sir.
So far as C and D, reinstatement has been ordered in the same colleges.
The post which they were holding at the point of, at the time of
At the post they were holding as on the date of
order of
termination.
termination.
Full stop. Next. The affidavit further states that as the college at Pavgada
Yes, ma'am.
had been closed.
No, that Gundlarhalli, Pavgada Taluk. Gundlarhalli mein.
At Gundlara
MGM Padvi Purva College, Gundlarhalli.
at MGM Pre-University College, Gundlarahalli, Pavgada Taluk had been closed. The orders of reinstatement are subject to approval by the director. PU board. Counsel for the respondent submits that insofar as the reinstatement at MGM Pre-University College at Gundlarahalli, the order of reinstatement may not confer any benefit. Yes. As the college was closed. Full stop. The government is a respondent.
Yes, ma'am. Yes, government is also.
Government is a respondent. We've also filed a statement of objections, my lord, that prior to suspension, approval was not sought.
Lord.
Therefore, that is all. My lords,
Approval itself is not sought.
approval was not sought, my lords. Therefore, their removal, suspension itself was bad. That is the stand we have taken.
That they have taken.
Prior permission
Totally
before-
false.
My lords, approval is necessary since.
My lords,
Just one
lords,
minute. Just one
I am
minute.
for the respondent number 1 in 17.1 and 17.4, my lords. Dismissal order was passed without obtaining prior permission or prior approval of the department, my lords. Therefore, department is not liable to pay any kind of financial benefits to the private respondent, my lords.
Lord, the
Now
prior
there is no
approval for
workload
keeping them under
proposed
suspension,
institution, my lords.
as well as Lord, thereafter, Lord,
Let us
I'll have it tomorrow, my lord.
subjecting
What
them
happened,
to
my lord?
inquiry, Lord,
There
with
is
the approval of the
now
previous.
here, my lord.
Needless full stop. Next. This aspect of whether order of reinstatement has the effect of being implementable order is a matter that requires consideration in light of the stand of the private respondent. And also noticing that the institution at Gundlarahalli had been closed. Full stop. Relist the matter in the
One submission.
week commencing from.
Request for a date.
I may be, Lord, I may be permitted to file rejoinder to the objections filed by my learned friend in government.
Relist the matter in the week commencing from 6th of January.
Very well.
For a date, my lord, specific, may I request for a specific date, my lord.
6th of
Please, my lords. Any date may be fixed, my lords.
8th of
My
January.
lord, and some
Lordship,
financial
sorry.
help,
May-
some financial help, because I'm nowhere, no,
Lord,
If there's
It
a
is the
stay of
government,
ignorant-
it is the government who have
And
to
I'm-
consider.
Needless to state, the court reserves liberty for modification of the interim order upon hearing both sides.
Very well.
Lordship, seal number 33, your lordship.
Just 1 minute, just 1 minute.
Yeah.
Next time you tell.
Seal number 33,
Just
your
1
lordship.
minute, just 1 minute. List after winter vacation. Yes.
Tomorrow morning.
No, this is only for consideration.
I do not have the file, my lords. I'll have to have a look at it.
Just 1 minute. His only contention was.
Yes.
He is not being heard. And some order is passed. Order is passed or not yet passed? So he wants to be heard. That is the only thing.
covered by judgment.
My lords, I apologize. I'm inconvenienced, my lords. I do not have a copy of the
Delist
petition.
on 20th. His only
I'll-
contention that he wants to be heard.
Yes, my lords, I'll have a look.
20th.
Lord, in 21, Lord, in 21, I was heard that the matter has been reserved. In that particular matter, pursuant to your lordship's order, we have also passed an impugned order that may be also considered.
Yes.
Because now,
Now, the only point I'd asked them is what is the effect of in the note sheet of referring to the minister?
yes, ma'am.
Because under the guideline, after the transfer period is over, it is the chief minister who has to approve.
That was been subdelegated to the concerned ministers. That is what the
No, correct. But after the transfer period is over,
the second writ petition, paragraph number 3 of the second writ petition clearly states which is that particular period also.
no, correct. But now the order admittedly is 3/12,
Yes, ma'am.
isn't it? So under the transfer guidelines till July,
Yes, ma'am.
it was delegated to the minister.
Yes, ma'am.
So the contention of the respondent was in supporting the order was that the approval of the chief minister 19/11/24 would take care of requirement and the transfer guideline relating to order being passed after the period is over.
To that aspect, my lord, the minister in his approval, when the minister gives his approval, he says that Kandike Nalakku, where it is the CM's note which has been noted on.
So he refers to that.
Yes, ma'am. That also I've just produced that with the entire e-file. ಖಂಡಿಕೆ 4ರಂತೆ ಸಿಎಂ ಟಿಪ್ಪಣಿಯನ್ನು ಅನುಮೋದಿಸುತ್ತಾ ಮುಂದುವರೆದು he makes certain more transfer proposals. That I have just
Correct, but then there was no necessity once again for the minister to have looked into it. It's only an internal procedure.
yes, ma'am.
Because the chief minister in 1911
Yes, ma'am.
has already granted approval.
Yes, ma'am.
So whatever was done again is only for the purpose
of our
passing the posting order because
Yes,
the order
yes.
of the court.
just to take it into consideration that the file from the department goes up to the chief minister and gets back again. To follow that procedural aspect also. And the subsequent e-file what is been produced also takes care of the subsequent directions of your lordships. Then also making a fresh posting up to going to the minister's approval and coming back again. That's also in the note sheet here.
But you have served that, isn't it?
Yes, ma'am. Yes, ma'am. And the acknowledgement is also duly available.
I'll consider.
Maybe prior to vacation, if it is passed, so that our order does not becomes infructuous.
I'll consider.
Yes, deeply.
33, Lodge, 33, 23.
23, list after winter vacation. After vacation, after.
My lord, it's cause list number 179, my lord. This is the
Just wait,
BBMP case.
Just wait.
Yes,
I'll
ma'am.
come to that.
24.
24. 24. ಏನ್ ಮಾಡೋದು? What can correct now? What we can do next 2 days? I don't want to put matters except what I've heard. Take a chance on 20th. That's only half day. If it comes, it reaches. 20th.
25.
I am for the petitioner, my lord.
Yes.
For the past 8 to 9 times, government has taken.
May be
only
taken
to
up
take
on first
instructions from
week,
the
my
government.
lord. First week,
25?
it may be taken up.
So at least,
First week, January, it may be.
This is the matter
be a final,
in the
chance for them.
week commencing from
13th of January. 26.
My lord, this is pertaining to the interest on pension for the Shanbog's matter, my lords. There are three.
Service book was not available.
My lords, there are 3 petitioners. Insofar as the first petitioner is concerned, he retired way back in 73. But we have calculated until 98 to grant pension. The second petitioner, the payment service register itself is not to be located. Insofar as the third one is concerned, my lord, the state has preferred an appeal against the order where interest has been granted. My lord, in view of all of this,
Yesterday, what you had
I think relist tomorrow. Let us.
wait,
47.
47. 47.
Notice, I'll take notice in that matter, my lord. That
Which
is also
matter?
pertaining to interest,
37.
yes, notice and pertaining.
No, wait, we'll come to that. List,
27.
list 37 along with 27. Yes, next.
27.
27 may be taken up after vacation.
List the matter in the week commencing from,
Much.
28th of January.
yes.
28, 29 urgent. 30.
Let us see, let us see. Yes. Date we have given. Yeah. No, you-
30.
You move a memo,
30. 30. Shivakumar.
list the matter after winter vacation.
31.
Same order.
Here, post of junior assistants for appointment for post of junior assistant called. Under the rules, 50% by promotion, 50% by direct recruit. Your lordship had granted an interim order. In spite of they have issued a fresh notification now calling for. All the posts to be recruited through direct appointment.
No.
That notification has to be.
Correct. Okay, but then you have a remedy now. You have to explore your remedy. I've already passed an order.
No, fresh notification.
Contempt ಮಾಡಿ.
No, fresh notification order. This is a fresh, along with the
No,
application.
correct, but now what we can decide?
But your lordship, earlier, my lord, interim order is not with that much respect, my lord, it has not stayed the notification. So only said, my lord, as per the rules, we can proceed. That's all it's taking advantage of that again, they have issued this notification.
Any action taken by the respondent in the interregnum are subject to orders to be passed in the present petition. This is the matter in the week commencing from.
27th. 32.
Lord, in this case, my lord, the petitioner is appointed as a typist by the sixth respondent. The government is not issued an order for appointment only on the ground that the PUC is not equivalent to JOC. JOC is not equivalent to PUC, my lord.
Just on,
Friday, month.
list on Friday.
In the preliminary.
33.
For the petitioner lordships,
33.
pertaining to 108 ambulance.
Yes,
That's,
We have filed one,
your lordships have directed me to
Thirty.
issue a letter. I've done that, my lords. The
Manjuna.
directing how the R3 is to appropriate the funds that I have released. I'm placing it for your lordship's consideration.
filing the statement. And the thing is, I've read the copy of it, lordship. Both are contradictory to each other. The R3 says that whatever the funds are released are not sufficient for me to pay the wages for the month of
No, no,
October.
correct, but now R3 will have to comply with what the government has
Please, my lords.
direct.
My lords.
Just let us see, for the time being. Yes, what is the direction?
My lords, if your lordship see, my lords, at the letter bottom of page 2, there is a table. 30.22 crores, 18,000 to be appropriate towards the salaries. And 10.37 crores, 10 crores, 37 lakhs, 82,000 to be appropriate towards other operational expenses, including other salaries. And this is compliant, my lords, with your lordship's previous order of 12/9/2020.
Let us see, for the time being, they'll have to comply with this, remaining wills.
Let them pay the wages for the month of.
Correct,
October.
so
Yes,
we'll
sir.
say, the AGA has filed a memo, an enclosed copy of the letter dated 16/12/2024, addressed to the file.
R3.
R3.
Yes, sir.
Full stop. It's further submitted that in the table found at page 2, the appropriation of the amount towards wages is indicated, and that insofar as for the months of October, November and December, out of the amount released, an amount of rupees 3022.18
Lakhs, my lord. Or your
Lakhs.
lordships may say 30
30 crores.
30 crores, 22 lakhs, 18,000.
30 crores, 22 lakhs, 18,000 is to be appropriated only towards the wages of EMT and pilots. Pilots. Full stop. Learned counsel for the petitioner submits that in light of such direction, the third respondent must be directed to comply with such direction.
As per dated 12/9/2020.
Comply with such direction. Full stop. Learned counsel for R3 has filed reply statement. Reply statement. Full stop. Same is taken on record. Needless to state, in light of the communication of 16/12/2024, third respondent is to ensure that appropriation must be done in terms of the direction of the government, which government, and the wage component released by the government is to be dispersed to the petitioners. List the matter in the week commencing.
There's no money, my lord, therefore we have given the detailed statement, my lord, whatever they have dispersed, we are dispersed to the employees, my lord, it is minus now, it's only, we are with only 5 lakhs, my lord. 3 crore is required for a diesel only.
Learn that you file your, that will.
He will have to fund it. He has disbursed 37 crores unilaterally on his own. He has to make good that amount.
Insofar as the contention of R3 placing reliance on statement of objections, that is a matter to be considered later. However, for the present, in light of the direction of the government, there has to be dispersal of the amount released by the government towards wage component. And there cannot be appropriation of the amount released towards wage component under any other head. List the matter in the week commencing from 13th of January.
Can it be after the next week after that?
Why is 20th? Can the wage some time frame to be given, your lordship?
So now he has to, money has gone to him, he has to disperse it.
Immediately. It will be immediately, lord. 3 months is over. We are not having any money. 3 months are over.
Third
But they
respondent,
disperse the wages which is due for the month of October and November, your lordship.
third respondent to take immediate steps for dispersal. Other issues and grievances of the third respondent with respect to the government is a matter to be raised by third respondent with the government.
Much obliged.
Could it be in the week of 20th?
This is the matter in the week commencing from 20th of January.
34,
Deeply obliged.
34, appearing for the petitioners.
This is the matter immediately after winter vacation.
35, interim order में kindly be extended.
Interim modern operations extended till the next day.
35,
Same list the matter after winter vacation.
36,
My lords, in this matter, I am just seeking mandamus, my lords.
No, correct.
Mandamus with respect to D1 and D and D1. It's just regarding to the AICT pay scale, my lords, the government.
Let us,
On a later date, my lords, not as the day.
let us list the
My
matter.
lords, date may be given, my
And
lords.
list the matter in the week commencing from. Yes.
37,
Much
38, 38.
So what is the, what interim order regarding?
I am for the respondent, my lord. Respondent for 1 and 2.
No, whether there was an inquiry.
Inquiry, there is an inquiry. They only have produced the documents, inquiry proceedings.
Huh?
It's a proper inquiry, but there is an inquiry.
Let us see. Really,
They say it's not a proper inquiry. Let them go before 94, section
let us see.
94 is an appellate order, my lord.
prima facie, I'll see. If there's no inquiry, we'll see what is to be done. Relist the matter. 20th,
Much obliged.
39,
list after winter vacation.
40,
List,
My lord, in this arguments have been already heard, some clarification from BBMP regarding against government guidelines transfer. Government guidelines.
Correct, but now we have to pass an order. Now we can't list the matter in the week commencing from.
13th of January. 41,
Please.
List the matter after winter
Lord,
vacation.
writ appeal has been filed in this. Could your lordship kindly get the matter after
In-
my lord
in-
conducted?
in-
13th, my lord.
Let us see. Yes,
42, In serial number 42, I am for the petitioner, may I request for a date,
This is the matter in the week commencing from
13th of January. 43,
43 is already argument are completed, my lord. Only for instruction of the government, my lord. Was the granted post, my lord, was in this case, my lord, was in teaching and non-teaching teaching jobs. Was
Yeah.
granted post.
My lords, the
Was
file-
already argument was concluded. 3 times, my lord, he was.
file is
taken
pending
time
before
for
the
instruction of the government.
Department has forwarded it, my lords. The file is pending before the
Pending.
ministry, my lords. It cannot be processed anytime soon, my lords. Post vacation, my lords will.
Very
the
difficult.
AGA
60 members
submits
is there, my lord.
that the file is before the concerned minister.
Ministry, yes, my lords.
List the matter in the week commencing from
13th of January, 44, 44.
So this is the matter where.
This matter, my lords, there's a development. My lords, the petition itself might be infructuous for the reason that the the appointment which has been made by the corrigendum dated 17/8/2024 and another prayer, my lords, where the notification dated 14/11/2024 has been challenged. Both have been withdrawn and new rules have been made.
withdrawn.
Yes.
Therefore, my lord, they can withdraw the impugned order of appointing the.
Yeah,
charge.
that's it.
That can also be withdrawn.
Just one, huh?
No, that does not, my lords, the issue is that, my lords, the petitioner wanted to be appointed as an in-charge chairman. That is the first prayer. Subsequently, they amended, my lords, with regard to the other in-charge being appointed, saying there's some contradiction and other aspects to it. Now, my lords, that particular corrigendum has been superseded by the new rules. Now, my lords, that's the information we have as of this minute, my lords. We just got to know. Now, my lords, we are just placing it on record, my lords. All we are requesting it is that if they want to challenge or continue the entire writ petition, we still maintain that, my lords, dehorse these prayers, it will become a PIL.
Then let us see. Now, if they're going to withdraw it and keep it pending, let them file, you have a look at it.
After vacation, my lords.
And this is the
In the
matter.
instruction, my lord, let them not take statute.
No, now they framed some rules, you have a look at it.
To
ಅಲ್ಲ,
either way,
ನನಗೂ
my
ನಾವು
lord,
ನೋಡಿಲ್ಲ
even
ಇನ್ನ.
if there are
My
rules,
lords, I may have it after
in an
vacation.
in-charge arrangement, they can't exercise statutory function.
No,
My
that
l-
I can't enter into in this procedure.
My lords,
Well,
in the
it-
meantime,
That's my board will come to a standstill.
No, that person now goes.
No, my lord, he
Appointment,
remains.
the appointment made goes, is it?
My lords, now we have to see what are the new rules, what has happened. As of now, we have only one aspect of it. See, my lords, they have, the best part is that they have the copy of the notification of the new rules. We don't have it.
That's
They have
all
it in their
we
hand.
Record.
Allah.
Your lordship may have it tomorrow, my lord.
No, no.
The
My
rules is
lords,
nothing
my lords,
but
tomorrow, day
information.
after, my lords, I am not
It
in.
requires hearing, whatever it is, it requires
Yes.
hearing.
my
May I
lords,
just make this request and leave it to your lordship? It is the pollution control board's case that on the basis of notification, certain person is appointed. Notification is withdrawn. Therefore, my lord, my submission is there is no impediment to stay the present appointment because the basis on which he is appointed is withdrawn, even admittedly according to them. Even otherwise, even in the new rules, what is done is the earlier notification is framed into new rules.
No, that we'll see,
But ultimately.
Now, the present appointment goes by virtue of the rules.
Yes,
Appointment
yes,
will
and
be made as
Probably
per
he
the
would
rule.
come back under the new rules, my lords.
So
Or he
therefore-
or any other concerned person would come under the new rules. My
Let
lords, may
us-
have it after vacation, immediately after vacation.
Let us see. Now we can't pass any interim order now.
Please.
But then he will, my lords, continue.
My-
There is absolutely
Yeah.
no stay of his appointment. He'll simply continue.
No, that has to be considered an order passed. List the matter.
my lords, in the meantime, let the petitioners also implead DPAR, my lords, Department of Personal and Administrative Reforms, my lords, since it pertains to appointments. There's a separate, let them implead the DPAR.
Directed to implement the DPAR.
Yes.
That Council Shri A. Mahesh Chowdhury submits that rules for appointment of
The
chairman.
corrigendum, my lords, which they say 17/8/2024
Hmm.
has been superseded. Pratish, why don't you
Corrigendum?
give that?
Corrigendum of 17/8/2024.
ಅದ್ ಕೊಡ್ಬೋದು ತಾನೆ? My lords, I think the petitioner advocate only has the copy of the, I just got information, they have the notification itself.
Has been superseded by.
My lords, sir.
Kudu.
That superseded by the rule.
Superseded by the rules notified on 18/12/2024.
Today.
Matter requires consideration. list the matter early date in the week commencing from. Yes,
Till then, at least statutory, my lord.
it has to
That
be
if
heard and
in-
then order passed. Let us,
That if in charge officers are permitted, my lord, it may lead to,
no, we'll see, they'll be liable to account.
but those decisions are irreversible decisions. Supposing, my lord, they grant statutory, my lord, licenses, those are irreversible decisions. May I just
Chairman
Under-
alone does not, I can speak for Pollution Control Board. Chairman alone does not grant any licenses.
Your
It
lordship
is a
may-
committee. It's a committee which grants. In
That-
any event, my lords, the Water Act saves all the acts done, even if an appointment is illegal under the Water Act. My lords may have it on week commencing from 6th, and my lords may hear it.
Only statutory functions, my lord, from right from Dutt Road and
Needless,
Muniraju, my lord.
needless to state, any action taken by the in charge chairman would be open for taken by the in charge.
My lords, that
director.
would, my lords, may open a floodgate, my lords, for the other people, my lords, who unconnected with the issue, take this interim order and say that, my lords, assuming my lords hold it against the respondents, my lords, they will take this interim order and they may challenge all the actions otherwise.
May I just place on record the judgment?
My lords,
Right
we are
throughout the-
looking at the floodgate, my lords.
The settled position is in charge officers can never confer statutory obligations, can never exercise statutory powers. I'll place all the judgments, my lord.
Then, my lords,
The
we will
right
hear.
from Dutt Road, they have held, my lord, in charge officers, even placed under
Third,
232, they can't exercise that.
The contention of the petitioner that an in charge
Office.
officer cannot exercise statutory powers
Please.
is a contention that is kept open for consideration.
Very good.
Yes.
With your lordship's permission, serial number 59, Malas.
Hmm.
Malas, you have been terminated without inquiry, without notice, Malas.
Okay.
59, Malas. Tomorrow, Malas.
Yes, 20th.
20th.
56 by Lord, Reynolds, 68.
My lord,
The state may not have taken a stand regarding whether or not
It's repatriation, what is the stand?
56 mile. Then your lordship will pass not grant me an interim order.
How we
If they
can-
find not stating objection.
In the entirety, all repatriation, we have to stay. How we can, how many times we have given the time? Anyhow, no,
56 my lord.
no irreversible harm is done.
56 my lord.
my lord, case number 79, my lord, in
What's
cause
your
list one.
What's your?
56 and well within not that. 56 my lord.
Which is that matter in which I granted the counsel for the petitioner submit that he is on the verge of retirement. Reliance is placed on the order passed in WP 30273 of 2024. Passed on on the order passed on 13/11/2024. Order of 13/11/2024 reads as hereunder. In light of the same, there would be an order of stay of
Annexure capital A is not also.
annexure A insofar as the petitioner is concerned.
Please.
Made clear that respondent is at liberty to seek for modification of this interim order upon filing their statement of objection. It's also clarified that this order is passed only taking note of the age service left of the petitioner and cannot be treated as a precedent in other matters.
Serial number 53, my lord.
56 my lord.
Your lordship has directed last occasion, Saru the copy, transfer matter, my lord, and posted to today, my lord. That's the couple's case, my lord. The husband is working in the jail department and wife is in the judicial department and daughter is in 10th standard, my lord. In the academic year, it is order is passed, my lord.
56 my lord.
53, my lord. 3, my lord.
The court employees.
Please, my lord.
Then you'll have to wait.
Tomorrow, my lord.
No, no.
In this matter, my lord.
66, my lord.
In this,
This is the matter.
tomorrow, my lord.
From where to where you're transferred?
Sakleshpur to Polaris for 87 kilometers, so 2 hours is required, my lord. The husband is working in the jail department.
Maybe, maybe. Let
But
us.
my lord, the daughter who is studying in 10th standard, my lord, her
Serial number
academic
66.
year is affected.
56, my lord. 53 lists the matter in the week commencing shortly.
66.
My lord, tomorrow, my lord.
66.
66, my lord. The honorable.
Without due process of law dismiss ಮಾಡಿದ್ದಾರೆ ಸರ್. ಸುಮಾರು ವರ್ಷಗಳಿಂದ 17 ಡಿಸ್ಮಿಸ್ ಮಾಡಿದ್ರು. ಅವಾಗಿಂದ ಹಾಗೆ ಇದಾಗಿದೆ.
All that will.
ಎರಡು ದಿವಸಕ್ಕೆ
But after
ಬರ್ತಾ ಇದೆ
vacation.
ಸರ್.
My lord, 66, my lord.
Can't take it up now.
My lord, serial number 66, they have.
ಲಾಸ್ಟ್ ಟೈಮ್ ಬಂದು ಅವ್ರು ಅಬ್ಜೆಕ್ಷನ್ ಕೊಡ್ತೀನಿ ಅಂತ
ಅಲ್ಲ, ಆಯ್ತು, ಇವಾಗ ನಾಳೆ ನಾಳಿದ್ದಾಗಲ್ಲ.
ಲಾಸ್ಟ್
My lord,
ನಾಳೆ ನಾಳಿದ್ದಾಗಲ್ಲ.
serial number 66, my lord, so directed to file statement of objection, failing to which the honorable court will order that our prayer will be considered, my lord. Still that, after that order, my lord, 3 days have been, 3 occasions has been listed.
What is
But
your prayer?
My lord, for a reinstate, my lord, by for
lord, the
the
petitioner
memorandum
is in
was
nature.
memorandum of was challenged, my lord. So I am a human resource officer, my lord. So I was relieved on on a unauthorized person made a complaint, and I was relieved on that, my lord. Without any proper inquiry, I was relieved, my lord.
Your contractual basis.
Yes, my lord,
Yes,
contractual.
contract employment.
ಇವ್ರದ್ದು
My lords, HR consultant under the National Health Mission, my lords, that entails certain responsibilities which the petitioner failed to do. Therefore, our objections are ready, my lords. They cannot be signed immediately.
Now the termination is simpliciter or on the ground of allegation.
There is only one allegation that I had,
Now if
My
it's,
lord, the contract says that subject to the,
if it's stigmatic without inquiry, you can't.
yes,
no,
ma'am.
my lords, the contract itself says there was an agreement executed pursuant to the appointment, my lords. It's on contract basis. And if the performance is not to the satisfaction of the client, then it can be terminated. There are only one thing now, either 1 month's salary is you withhold or you pay and then you relieve them, my lords. I filed my objections in that, my lords.
20th.
Yes, madam, in the others list, my lord, please.
Not list to serial number 15, the matter which was passed over.
Order list,
List to serial number 15, CMP which was passed over, my lord.
56 interim order.
My lord.
My lords has heard both of us. Tomorrow, 20th, my lord, day after tomorrow.
20th, you take a chance.
Then tomorrow, then I'll take a chance tomorrow itself, then. Please, tomorrow.
ತೀರ್ಕೊಂಡಿವಿ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ವಾರ್ತಾ ಇಲಾಖೆಯಲ್ಲಿ ಅವ್ರು ಬರಬೇಕಾದ ಬೆನಿಫಿಟ್ ಇದೆಲ್ಲ ಗಂಡ ಹೆಂಡತಿ ಮೇಲೆ ಆರ್ಡರ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರ ಒಳಗೆ ಅವ್ರ ಬೆನಿಫಿಟ್ ಎಲ್ಲ
ರೆಸ್ಪಾಂಡೆಂಟ್
ಇದರಲ್ಲಿ ಅವ್ರಿಗೆ ಹೆಣ್ಣೆ ಹೆಂಡತಿಗೆ ಅವ್ರ ಮಗ ಬಂದು ಬುದ್ಧಿಮಾಂದ್ಯ ಮಗ ಸ್ವಾಮಿ. ಇದರಲ್ಲಿ ಅವ್ರಿಗೆ ಬಾಡಿಗೆ ಕಟ್ಟಕ್ ಇದಾಗ್ಲಿ ಅಲ್ಲ ಟುಮಾರೋ ಮೇಲಾಡು, ಯಾಕಂದ್ರೆ ಅವ್ರು ಆರ್ಡರ್ ಮಾಡಿ ತಗೊಂಬಿಟ್ರೆ ದುಡ್ಡು ಇವ್ರಿಗೆ ಏನು ಬೆನಿಫಿಟ್ ಸಿಗಲ್ಲ ಸ್ವಾಮಿ ನಮ್ಗೆ.
56 my lord.
You're the first wife or second?
ಸೆಕೆಂಡ್ ವೈಫಿಗೆ ಏನು ಬೆನಿಫಿಟ್ ಇಲ್ಲ, ಬಾಡಿಗೆನೂ ಕೊಡ್ತಾ ಇಲ್ಲ. ಇಲ್ಲಿ
You are the first wife or second wife?
ಫಸ್ಟ್ ವೈಫ್ ಬೆನಿಫಿಟ್ ಎಲ್ಲ ಇದನ್ನ ತಗೋತಾ ಇದ್ದಾರೆ ನಾವು ಸೆಕೆಂಡ್ ವೈಫ್.
What right you have?
ಸೆಕೆಂಡ್ ವೈಫ್ ಇಬ್ರು ಹೆಂಡತಿ ಇರಲ್ಲ ಸ್ವಾಮಿ. ಸೆಕೆಂಡ್ ತೀರ್ಕೊಂಡ್ಮೇಲೆ
You have no right.
ಅಲ್ಲ ಮೈಲಾಡ ಅಲ್ಲ ಅವ್ರ ವೈಫ್ ಇದನ್ನಕ್ಕೆ ಅವ್ರೆಲ್ಲ ಮದುವೆ ಆಗಿರೋದಕ್ಕೆ ಮಗ ಎಲ್ಲ ಇದೆ ಸ್ವಾಮಿ.
Maybe, but-
ಬುದ್ಧಿಮಾಂದ್ಯ ಇದು ಸ್ವಾಮಿ.
No, correct.
My lordship, kindly allow interim prayer, my lord. 56 ಅಲ್ಲ.
ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಇದ್ದಾರೆ ಸ್ವಾಮಿ ವೈಫ್
Correct.
ಹಸ್ಬೆಂಡ್.
You have to seek for any declaratory right or right of maintenance and get it attached in so far as the child. But you cannot prevent the first wife from getting it.
ಅಲ್ಲ ಫಸ್ಟ್ ವೈಫ್ ಮಗ ಎರಡನೇ ವೈಫಿಗೆ ಬುದ್ಧಿಮಾಂದ್ಯ ಅವನು 13.
Right, where is your right? Unless
ಅಲ್ಲ
you get
ಮೈಲಾಡ
an
ಅಲ್ಲ ಅವ್ರು ಅಲ್ಲ ಅವ್ರಿಗೂ ಬರ್ಬೇಕಾಗಿದ್ರಲ್ಲ ಅರ್ಧ ಬೆನಿಫಿಟ್ ಬರ್ಬೇಕು ಸ್ವಾಮಿ.
where you have to get an order.
ಆಗ್ಲಿ ಅವ್ರ ಇದ್ರದಾಗ್ಲಿ
Civil court you have to get an order.
ಅಲ್ಲ,
not to
ಅಲ್ಲಲ್ಲ.
this.
ಸುಮಾರು ಮೇಲೆ ಮ್ಯಾಟರ್ ಅರ್ಜೆನ್ಸಿ ಇದೆ ಮೇಲಾಡಿಲ್ಲ ಅಂದ್ರೆ ಆರ್ಡರ್ ಮಾಡ್ಕೊಂಡಿದ್ದಾದ್ರೆ ದೊಡ್ಡ ಹೆಂಡತಿಗೆಲ್ಲ ಇದು ಬೆನಿಫಿಟ್ ಇದೆಲ್ಲ ತಗೊಂಡ್ಬಿಡ್ತಾ ಅವ್ರಿಗೆ.
You don't, ನಿಮ್ಗೆ ಏನು ರೈಟ್ ಇಲ್ಲ.
ನಾಳೆ ಟುಮಾರೋ ಅರ್ಜೆನ್ಸಿ
My lordship,
We commencing from
56 ಅಲ್ಲಿ interim prayer allow ಮಾಡಿ my lordship. 56 interim prayer allow ಮಾಡಿ. At least
6th of January.
Petitioner is being harassed, my lords, in the office with respect to certain allegations of sexual harassment. in the inquiry report of which we have challenged in the writ petition minutes. Now, on the basis of that, my lords, not only is there a penalty order passed, so there being double punishment, his promotion is also being stayed, my lords, on no basis. My lord, there's some urgency because on each state, my lord, now there is we're given to understand there's some harassment in the office that he's facing. So the matter that was mentioned last week, my lords, could it be posted anytime tomorrow or day after, my lords, if it's possible?
Correct, sir, but we have to hear the matter.
My lords, it was partly argued, my lords, on the last week. If my lords, you can take our chances anytime tomorrow or day after.
No, no, we have not passed any interim order of stay.
There's no interim order, my lord, that was still being considered because, my lord, effectively it's a short objection that the respondent taken of jurisdiction. So it could be disposed of completely, my lord.
2 days is difficult. I'll have it immediately after reopening.
Okay.
My lord, so specifically.
Relist the matter. Just pray God.
Lordship.
Just pray God that I continue.
My lordship, kindly allow my interim prayer, my lordship.
61.
56, my lordship.
36.
Respondent. The 2019 matter dismissal.
ಅವ್ರೇನು ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಸ್ವಾಮಿ ಅಷ್ಟೇ ಬರೀ
File your, complete your. Complete.
56.
I have sent the draft to the client.
ಕೈಂಡ್ಲಿ ಅಲೋ ಇಂಟೀರಿಯಂ ಪ್ರೇಯರ್ ಅಲೋ ಮಾಡಿ ಮೈ ಲಾರ್ಡ್ಶಿಪ್.
Respondent to complete their pleadings by the next date. Relist the matter in the week commencing.
56.
20th of
Okay.
Shorter date.
Item 38, my
Great.
lord. The date is given on 20th, my lord. I have the preliminary list, my lord, admission statements.
ಬರುತ್ತೆ ನೋಡಿ.
Please.
My lord, my case number is 79, my lord. Can I request a date, my lord?
Yes, date will be given. Our date.
My lord, in the earlier date, my lord, it's a BBMP case.
Yes.
It's for the implementation of annexure A and B, my lord, so second pay commission.
Our date.
Blush.
Sir, court officer, sir.
Sir,
ಇದು
ಒಂದ್ ನಿಮಿಷ sir, wait
79
ಮಾಡಿ,
ಯಾವ
date
ಡೇಟ್
ಕೊಡ್ತೀನಿ,
ಕೊಡ್ತಾ
ಒಂದ್ ನಿಮಿಷ
ಇದ್ದಾರೆ
wait
ಸರ್?
ಮಾಡಿ. ಒಂದ್ ನಿಮಿಷ
ಸರಿ,
wait
sir.
ಮಾಡಿ.
ಸರಿ ಸರ್.
ಹಾ. ಒಂದ್ ನಿಮಿಷ. ಸೀರಿಯಲ್ ನಂಬರ್ 16. ನಾಳೆ
ಯಾವ್ದು ಹಾಕ್ಬೇಡಿ ಸರ್ ಇವು.
ಬೆಳಗ್ಗೆ.
Sir, serial number 28, sir, list one.
ಒಂದ್ ನಿಮಿಷ ಸರ್.
Serial number 28.
45 ಕರ್ಬಿಡ್ತೀನಿ ಒಂದ್ ನಿಮಿಷ ಸರ್. 45 ಯಾರಿದ್ದಾರೆ? 45 after vacation date ಅಂತ ಹೇಳಿದ್ರಿ ಅಲ್ವಾ? ಒಂದ್ ನಿಮಿಷ. 45 13/1/25.
Okay, sir, thank you. Sir, serial number 28, sir. 28.
ಏನಿಲ್ಲ ಡೇಟ್ ಇದೆ. 47 ಇಲ್ಲ after vacation. 51 after vacation.
Sir, 79, sir.
14/1.
79, 14/1 ಬಂದಿದೆಯಾ ಸರ್?
ಒಂದ್ ನಿಮಿಷ ಸರ್. 55
14/1 ರಜೆ
55
ನೋಡಿ.
14/1 ಅಲ್ಲ.
14/1 ರಜೆ ಇರ್ಬೇಕು ನೋಡಿ.
16/1 60 ಹೇಳ್ತೀನಿ.
14th ಹಾಲಿಡೇ ಅಲ್ವಾ?
16/1 51 16/1.
ಹೌದಾ?
ಹಾ ಒಂದ್ ನಿಮಿಷ ನಾನು ಹೇಳ್ತಿದ್ದೆ 50 ಎಲ್ಲ ಜನ ಹೋಗಿದೆ. 55 ಯಾರು ಇಲ್ಲ. 57 58 59 20th ಅಂತ ಅದು ಕೊಟ್ಟಿದ್ದಾರೆ ಸರ್ ಆಗ್ಲೇ. 60 ಅನಿಲ್ ಕುಮಾರ್ ಆಫ್ಟರ್ ವೆಕೇಶನ್. 61 ಜನ ಆಯ್ತು. 62 ಇಲ್ಲ. 63 64 64 ಆಫ್ಟರ್ ಹೇಳಿಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್. 65 67 66 20ನೇ ತಾರೀಕು 20th ಅದು ಗೊತ್ತಿಲ್ಲ ಬರುತ್ತೆ. 67 68 ಇಲ್ಲ. 69 70 71 72 73 74 75 13/1 ಆಗಿದೆ. 75 76 ಈಗ ಕೊಡ್ತೀನಿ 16/1/25. 77 16/1/25. 78 79
79, sir. 79.
ಡೇಟ್ ಸರ್, ಸ್ಪೆಸಿಫಿಕ್ ಡೇಟ್
ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಆಗುತ್ತಾ ಸರ್ BBMP ಕೇಸ್ ಅದು?
13th of January.
ಓಕೆ ಸರ್, 13th. ಓಕೆ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್.
80 81 ಮುಗಿತು ಸರ್. ಈಗ ಹೇಳಿ ಉಳಿದೆಲ್ಲ ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಂತ ಈಗ ಹೇಳಿ.
28.
ಒಂದು